State of Tennessee versus Deanne Elizabeth Vincent. My name is Tom Stovall, and I have been assigned by the Secretary of State to be the administrative judge in this hearing. As the administrative judge, I will not participate in the decision that is made on the merits of this case. That decision will be made by the members of the commission that are present this morning. Could I ask at this time for all the commissioners to please identify themselves for the record?
Fontaine Taylor.
Austin McMullen.
Marcia Franks.
John Grease.
Diane Hills.
Gary Bloom.
Johnny Horn.
Thank you. Members of the commission are instructed that their decision in this matter must be based only upon the record that's produced during the course of these proceedings today. Failure to abide by this instruction could result in the matter being reversed or remanded back to the commission for further consideration should it be appealed to Chancery Court. I would also advise the commissioners that all discussions about this case must be on the record. If we take any breaks during the day for lunch or just breaks during the proceedings, you cannot discuss the case with each other or with any of the attorneys or witnesses that were appearing before you today. I'd also ask at this time if any of the commissioners have any prior knowledge about this matter or have received any ex parte communications or have any familiarity with the respondents, either Ms. Vincent or Ms. Cudd, and if so, put that on the record.
Your Honor, I know Ms. Cudd.
I'm sorry?
I know Ms. Cudd. I've done business with her firm. I don't think it would influence me in this case. I know nothing about the case itself, but I do, for the record, want to let you know that. All right. Well, Mr. Chairman, it is your decision as to whether or not you believe that from an not personally, but whether or not you believe that on an objective, from an objective point of view, a reasonable person would call your objectivity into question in this matter, and if you feel that's the case, you should step aside. On the other hand, if you feel that that's not the case, then you are free to proceed. It's your decision to make, Mr. Chairman. Thank you, Your Honor. I think I'm good to go in this case.
All right. Thank you, sir. All right. The notice of hearing in these two cases were both filed on October the 5th of 2015, and I will provide that to you in a moment. Here on behalf of the department is Ms. Shalina Brown, Assistant General Counsel with the Department of Commerce and Insurance. Ms. Vincent is represented by Mr. Grover Collins of the Nashville Bar. Ms. Cudd is here and is not represented by counsel. Members of the commission, Ms. Cudd was represented by counsel, and her counsel has had to withdraw at the last moment for a personal reason, but the reason for the withdrawal is in no way the fault of Ms. Cudd or has nothing to do with the representation of Ms. Cudd. And I have discussed this matter with Ms. Cudd this morning, and Ms. Cudd, as I understand it, you are aware of the situation and you wish to proceed without counsel this morning. Is that correct, ma'am? That's correct. All right. And also, I believe, Mr. Collins, you had stated that you wanted to make a motion on the record.
Yes, Your Honor. Members of the commission, being that Ms. Cudd will be also a witness in my proceeding, it would be my desire for her to be represented by counsel as going forward. So I would make a motion in this case, just for purposes of the record, to continue this matter until the item that is keeping her attorney from being present for her today can be resolved and we can adjudicate this matter with more finality going forward. Thank you.
All right, Ms. Brown, you have a comment on this?
Yes, Your Honor. The department vehemently opposes any continuance of either of these matters. This is the fourth setting of this case. We have been attempting to have this matter heard before this commission for over 1 year. There has been continuance after continuance for various reasons. I would respectfully urge the board not to continue this matter There will be no prejudice to Ms. Cudd since she has waived her right to an attorney and is willing to proceed forward without one. And I would urge this board not to consider the continuance.
Right, Ms. Cudd, do you have any comment on this?
I agree with Ms. Brown. I'm prepared for my part of the case here. They're two separate cases, and I feel that if you'll be patient with me, I'll do my very best on that, but I do believe I have the facts and do not want to continue this.
Members of the commission, as is clear and will be clear once you read the notice of charges, these are two separate cases. There's a notice of charges filed against Ms. Cudd and a notice of charges filed against Ms. Vincent, but the facts are intertwined, and so the parties have agreed that for expediency, it's best to just put the whole case on once, and then you all make a decision as to each of the respondents in this case. We discussed this matter prior to coming in here, and I denied the motion for a continuance. However, since it's my practice that if something like this comes up at the day of the hearing and the commission is present, then I think it's appropriate to allow the commission to be heard on this. And so, Mr. Chairman, you have a request for a continuance from Mr. Collins pending before you, and it's up to the commission as to whether or not they wish to continue this matter to the next setting or proceed today, Mr. Chairman.
Thank you. Your Honor, members of the commission, is there a motion either to accept the recommendation or the motion of Mr. Collins or to deny? Ms. Taylor?
Can I ask a question?
Certainly. I was just trying to get a motion on the floor. So
let me ask a question.
Go
then
right
maybe
ahead.
I'll make a motion.
Yes, sir.
Mr. Collins, could you explain what the prejudice would be to your client if we went forward with the trial today? I didn't understand from what you were saying what the prejudice would be.
Thank you, Mr. McMillan. And to address that, with respect to the prejudice that would be with my client with respect to Ms. Cudd, I am not quite clear as to what Ms. Cudd's testimony will be as it goes forward. And going forward, as far as procedurally speaking, I believe that it would be more expeditious if she had her attorney here. And in the interest of time of the board, I would ask for that continuance. But to address your question specifically, there may not be any prejudice very well done by her proceeding on her own, other than possibly to herself.
Well, I appreciate your answer and understand where you're coming from. I would move that we deny the motion. The state opposes the motion. Ms. Cudd is willing to go forward and understands the risks and of doing that. We're all here. It's been postponed before. I think we ought to go ahead and go forward now. That's my motion.
We have a motion by Commissioner McMullen, seconded by Commissioner Horn, that the request to postpone or continue be denied. Is there discussion on the motion? All right, then let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. Your Honor, it appears the commission has denied that request.
All right, thank you, Mr. Chairman. We'll proceed. At this time, the parties have requested that we invoke the rule in this case. So all the witnesses that will testify in this matter, obviously other than party representatives and the respondents, need to step out of the room, please. Ms. Brown and Mr. Collins, do you all have witnesses here? Oh, okay. Brown, do you have the copies of the notice at this time?
Yes, sir.
All right. Council is now going to pass the two notices of charges to the commissioners, and we will stand in recess for a moment to allow you to review those charges, and then we'll hear opening statements. Have all members of the commission had an opportunity to review these charges? All right, all right.
Okay, Your Honor,
All
we're
right.
good to go.
All right. We'll go back in session now that all of the commissioners have had an opportunity to review these charges. I would again ask if any of the commissioners has any prior knowledge about this matter. Seeing none. All right. And as I stated before, but as now should become clear from reviewing these two notices, we do have separate charges against these two individuals, but obviously the facts are intertwined, and that's why we are presenting the case to you just on just one. But keep in mind that we are talking about the responsibilities and actions of two different individuals in this case. All right. At this time, I would ask if we have opening statements from counsel. Ms. Brown?
Sir.
Because of the number of people we have at council table, it might be, if I could ask counsel if you could stand up at the podium when you make your presentations and when you're questioning the witnesses, please.
Yes, sir.
Thank you.
Good morning, Commission members, Your Honor. My name is Shalina Brown, and I represent the State of Tennessee Department of Commerce and Insurance against the respondents, broker Hope Cudd and affiliate broker Deanne Vincent. There are two respondents before you this morning in this hearing. Respondent Hope Sharice Cudd is the principal broker of RE/MAX First in Maryville, Tennessee, during the entire time in question in this matter. Respondent Deanne Elizabeth Vincent is a licensed real estate agent working as an affiliate broker under Hope Cudd with RE/MAX First in Maryville, Tennessee, at the time of the alleged violations in this matter, and is the broker that interacted with the complainants, David and Terry Stone, and engaged in the various real estate transactions for the Stones. Affiliate broker Deanne Vincent met David Stone through a mutual friend and was involved in various real estate transactions concerning the sale of homes as well as property management. Often, Mr. Stone would refer to Ms. Vincent because she was familiar with the real estate market, and he often would solicit her advice and recommendations on how to handle various properties. She placed several houses on the market for him. Some she was able to sell and others she wasn't. She was also engaged in property management for several of his rental homes. In one particular instance, it was a home on 1339 Forest Hill, in Maryville, Tennessee, that Mr. Stone had solicited the advice and recommendation of Ms. Vincent concerning the sale of this home. Since the home was still under construction, Ms. Vincent suggested that Mr. Stone wait until it was completed before it was placed on the market. Mr. Stone asked Ms. Vincent to place this home on the market for him, and she did so. Unfortunately, it did not sell. So in an effort to generate some income, she suggested that they place the house on the market for rent, and they did so. Mr. Stone rented the home out through Ms. Vincent through the RE/MAX First agency in Maryville, Tennessee. The tenant stayed the complete lease term. The home was rented again for a second and third time. At the third lease term, it appeared that the tenant was not happy in the home and left and didn't complete the lease term. So Ms. Vincent approached Mr. Stone about renting the home for herself. He agreed to this and gave her a reduced rent of $1,000 a month, and they entered into a written lease agreement. In exchange for the reduced rent, Ms. Vincent agreed to manage several of Mr. Stone's other rental homes in the Maryville area. Mr. Stone is a pilot with American Airlines, and he travels often, so he relied on Ms. Vincent to collect the rent checks and make those deposits into his account while he was away internationally. He was often gone for several days at a time during each month, so he needed some assistance with his various rental properties. After Mr. Stone got married to Terry Stone, they continued to use the services of Deanne Vincent, and she continued to live in the rental home located at 1339 Forest Hill Road at the same rental amount of $1,000 per month. Deanne Vincent rented this property from the Stones from November of 2010 until May of 2014. Ms. Vincent was always interested in purchasing the property and had expressed this to the Stones, and at one point in 2013, they entered into a purchase and sale agreement to purchase the Stones property through RE/MAX First. However, she was unable to obtain financing, so the deal was not consummated. Today, you will hear testimony from the witnesses about how she was always trying to get the Stones to reduce the price of the home or manipulate the appraisal or do something in her favor in order to qualify for the financing for this home located at 1339 Forest Hill Road. Over the years, the relationship between the Stones and the respondent Vincent soured. After some time, the hassle of dealing with Deanne Vincent for the Stones became more of a problem, and her property management services were no longer helpful to the complainants, and they were losing money on the rental of the home. So they asked her to vacate the premises. But instead of vacating the premises, they got a letter from an attorney who attached a lease with option to purchase concerning the 1339 property. Now, you will hear testimony from David Stone telling you that they never entered into a lease with option to purchase for this property, and that document was altered and it was a forgery. So the Stones had to retain an attorney in order to address this. Finally, in May of 2014, Ms. Vincent vacated the premises. Commission members, this is a clear-cut case of a respondent that is engaged in misconduct. The department will prove that the acts and conduct of these respondents warrants disciplinary action that needs to be taken by this commission. And these real estate professionals no longer should be allowed the privilege of possessing their real estate license. Thank you.
Good morning. Commission members, it's a pleasure to be in front of you this morning. The state lays out a case of a very clear-cut case. I would submit to all of the commission members that no case is ever clear-cut, and more importantly, most of these, as I've sat through many of these, always have intricacies that once all of the proof bears out, a much muddier picture is what we see. One thing I will agree with the state on is this. Mr. Stone and Ms. Van Zant had a relationship professionally for a very long time. During this time, they trusted one another. They were business partners on deals. They even bought a house together at one point. And throughout this relationship, Mr. Stone gave Ms. Van Zant a reduced rate on 1339. Now, this reduced rate, as the state suggested, was because that was in lieu of compensation for the management business. We would submit to the commission that that was not the case. There was no agreement whatsoever as far as reduced rate for the management of his properties. What I think the proof will bear out from our end is certainly that Ms. Van Zant was managing several properties for Mr. Stone and receiving no compensation whatsoever except for the initial finding of the renter, which was done through her broker, Ms. Cudd, and which RE/MAX received the commission. Further collection of checks, delivery to Mr. Stone, and the like was continued for a number of years without compensation to Ms. Van Zant. We believe that this is a 5-count notice against Ms. Van Zant. We believe through the testimony you will find that counts 1, counts 2, counts 4, and counts 5 can be easily explained. There was a purchase and sale agreement to which Ms. Van Zant was actually the buyer. She did have a document which we will produce today, albeit unsigned by Mr. Stone, but signed by Ms. Van Zant, disclosing her personal interest. There was not, however, a confirmation of agency status given by Ms. Van Zant in that purchase and sale agreement. However, Ms. Van Zant was the actual purchaser and not acting as an agent in that case. No commission was awarded pursuant to that, or was going to be awarded pursuant to that purchase and sale agreement. Furthermore, you will hear that the reason that Ms. Van Zant was unable to obtain financing was because the appraisal done by her bank found problems in the house and in the household that disqualified her from an FHA loan. This was not a conventional loan, this was an FHA loan. They did their appraisal. As you all are well aware, the bank has their own person that does those appraisals, and Ms. Van Zant's appraisal found problems with the house that caused FHA to not be able to finance. Now, all of those facts will bear out, and I think it will be acceptable, the explanation given by Ms. Van Zant. However, I have a problem. I have count 3. Count 3 suggests fraudulent behavior. As suggested by the state, there was a lease in which it was purported to be forged. Ms. Van Zant has an explanation for that. Not an explanation that explains it in a way that makes it okay, but she'll tell you the circumstances surrounding that and why she did something that she is truly sorry for. After you hear the proof and the case laid out by Ms. Van Zant, I will stand before you again and respectfully ask you to punish Ms. Van Zant, but do not give her the death sentence on her license and allow her to continue to have a way of life, and as she's done for a number of years, and allow her to continue to practice the sale of real estate as she has done diligently for any number of customers that she's serviced throughout the years. Thank you.
Thank you, Mr. Collins. Ms. Cudd, do you have anything you'd like to say in opening? Again, you'll have an opportunity to fully testify and explain your side of this case, but if you have a brief opening, you go right ahead, please, ma'am.
Just a brief one.
Go ahead, ma'am. Ms. Cudd, I think probably at this point we need to, I should have done it earlier, but I think at this point we need to go ahead and put you under oath. So would you raise your right hand, please?
affirm that the testimony you're about to give in the foregoing case is the truth, the whole truth, and nothing but the truth, so help you God?
Go ahead, please. Speak into the microphone so we can hear you.
Excuse me, I'm a little nervous.
That's all right.
My name is Hope Cudd. Thank you for taking the time to meet with us today. I did just want to reiterate that my purpose here is a separate case, is that I've been charged with failure to supervise an affiliate broker. I have been subpoenaed to be a witness in Ms. Vincent's case, but I'm not sure how much I'll really be able to provide for that because I was not aware of any of the actions prior to receiving a TREC complaint in regards to Ms. Vincent's actions. So I'll be happy to answer questions, but I'm here to provide the information as far as what was, in regards to my case, as far as failure to supervise, which I do not believe I'm guilty of.
Thank you very much, Ms. Cudd. You can take a seat. Ms. Brown, you want to call your first witness, please?
Yes, Your Honor. The department would like to call Mr. David Stone. I believe he's in the other room. If you give me a moment to have him.
All right. I believe one of your co-workers is going to get Mr. Stone. Stone, would you go over there, please, sir? Take a seat right there, sir. And raise your right hand, please, sir.
Do you swear or affirm that the testimony you're about to give in
Thank you, sir. Ms. Brown?
Good morning, Mr. Stone. Could you please state your name and address for the record?
Stone, could you speak up and into the microphone, please? As long as the red light's on, that means that, yeah, that we could hear, it's picking you up. Go ahead.
My name is David Stone. My address is 3806 Atlee Drive, Lewis 7777.
And are you familiar with the respondent, Hope Cudd and Deanne Vincent?
Yes,
And who is Hope Cudd?
Hope Cudd is a realtor or a manager at RE/MAX.
In what city? Is that Tennessee? And who is Deanne Vincent?
She was a realtor for RE/MAX in Maryville.
Now, were these both your realtors?
Hope was not directly involved with anything I've done. I just met Hope after we became involved in this litigation.
And was Ms. Vincent your realtor? Now, did you have occasion to file a complaint with the Tennessee Real Estate Commission office on October 11th, 2014?
Yes, I did.
And with your complaint, did you include an affidavit as well as additional documentary exhibits with that complaint?
Yes, ma'am, I did.
And did you first have knowledge of the information that you contained in your affidavit?
Yes, ma'am, I did.
And where did you meet the respondent, Deanne Vincent?
I believe I was introduced to her by a friend of mine, David Perry.
And approximately how long have you known her?
Since, I don't really remember, probably, when did we meet?
Answer the question, Mrs. We need to, I need the best of your memory, sir.
I'd guess somewhere around 2010. I really don't know. I'm sorry.
That's all right. Did you meet her in her official capacity as a realtor or in a social setting?
Social setting initially, yes.
Okay. And were you aware that she was a realtor?
Yes, I believe I was.
And you became interested in using her services, is that correct?
That is correct.
And when did she and her company begin providing real estate services for you?
When I first began to market a property, 12-ish, I'm not positive about when that began, but yeah, it was first for the sale of the home.
What property was that?
Well, I had several properties at the time, but we began Forest Hills was the first property that we were involved with for the sale of Forest Hills. I had built it as a real estate speculation. It didn't sell. I took it back. I attempted to sell it, and I asked Ms. Vincent to assist me in the sale of Forest Hill.
And did you ask her to list and put it on the market for you?
Yes, I did.
And did she do that through her firm, Remax First?
Mr. Stone, could you speak up, please? I know you're rather soft-spoken, and if you could just maybe pull the mic. Oh. Thank you, sir.
Sorry.
It's much better.
And did the home sell?
No, it did not.
So did you relist it on the market?
We decided to try to rent it for a while and relist it later. The market was kind of down at that time.
And were you able to rent it?
Yes, I was.
And how long was it rented for?
I think we rented it for one tenant. I believe it was, I don't know if it was a 1 or 2 year contract, but at the end of the contract we attempted to sell it again unsuccessfully and then rented it again after that.
And were all these transactions done with Ms. Deanne Vincent?
Yes, they were.
And were they done through her office, Remax First?
Yes, they were.
Okay. And were all of, was it just this one rental home that she was handling, or were there any others?
At that time, it was just Forest Hills.
It was just the Forest Hills. And for how many years did you rent this property through her?
3 or 4 years, I'm not sure exactly.
And then did you sell the property?
No, I did not. Well, I eventually sold it. I did eventually sell it, but Miss Vincent indicated that she would like to buy the property, and it became a vacant mid-lease, and so she just moved in at that point with the intention of buying it.
So Ms. Vincent rented the property from you?
That is correct.
Was there a written lease agreement?
I believe there was, yes.
And what was the rent?
It was $1,000 a month.
And is this the same amount of rent that you were charging the previous tenants?
No, it was a lesser amount. It was hopefully a short-term rental while she got her finances together to purchase the home.
And is that the reason why you gave her a lesser amount?
That's correct.
Was she managing any other rental homes for you at this time?
Later she did. My wife suggested that we were giving her a pretty good break on the rent, that she could help out in managing some of the homes.
So in lieu of the reduced rent amount, she provided some property management services?
That's correct.
So you never had any compensation agreement for the property management service in writing?
No, we did not.
Now, was she the only one you dealt with at Remax First?
Yes.
Was there anyone else that you had any prior dealings with at Remax First?
I don't think so, no.
Now, when she was doing these property management services, did she remit the rent amounts to you directly?
No, she deposited them for me.
And she deposited them into your bank account?
That's correct.
Okay. And who kept track of all the rental payments and kept them on a spreadsheet and tracked all this?
I did not do that. I just
Did you rely on Ms. Vincent for this?
I did.
Okay, so she was also doing these services as well in her property management function?
Yes.
And do you recall, did she timely remit the rents to you?
I don't believe it was real timely, but I didn't know whether that was at whose thought that was. I don't know if the rent came in later or they were late deposited. I don't really know the sequencing of. I didn't question how the bank money got into the bank.
So for how long of a period of time was she your tenant at 1339 Forest Hill?
A year or so, I'm not sure.
And who lived in the home?
Well, it was rented to her and her daughter. I don't really know who all lived there. It seemed to be pretty well occupied when we later went in to look at it. There was, all the rooms seemed to be occupied.
And you had a written lease agreement with her?
Yes.
Your Honor, if I may approach. Your Honor, if I may approach the witness.
Yes. Ms. Brown, don't pass that to the board yet.
Mr. Stone, do you recognize this document?
Yes, I do.
Could you please describe it for the court?
It's a lease agreement for.
And- Sorry, go ahead.
Signed in 2010 for the Forest Hill property.
And who are the parties to the agreement?
Myself and Miss Vincent.
And is that your signature on the second page?
Yes, it is.
And is this the property that you rented to Deanne Vincent and her family?
Yes, it is.
Your Honor, I would request that this be entered as the next exhibit.
Without
I have no
objection.
objection. However, there is an Exhibit 3 at the bottom. Maybe we need
Yes,
to
is that-
scratch that out, or
Is that
just
from
for
a
clarity.
deposition or something?
It
Brown?
might have just been an.
All right, this will be marked as exhibit number 1, entered into the record. If you could, perhaps, ma'am, could you pass that to the? Go ahead, Ms. Brown.
Now, Mr. Stone, did Ms. Vincent sell any homes for you?
No.
Sorry?
No.
So she only handled the property management for your rental homes?
Well, she attempted to sell Forest Hills and I believe also my Myers Circle, but neither were successful.
She attempted to sell 2 homes for you?
I believe so, yes.
Now, how many homes did she manage?
I think it was 3 homes at the time plus the Forest Hills.
So 3 homes plus Forest Hill, 4 homes?
Yes.
And that was even during the time she lived in that home?
Yes.
Now, at some point, did she approach you about purchasing the 1339 Forest Hills home?
Yes, she did. That was when she originally moved into the home. The tenant moved out mid-lease, and she said, well, and basically suggested instead of trying to, lease it again to someone else, that she could, I could rent it to her while she got her finances together in order to purchase it.
And did you enter into any agreement?
Yes, we did.
And did she ask you to reduce the price of the home prior to entering into that agreement?
She did. It hadn't sold at the price we were, trying to sell it for, and she asked if we could reduce it, and I agreed.
And was she successful in purchasing the home?
I know she never was successful at that.
Why not?
She just didn't seem to be able to get her finances in order.
So then what did you do with the home?
Well, she finally asked me to lower the sales price below what I thought it was reasonably marketed at, and I just told her that I'd like to put it back on the market and sell it myself.
And did you sell it?
Yes, we did.
Okay. And did she vacate the premises?
She eventually vacated, yes.
Okay. Now, if we could just go back to the complaint that you filed with the Tennessee Real Estate Commission office. Your Honor, if I may approach the witness. Mr. Stone, do you recognize this document?
Yes, I do.
And is this the complaint and affidavit you filed with our office?
Yes, it is.
And is this signature on the complaint and affidavit your signature?
Yes, it is.
And if you wouldn't mind, if you could please read the affidavit aloud into the record?
Ms. Brown, why are we going to have him read this?
I can have the board members read it, or
Yeah, we don't need to have him read this.
okay.
We'll let the board read that. Were you putting this into the record as an?
Yes, I would like to.
All right. Without objection, then this will be exhibit number 2. If we could have this passed to the board, and I'll give the commissioners an opportunity to review this document before we proceed. Go ahead, Ms. Brown.
Mr. Stone, back to you having to have Ms. Vincent vacate the 1339 premises. Did you have to hire an attorney and send a notice to have her vacate the premises?
Yes. The reason we hired the attorney, we were discussing Ms. Vincent leaving the Forest Hills property, and I wanted to make sure that we were doing it correctly by the lease, and I didn't have a handy copy of the original lease at the time. And so we asked, to get a copy of the lease from Ms. Vincent to make sure we were going to comply with the conditions of the lease. And I got a call from an attorney. I don't recall the gentleman's name that was representing Ms. Vincent, saying that we were not in compliance with the lease, and named several items that I didn't have any recollections of. First off, it was referred to as a lease to purchase, and that was not something I recalled having done. And so we asked the attorney to send a copy of the lease to purchase or agreement, and it's on that document that we noticed that the signature had been copied and pasted to it, and it had items in it that were pretty well, there were things I wouldn't have agreed to. They were very much in favor of Ms. Vincent and the sale, or the possible sale of the property. They almost were ridiculous in their nature, and so we hired an attorney to represent us in that regard.
So you were sent a letter from an attorney hired by Ms. Vincent with a lease with option to purchase document attached?
Correct.
Okay. Your Honor, if I may approach the witness.
Yes.
Mr. Stone, do you recognize this document?
Yes, I do. It's the document that we had the questions about the lease to purchase that I had never, no memory of signing. And if you'll notice on the signature block last page, it's exactly the same as on the original lease agreement that I had signed.
So was this the letter that the attorney, Ms. Deanne Vincent's attorney, sent to you attaching the lease with option to purchase agreement?
Yes.
So was this the first time that you had seen this document?
That's correct.
When the attorney sent it to you?
Yes.
And is this the document that you signed with Ms. Deanne Vincent?
No, it's not. That was the issue I had with it, that I had never seen the document, nor did I sign it. And if you'll notice, the signature blocks on the original lease and this lease are the same. And the last line of the original lease, the wherefore line, if you'll notice, it's not parallel to the rest of the text on the page of the lease to purchase arrangement.
So this signature block is the same as that was on the lease agreement?
Yes, it is the signature block from the original lease agreement transposed to the lease to purchase agreement.
And this is not a document that you have ever signed?
That's correct.
And you never entered into a lease with option to purchase for the 1339 Forest Hill property?
That's correct. I never entered into that agreement.
Your Honor, I would request that this be entered as the next marked exhibit.
Exhibit number 3, if you can pass. I'm sorry, Ms. Collins.
And I apologize for interrupting, Your Honor. I just have a question as before this is authenticated, if this is the entire document. It appears there's 2 paragraph 19s, and I just want to make sure that this
All right.
is the entire document that was given to Mr. Stone.
It appears to be, yes.
All right, then we'll enter this into the record as Exhibit Number 3. If you could pass this to the commission, please. Go ahead, Ms. Brown.
Mr. Stone, so at this point, after receiving this letter, what did you do next?
We engaged an attorney because I didn't know how to proceed from that point.
And you consulted with an attorney, and what happened?
I believe he responded to her attorney, and it was dropped at that point. I don't think it proceeded any further than that when we pointed out that the document wasn't an original.
And had Ms. Vincent vacated the property?
I'm not sure of the timing in that, but she did vacate the property.
And were you able to enter the home to inspect it?
Yes.
And upon entering the home, what was the condition of the home?
Your Honor, I'm going to object to the relevance of this.
Your Honor, I'm just trying to determine what the situation was and what action he had to take after she vacated. It's all relevant in terms of his complaint that he had filed.
I don't believe it's relevant in terms of what the notice of charges are. And
I agree with you, Mr. Collins. I'll sustain that objection. Let's move on.
Mr. Stone, did you have to file a civil suit against Deanne Vincent? I believe he does reference that in his complaint.
while he may reference it in the complaint, I would, again, cite the notice of charges and the burdens on the state to prove her charges, not necessarily what's in the complaint.
I agree with you, Mr. Collins. So let's move on.
Now, you had mentioned that you had really no other interaction with anybody else at the RE/MAX First agency. Is that correct?
That's correct.
So, how do you know Hope Cudd?
Only in follow-up of this action, I hadn't met her at the time at the office or anything.
So you had no interaction with her at the time you were dealing with Ms. Vincent?
That's correct.
And when Ms. Vincent began providing property management services for you, you never met Ms. Cudd?
I don't believe I did. I may have, but I don't think I did.
What about when you entered into the purchase and sale agreement with Ms. Vincent?
No.
Now, weren't these documents processed through the RE/MAX First Agency?
I really don't know how they were processed. The only back to your original question, I guess we didn't. Since I really don't know how the documents were processed, but I don't believe that RE/MAX. I don't believe they were involved in that. I thought that was an agreement between Ms. Vincent and myself.
I believe you had said that the documents were processed through RE/MAX First.
Well, they have it on the papers, but I never met anybody there, nor did I discuss it with any other staff there.
So you never had occasion to visit the offices of RE/MAX First in Maryville?
Oh, often, because that's where Deanne's, Ms. Vincent's office was.
Were you aware that Hope Cudd was the supervisor of Ms. Vincent?
No, ma'am.
So you did not even know that Ms. Cudd was her principal broker?
No, ma'am.
So when was the first time you met Ms. Cudd?
Well into these proceedings where we filed the complaint, and we filed with you folks because I didn't know that it was relative to the RE/MAX at all. Lease to purchase didn't have anything to do with RE/MAX. It was just on a sheet of paper, and so I thought, well, that's not part of her performance at RE/MAX. So I brought the complaint to you because I thought it was unethical behavior.
Now, at the time you began having problems with Ms. Vincent, was she still employed by the RE/MAX First Agency?
Yes, she was.
And did it occur to you to go to them with your complaint?
Well, no, it didn't, and it was because that the dealings we had were not. Well, I guess I could have gone to them and complained, but the problem I had with Ms. Vincent was that I felt she had forged a document in a business dealing with me, not that RE/MAX itself had any involvement in it.
Your Honor, I have nothing further. I tender the witness.
Yes, please. And Your Honor, would you prefer at the podium? Or?
I would, because
Yes, sir. Good morning, Mr. Stone.
Morning.
Can you tell the commission what type of relationship you and Miss Van Zant had? And I don't mean
Well,
to imply any.
No, I considered her to be a good friend. I enjoyed her company. I thought she was a very pleasant, nice person. I enjoyed the business dealings we had. I thought she did a good job, except, we didn't sell the house. So, and I thought she was a nice lady.
Okay. She was managing several homes for you, correct?
Yes.
Okay. And during that time, did you have any problems with her, shorting you money or not getting you what you needed, or any problems generally with her?
Well, it turned out that I wasn't really monitoring the situation very closely, and after I got married, my wife, I didn't really want to have anything to do with rental properties. My first wife had been involved in rentals, and she was killed in an accident, and I just really didn't want to have anything to do with it, but I still had all the rental properties, and I work as a professional pilot, and I'm gone quite a lot, so it was very helpful to have someone else, manage my properties while I was away. And so, no, I wasn't monitoring the income of them or anything from it very closely. And it turned out after I remarried, and my wife said she wanted to be involved in the rentals, and I said, please have at it. I don't have any desire to be involved in it. She noticed some discrepancies in the payments and timing of the payments.
And just so we're clear for the purposes of the record, I'm just trying to get the timeline straight. When were you remarried?
11/11/11. I can remember that.
Smart man. I should have done the same. And that was to Terry?
Yes, Terry.
Okay. And you had never negotiated or signed any contract with Ms. Van Zant with respect to compensation for her managing these rental properties?
No.
And in fact, you used RE/MAX the first time to find these purchasers, or these renters,
Yes.
pardon me, every time.
I don't know if it was every time, but I think initially I did run it through RE/MAX, but I don't know that we continued to do that or not.
In any respect, though, Ms. Van Zant in no way received any compensation in the form of payment from you
That's correct.
for the management of these properties. Okay. And during that time, she would collect checks and deposit them for you in your own account.
That's correct.
I apologize to the commission for being redundant there. I just wanted to make that point. Now, you said you met her around 2010. Is that correct?
It's probably earlier than that because I'm looking at the dates on this material here, but I really don't recall exactly when we met. Sorry.
I realize it's been a while, so no harm, no foul there. Did y'all ever enter into business dealings together, such as purchasing a home?
Yes, we did. Ms. Vincent had a property, an investment property. She asked me if I'd like to become involved with, and it looked like a good prospect to buy, fix up, and sell. So I invested $40,000 in that, and I believe her uncle or some relative invested also, and we had at a very bad time in the market. The market was just flat as it could be, and we could not seem to get a buyer for it. So,
in any respect, I mean, y'all's relationship was to the point where y'all were buying houses together, working together.
Yes.
Would you say it was a strong relationship?
I was very. I enjoyed working with her and thought she was a very pleasant person. Yes.
And when would you say that this relationship, in the words of the state, soured?
Well, I guess after I married him, Terry initially, seemed to just as well taken with her as I was. She was very pleasant, but when she started looking over the finances and they just didn't add up, and there were, some missing payments and things like that. So about then we started having, I began to be a little reserved in our relationship, yes.
So let's talk about 1339 Forest Hill. That was the property that Miss Van Zant was living in, correct?
Yes.
And that was for $1,000 a month.
Yes.
And that lease term initially started in 2010.
Yes.
And then thereafter, when it ceased sometime in 2011, correct?
Yeah.
I believe that's Exhibit 2. After that lease ceased, you continued to be in a month-to-month relationship, rental-wise. Is that
Yes.
correct? Okay.
Well, now wait a minute. Once Miss Vincent moved out, no, she did not continue to manage our properties.
Well, I understand when she moved out. I'm sorry, I was unclear. Let me rephrase for you. You had a lease with Miss Van Zant
Yes.
for a term of 1 year?
Yes, I believe that's the term.
Okay. Now, during that time, did she stay after that lease term?
Well, the only way I could do that is look at the dates, but I think
Go ahead. I mean,
I think we went to a monthly lease at some point in there, month
Please
to
take
month.
If you ever need to refer to something, just let
Thanks.
me know and we'll go ahead and do that. I believe it'd be, yeah.
There's item 3 on the lease agreement, I believe, from somewhere in November 2010 until November 2011 was the initial term, I believe.
I apologize, Your Honor. For purpose of the record, that would be Exhibit 1. And so she continued for that period of time after the 2011 October 31st.
Yes.
And she continued to stay in the house until 2013, is that correct?
Or
Or is it 2014?
we'll have to look that one up too.
Okay.
I guess it would have been around in 2014 because that's when yeah, I got the letter from her attorney, Mr. Stallward.
So prior to that in 2014, after the 10/31 of 2011, 2014, She's continued to pay you $1,000 a month without
Yes.
incident. Was there any time where you felt the need to check on the condition of the property or anything like that? Prior to moving out, her
No,
moving out?
no, I didn't.
Okay.
I didn't feel the need.
Now, question I have for you now, Mr. Stone. She's managing several properties for you. You said 3 in addition to the Forest Hill, correct?
Yeah, let's see. There was one that had a lease, lifetime lease involved in that, and then there were 3 additional in Forest Hill.
Okay, now, I want to talk to you about the lifetime lease, okay?
Uh-huh.
Who was that lifetime lease with?
It
What was
wa-
the property address and who was it with?
That is 8, 11, and 13 Alexander, and that would have been Brenda Stowell.
Yes.
Mr. Stone, can you identify the document I've just handed you?
It's the lifetime estate lease for 8, 11, 13 Alexander.
And that's the one you were just referencing, is that correct?
Yes.
Your Honor, I'd like to make that the first exhibit of our proof.
Mark this as exhibit number 4.
Now, Mr.
Do you have a
Stone,
copy that we can mark?
the state has one. I need. I don't have copies for the commission. I'll
All right, if
apologize.
we have a copy that we can put into the record and pass to the commissioners. Does Mr. Stone need this to testify from, too?
Just one question, Your Honor.
All right, why don't you go ahead and ask him, and then we'll put in the record and pass it to the board.
Mr. Stone, there is a piece of that lease agreement in which you name a property manager. Is that correct?
Yes, it's must be item 2, second page towards the top.
You named Ms. Van Zandt as the property manager. Is that correct?
Well, yes, to collect the rent, yeah.
Now, this was done at your attorney's office.
Yes.
Okay. Did you name her the property manager without her knowledge?
Quite possibly. She was collecting the rents for me, and I was just telling, this person where to send the rent, so yes.
I mean, quite honestly, you've got a good relationship. She's been collecting rents on it. You just assumed she would collect on
Continue.
that one. as well.
I assume she would continue that, yes.
Okay, and you did that on your own accord at the attorney's office?
That's correct.
Okay. Now,
Mr. Collins, could you get a copy for us, please?
and coincidentally, when you did this without the knowledge of Ms. Van Zandt, you, of course, did that without the knowledge of Ms. Cudd, correct?
That's correct, yes.
Okay. And again, to reiterate, you hadn't met Ms. Cudd and didn't even know Ms. Cudd until well after this.
Correct.
Okay. Now, at some point, you tried to refinance the house at Forest Hill, is that correct?
Yes.
Were you successful in being able to refinance that house?
I didn't find terms that were acceptable to me, no. I could have refinanced, but it would have been worse than, I used a home equity line of credit for it, and I was trying to split that off, but it wasn't worth the money, and it just didn't work out.
I don't intend to get personal with your finances. I just
that's
want to
okay,
know, was there a appraisal done during that refinance?
I believe there was, and I think it was around 265, but I'm not positive, sorry.
Did you get to the point where an appraisal was done, and you're sure of that, or is
Yes, there was an appraisal.
Okay. Subsequent to that unagreeable terms to refinance, then you approached Ms. Van Zandt about her purchasing the home. Is that correct?
I don't think that's exactly correct. I think
I apologize. I don't mean to mischaracterize.
Okay.
You just tell me what you think.
when as I think as I earlier stated, we had a tenant move out mid-lease, and Deanne, Ms. Van Zandt, had said she had always indicated that she was interested in buying the home, and when that renter moved out mid-lease, she said, well, I can just move in and get my financing together and buy the house.
And during that time, did you actually come to terms with her on what that purchase price would be?
Well, it kind of went back and forth quite a bit, but she, I believe, original was it was agreed that she would pay the appraised price for it.
Okay. Now, at some point, that price was negotiated downward. Is that correct?
Yeah, she asked me if I could lower it, and I tried to lower it. Yes, I did.
Okay. And she was being the purchaser, and did you both agree to not use a real estate agency for this?
Yeah, that would have been fine.
Okay.
There's no point in it.
So with respect to the purchase of this house, your home at 1339, or proposed purchase, there was going to be no compensation for real estate services.
That's correct.
Okay. Was that reflected in the reduction of price?
But yes, I believe it was.
Okay. But she was acting as her individual capacity as a buyer,
Yes,
and at no point was a real estate agency used
that's correct.
with whatsoever. Okay. Do you recall whether or not she prepared a purchase and sale agreement pursuant to the agreement you had worked out?
Yes, there were, I believe, several iterations of that agreement.
Okay. And in those purchase and sale agreements that she prepared, at any time was there an enumeration of compensation being paid? In other words,
No,
okay, so at no point was anybody going to get paid for the
Correct.
sale?
that's correct.
Not broker, not Ms. Cudd, not Ms. Van Zandt?
That's correct.
Nobody. This was totally outside and her working just as a buyer. Okay. During that time, had you always known Ms. Van Zandt to be a real estate agent?
Yes,
Okay. Was there any doubt in your mind that she was a real estate agent?
no.
Was there any doubt in your mind that was what she had always done?
I didn't know about always, but as long as I had known her, she was doing that.
In any respect, nobody was getting any compensation for that sale?
That's correct.
Okay. And at some point, she attempted to obtain financing for that purchase. Is that correct?
That's my understanding.
Do you recall, or do you know, you may not know, I'm just asking, what type of financing she was attempting to secure?
I think I just saw something about one of the mortgage types on something. Let me look. Hold on. But I didn't have any knowledge of how she was pursuing the mortgage. No, it would only be from something I just read.
Yes. Do you have copies of these documents from Ms. Chudd? Ms. Cudd, excuse me?
I did not realize she would be a party to this hearing.
All right, we're going to make copies for her at our break, so go ahead. Brown, do you have an extra of the previous document? Do you have an extra copy of that? No, the one they're looking at, number 4, the life.
I have an extra copy with holes in it.
Okay, well, we need to get a copy from Ms. Cudd, and I was going to make a copy at a break. But if either of you have an extra copy of that,
I'll get one to her, Your Honor.
okay, thank you. All right, go ahead, Mr. Collins.
What did you say it was, 411?
Talking about this.
I believe it's the lifetime lease that.
No, I don't have a copy of the
Life term. No, what do you? Okay, thank you, Ms. Collins.
I apologize.
Go ahead.
Mr. Stone, can you identify the document in front of you?
Yes, it's a purchase and sale agreement.
And was that the purchase and sale agreement prepared by Ms. Van Zandt for the purchase of 1339?
Yes,
Okay. Your Honor, I'd like to make that the next exhibit to this.
Exhibit number 5.
And you received a copy of that purchase and sale agreement prepared by Ms. Van Zant, is that correct?
Yes, it is.
Okay. Do you remember or recall whether you received, where did you receive that document, first of all?
I don't know if I received it by hand or by mail or how, but I did have a copy of it.
Your ordinary course, would you go to her office? Or
Yeah,
would you?
if
Okay.
I was in town, I'd stop by there if we had some business to conduct.
Okay. But for purposes of this, you don't know whether you got it from her or?
Sorry, no, I don't.
Okay. Document for me, please.
It says personal interest, disclosure, and consent.
What is the address on that personal interest and disclosure?
Remax First, 612 Crawford Street. Is that what
I
you're
mean, for the, what purchase, is there a home address?
Oh,
on it?
yes, it is. That's Forest Hill address. Uh-huh.
Okay, and the 1339, the
Yes.
property we're discussing?
Yes.
Okay. Do you recall whether or not you received that document?
I do not recall whether I received that or not.
And you don't know whether you received or didn't receive that?
Let me just glance over and see.
Sure.
I see the
Sure. Take
title,
all the
but I
time you
really,
need.
I really don't know what it says.
Right. Go ahead.
But I do not know if I have a copy of this or received it. No, I don't.
At some point in early 2014, you requested, after she couldn't obtain financing, were you ever given a reason as to why she couldn't obtain financing? Do you recall?
No, I guess I really don't recall the reason.
Okay. Did y'all ever have a discussion about an appraisal or anything like that?
She felt like the appraisal wasn't valid because it was in the county, and she thought the guy that did the appraisal had used comps. Is that the word? That were in the city. So she was not comfortable with that.
Subsequent to her being removed from the property, you were able to sell the house at some point.
Yes.
During that time, well, first of all, what was the sales price that you received?
I think it's like $264. It's right at the county appraisal, which was what I was hoping to get out of it all along. So that was.
And at what time, how far along did it take in 2014 for you to actually sell the property?
Well, it went like hotcakes. It was on the market for less than a month, and there were three buyers interested in it. So it went very fast.
Who listed it for you?
I think I listed it through Remax. No, I'm sorry. I don't know.
In any respect, you got it sold for $264, you said?
I think so. It was the county appraisal, whatever that was. I believe it was $264.
Did you ever have to fix or remedy any water damage?
No, as a matter of fact, Miss Vincent had mentioned that she had somebody had told her it was built on a spring or something, and she said she had gotten some people in to give her an estimate for repair, and it just so happened that I mentioned that to a friend of mine, actually the brother of the guy that built it, and he said, I put in the septic field for that, and no, that's not on a spring. What happened is the septic field on the initial installation backed up and, just filled up with water. That it was a failure of the new septic. There's something he did that wasn't right, or the installer had done not right, and they called the builder's brother in to remedy it. So he said, no, that's not a spring. That happened when this failure happened.
Okay. Did you have to make any repairs to that septic system?
At the time, I'm sure it was repaired because there was a failure involved in the backup. David Perry and I were building houses together, and David had hired someone other than his brother, Robert, to put in the septic. The septic failed. David called Robert to see if he could fix it. Robert can fix anything. And he found the failure, repaired it, and he said, no, he told me that that's where all that water came from and that there's no spring under the house.
So in this case, I guess it was better to keep it in the family.
I guess. He should have to begin with. Robert does things well.
Moving on, though, when you sold the house, did you make this disclosure about the possible?
Yes. They asked about the water level, and I told them exactly what I've been told verbatim.
Perfect. Okay. And other than that, you were able to sell it for $264.
Yes.
Prior to that, and prior to when you asked for a copy of the lease, you then received a document that appeared to have a forgery on it.
That's correct.
Now, was this immediately apparent to you?
It scared me to death because the terms of the lease for purchase were so unfavorable to me. It looked like I couldn't sell it to anyone but her. That's what her excuse me, her attorney was telling me I could sell it to no one but Miss Vincent, and I had to sell it at that price. I thought that's ridiculous.
But in any respect, to reiterate my question,
I'm sorry.
No, please, I'm not attacking you on this, but in any respect, you knew immediately that you hadn't signed that document.
Yes.
And you knew that you wouldn't have agreed to those terms
That's
under any
correct.
circumstances. And pursuant to that, you were able to immediately decipher, pardon me, that this was in fact a forged document.
Well, immediately after I went up and started tearing my files apart and found the original lease, and then happened to look at the last page of the lease and noticed that the signature blocks were identical.
Do you feel like you sustained any loss in value of your ability to sell the house pursuant to this forged document?
No.
Okay. So, other than whatever qualms you have had with Ms. Van Zant subsequent to that, as far as purchase price, there was no loss incurred because of this purported forgery. Is that correct?
That's correct.
And you were able to honestly be 100% whole as far as selling it for fair market value. Is that correct?
That's correct.
Okay. Your Honor, if I could have a moment with my client.
All right.
Your Honor, that'll be all of my questions. I'll pass.
Thank you, Mr. Collins. Ms. Cudd, do you have any questions for Mr. Stone?
Short ones? Hello, Mr. Stone.
Hello.
I think we've actually seen each other maybe twice.
I think so. I think.
I'm not sure if we'd recognize each other on the street.
I just apologize for introducing myself to you again in the car because we had met before.
I just have a few short questions for you, hopefully before we take a break. Did you ever call me personally or speak to me about the lease agreement
No.
that you had with Ms. Vincent? Did you ever call or speak to me about the purchase and sales contract?
No.
Did your attorney, or did you ever instruct your attorney to call me or contact me once these issues began?
No.
When we managed your properties before, which Remax First had managed properties before,
Yes.
where Deanne was managing them, do you recall seeing our company info at the top of the documents?
Usually there was. Yeah, I believe you have a header, and there was something at the bottom too, I think.
Yes, okay. Did you notice that when she started managing the properties individually for you, outside of our office, that was missing?
That's correct. There's nothing there.
Okay. Did you ever think that there was anything wrong with that?
No, it wouldn't occur to me, no.
Okay. Do you recall that when Remax First was managing some of your properties prior to Deanne managing them, that we charged a 10%
Yes.
per month fee?
Yes,
And that once Ms. Vincent started taking that, Remax was not
that's correct.
collecting anything? Okay. That's all my questions.
Thank you. Ms. Brown, do you have any redirect for Mr.?
Yes,
No.
Your Honor, actually I do. Just briefly. Mr. Stone, Ms. Vincent's attorney was asking you about the lifetime lease, and he had mentioned that you had just inserted Ms. Vincent's name as the property manager, and you did not get her permission prior to doing that. Now, after you had put her name in, did you let her know that you had done so?
She was already collecting the rents from that property. I just added, put her name in there on the document to continue.
She was already receiving those rental payments, and you just formalized it
Yes.
by inserting. Okay. Thank you, Your Honor. Nothing further.
Else, Mr. Collins?
Just in response to the redirect, when did she start collecting rents to the best of your knowledge?
It would have been in 2011 or 12.
11 or 12?
I believe so, yes.
Is it possible that you're mistaken as to when she started collecting?
Yes, it is.
Okay.
It's quite
Thank you.
possible.
Right. Ms. Cudd, any other questions for Mr. Stone?
No questions
All
for
right,
me.
thank you. Members of the commission, questions for Mr. Stone?
Who would like to go first? Ms. Franks?
Hello. Do you feel that Ms. Cudd is in any way could have known anything about your dealings?
Oh, ma'am, I can't think of any reason or any way that she would have been involved or could have any knowledge of it. Sorry.
I'm wondering that Ms. Vincent, evidently, I don't have that before me right now, but the purchase and sale agreement, there was no earnest money on that purchase and sale agreement.
No.
Can you explain that?
Well, we had an ongoing relationship, and I considered her a friend. I didn't think there was any point in it.
And have you ever had a class in contracts?
No, ma'am. I was an engineering student, and I know, what holds up a bridge, but nothing else. Sorry.
So you were relying on her
Yes.
to advise you on that as to what makes a real contract.
Yes.
And I also noticed on it that there was no binding agreement date. That was not filled out.
Well, I just, as soon as you can get it together, we will make the sale. It wasn't, I tried not to limit her. I knew she had to get her finances in order to purchase, and I didn't know what was involved in doing that. Yeah, I was receiving a rent from the property. I wasn't on fire to get it sold. I just would like to get it taken care of.
So she did not explain to you what a binding agreement was then, did she? Okay, because that happens when the two of you agree on something, on the contract, that's the binding date. Can you explain why So there was there a length of time that you gave her to get a loan?
Initially, it was going to be within the year, but
Okay, so you gave her 1 year to get a loan.
it kind of crept on after that, yes.
Okay. And so then why did she stay in the house after that 1 year?
I thought she was making an honest effort at securing her financing, and I thought, I had faith that it would work out.
And so by the time you got to 2014, what had she told you in that length of time? What had she been doing to get a loan?
Said she, attempted to do this, and it didn't work out. And, for some reason, the loans, she couldn't get the loans, or she didn't, she had an investment property that precluded her getting the loan. I don't recall all the excuses. They seemed valid to me at the time. And, I was getting rent for the property, but I needed, the market was coming back up, and I wanted to get rid of the property.
Okay. When and I don't mean to be personal either, like Mr. Collins did, but when you remarried, did your wife, is she a licensed real estate person?
No, but she's extremely intelligent.
Okay, sounds like it.
We just make sure that's on the record.
Okay. So she was the one who brought it to your attention first, and
Yes, she did. She's got a real eye for detail. She had been a legal secretary before, and
okay.
she's just very good at spotting inconsistencies and things. And I handed over the business of the rentals to her gladly because I had no desire to do that. And she said, "Well, the figures just aren't adding up here. There's something going on."
And so what did you do? Did you ask Miss Vincent about that, or what did you do?
We did, and she said, well, one of the things, well, we hadn't gotten payment on one of the properties for 3 months, and she said, well, I believe that the guy's wife had lost her job, and he was having some difficulties, and that's
So she didn't explain that to you until you asked her?
correct.
Okay. I think that's all I have.
Thank you. Taylor? Okay. Ms. Hills?
Mr. Stone, one of the exhibits that the commissioners are still looking at, I guess it would be number 4. It's the purchase and sale exhibit.
ma'am.
And this may not be a fair question to you, but if you look at that, and I think you have a copy on the side, the left-hand side, it has.
Don't have a copy.
You
but
don't have a
I
copy.
did look
I
at it.
apologize,
Go
I
ahead.
didn't bring a
Okay.
copy.
Want him to look at this?
It appears to have pages missing. On the left-hand side, it has line numbers, 1 through 47. It appears that possibly page number 2, 4, 5, and 7 could be missing.
I'm sorry, no, I
Okay.
don't know about that.
I'll wait.
In the meantime, Mr. Bloom, are you still?
I'll
I'm sorry, go ahead.
go ahead with my other thing. Moving away from the purchase and sale agreement, on the lease agreement, Exhibit 1, on Section 12, it says that the last line, it says deposit to be deposited in for security deposit to be deposited into First Tennessee Bank, Maryville. Would the security deposit, would that be your account that it would be deposited into First Tennessee account? Number 12.
Yeah, I'm looking at the date, and I don't think so because I didn't have a First Tennessee account in 2010. It could be just the typo, but
Right. And then on the second page, number 21, it said notices are to go to RE/MAX first, and it gives the address. All notices provided. And on number 22, it said maintenance requests are to go to RE/MAX first. Were you employing RE/MAX first to do your maintenance and things? Did you?
no, ma'am.
At that time?
I was not.
Okay. And to exhibit number 3, which was the letter from Ms. Vincent's attorney, on the first page, at the very bottom, the attorney is saying that Ms. Vincent would agree to have an inspection done and gives possible dates and times. Did you ever request an inspection during these times or request an inspection after you received this April 9th, 2014 letter from her attorney?
I think after I received this letter, I went and immediately sought counsel. I don't think I pursued it without counsel at that point.
Okay. So you don't request going into the house to make inspection?
I don't think so after we received this letter, no.
When did you first go in the house then after you?
After Miss Vincent had moved out.
After she'd moved out? And were you accompanied by a RE/MAX first?
No.
Okay. And how did you find the house?
It was in pretty poor repair. It was pretty messy.
Did you have to do maintenance to it?
A considerable amount, yes.
Ms. Hills, the area that you're getting into at this point is the subject of an objection from
Okay.
Mr. Collins, and anything that transpired after Ms. Vincent moved out of the house is not relevant to this proceeding because we are bound by the notice of charges and that dealt with her dealings with Mr. Stone.
And we don't know if there are missing pages in the purchase and sale. Okay. Thank you.
I go Commissioner Bloom.
I just
Okay.
want to make a comment. I haven't seen neither 4 nor 5 at this point in time. That's what I was trying to say.
You have now number 5.
I have 5. 4, I thought it was my copy, so I was glancing over it, but I really haven't seen it.
Oh.
Does that
We're going to,
Yeah.
you'll
I
have
thought
your
you'd read it.
opportunity.
All right, thank you.
Wait, in the meantime, Commissioner Bloom, if you have questions.
Mr. Stone, thank you for being here today. I know probably not a comfortable event today. Is this a lease agreement that you used in all the leases that you used with Ms. Vincent?
I don't know, I'm sorry.
In the line she referenced where a deposit was to be made to First Tennessee Bank, if you'll go up 4 more lines, I was just wondering if this document was altered in some way. It says, execution of the lease contract, the sum of blank. So
Which line are you on, sir?
4 lines up from the line that referenced First Tennessee Bank deposit.
Does it
4
have
lines north.
Does it have a line number by it?
No, it just, line number by it. It's the paragraph that addresses security deposit. At the end of that first sentence, it says the sum of period. So was there a deposit received from Ms.
No.
Vincent?
No,
on
there
the
would not
lease
have
that-
been a deposit, no.
Okay, was there a deposit received on any leases that she executed for?
Yes, yes.
Okay, on those leases, was that line filled in?
I don't know, I'm sorry.
Okay. All right, sir. Let me ask you one other question. You mentioned that Ms. Vincent managed several homes for you.
Yes.
Or maybe the attorney did. I'm not certain. What in your mind did that mean, that she managed your homes?
She collected the rents. She received calls from the renters for repair. And if I were not able to make the repairs, or if I weren't in town, then she would arrange to have the repairs made.
She paid for that work?
No.
Was the reduction in rent considered to be compensation for her?
Yes.
Okay, so she was paid for that. That's considered a valuable
Okay.
consideration. Okay, thank you very much.
Sorry.
Sir, I guess it's captain, is that right?
Yep.
So you don't sit on junior side anymore.
I don't sit on the right side, it's the left side.
A couple of things that I just kind of wanted to hear you say, I guess, is that the signature block, you say it was transferred from one document to
Yes.
another. So you are saying that's not your original signature. I mean, I know it's your signature, but you didn't sign that document.
I didn't place the signature on that document, that's correct.
Okay. And how did you think that she was managing if she wasn't going through RE/MAX?
It didn't occur to me to wonder. I just assumed she managed it as an individual.
It seems like the deal might have been made. We can do this outside of the company, and I don't understand why. At some time or the other, that you explained it when you said you got a new wife. They usually turn your business upside down, but is there some way that a flag could have waved to say, look, something's not quite right here?
Probably to someone paying close attention, yes. I was not, I was doing going to work, doing my job, and coming home and monitoring my rental account for money coming in. I didn't really balance it to the penny, but it had an approximate amount in every month that looked reasonable. But there were obviously some omissions.
I just have a couple more that we wanted to ask you about. Sometimes it seems like the accountability might not have been all there. Is there some way that you could trace and say, my account should show this much, and it's not? Before you answer, let me try to clarify what I'm saying here. Sometimes people will have a habit of putting money in your account on time or this. Did you have any day that you would expect your money by?
No, sir, I did not. My schedule was such that it changed month to month, and I was, in town and out of town at different times during the month. One of the things that I had never thought about that my wife pointed out was that it would be a good idea if Ms. Vincent could, on the deposit slip, instead of just putting an amount, list where the deposits came from. And up until that time, she wasn't doing that, so that would have helped the accounting.
All right. One other question. What type do you fly?
Airbus A330.
Ooh. The red and green systems. Thank you.
Thank you.
Commissioner McMullen.
Good morning, Mr. Stone. How are you?
Morning.
Prior to you leasing the Forest Hill property to Miss Van Sant, you had hired her to try to sell the property.
Yes.
And did you have a listing agreement
Yes.
with her?
Yes.
And that was with RE/MAX?
Yes.
How long was she supposed to try to sell the property? Was there a term in that agreement?
I'm sure there probably was, but I don't recall. I don't know if you remember. Well, I'm sure you do. The market was running very poorly then, and she made some suggestions. Actually, she pointed out that there were quite a few items unfinished that, I went ahead and finished. Then she suggested staging the property to make it a little more appealing than an empty house. And I didn't have any really thoughts of how else to get rid of it. My partner left and went to do something else and kind of left me holding a house, actually, too.
At some point, did the term when she was supposed to be trying to sell the house run out?
Either it did, or we just together realized that it wasn't going to sell, and she suggested renting it out, which was a good idea to at least generate some income from it.
Okay, so after it was rented out to the first tenant, was she supposed to still be trying to find somebody to buy the house or not?
No, I don't think so. I mean, I would have been happy if somebody walked up and wanted to buy it, but we weren't actively marketing it then.
And you didn't consider her at that time to be supposed to be trying to sell the house?
Correct.
Okay. And then I think you said that first tenant stayed there for a year or two. You couldn't remember exactly
It
how
was
long.
a good. We had a good tenant to start with. Yeah.
Whenever that tenant left the property, was Miss Vincent supposed to find a buyer at that point? Or?
I think we put it on the market again for a brief period of time, but it really was no interest.
Okay. And at that point, you then rented it a second time to a new tenant?
Yes.
And once that new tenant was in there, was she supposed to be finding somebody to buy the house while that tenant was in there?
No, I didn't try to sell it while I had someone rented because it'd be difficult to show.
And then that's the tenant that left before the end of their lease term.
I think maybe that one or the following. I'm not really sure how many we had in there between there, but yes, one of them left midterm. I think the gentleman worked for Kodak or something, and he had job transfer and it just booked. I think that's the one that left.
So was there ever then another time after that where you had expected Miss Vincent to be trying to find a buyer for the property?
No, I think we tried to market it twice, and then rented it, and then when the renter left midterm, then she moved in.
There was a document that Mr. Collins showed you that was called a personal interest disclosure and consent, or something like that. And I just want to make sure I understand what your testimony was about that document. Can you say yes or no whether you ever got that document?
I'm sorry, I can't.
Okay. So is it possible that you got it and you just don't remember?
It is quite possible, yes.
Okay. Now, I haven't seen that document, but based on what we heard about it, my understanding was that it does have Miss Vincent's signature on it, but it doesn't have your signature on it.
That's correct.
Okay. The fact that it doesn't have your signature on it, does that do anything to your memory of whether you ever actually got that document?
It would obviously say I didn't sign it and return it, but I honestly do not recall seeing the document, and that's why I had to take a moment to read it to see what it said, because I didn't really know what it was about.
But it's possible that you received the document
It is possible.
and just don't remember reading it.
That's correct. I can't say one way or the other, and I apologize for being vague.
Okay. Whenever you received the letter that's been marked as Exhibit 3, which is the letter from the attorney who was representing Miss Vincent, I just want to make sure I understand this. It was after you received that letter that you then went and hired an attorney to respond to that letter. Is that correct?
I didn't know what it was to do because it looked like I was in pretty bad shape.
And you say it looked like you were in pretty bad shape. Is that because of the option to purchase agreement that was attached to the
Yes.
letter?
Yeah.
Okay. And did you have to pay that lawyer that
Yes,
you hired to
I did.
represent you? Okay. Thank you.
Ms. Taylor?
Yes, I want to ask, when you had the first tenants, first one or two tenants, do you remember any deposits being put up?
Yes, ma'am. I'm fairly sure that we had deposits.
And how were they handled?
They put in a trust account.
Through RE/MAX?
The first one, I believe, was through RE/MAX, and then after that, I had a personal trust account that I put the deposits in.
And did you have inspections when they left? Were
Yes,
they
ma'am.
inspected? So their deposits would either be
Yes, ma'am.
returned or not? All right. The other things I want to know was, how were the repairs handled on the
Well, it
homes?
worked. I'm kind of handy, so if I were in town and had the time to, and it was something within my scope of repair, I would fix it. If I was out of town, didn't have time, or it exceeded my abilities, then we would just hire someone to do it.
So let me refresh my memory here. When you got you would be, how would you know each month that you got money from the homes?
I did not track it month to month. Ms. Vincent made direct deposits into my rental account.
So if there were repairs needed, and you didn't do them, how were they handled?
She would pay them out of that account, or she would, I guess the check would go to her, and then she would use pay for the repair and then deposit the rest.
But at what time during the year or the month or whatever were you given an accounting?
Well, she would always tell me that, this had to be done or that had to be done, and this is what it cost, and, this is who did it if I didn't do it myself.
I'm talking about your deposits and your withdrawals and things. At what time of the year were you given an accounting?
The account was always available to me to review. I'm not sure I'm following your question.
All right, so you wouldn't, I guess what I'm saying is you were never given a month-to-month accounting on each property?
No, ma'am.
All right, thank you.
Was Ms. Van Sant a co-signer on the account where she was making deposits?
No, ma'am.
Okay, so was she the person writing checks out in case there was something that needed to be done, repaired?
No,
or
ma'am.
did you do that?
I'm not exactly sure. Some of the payments, I think, went to her. Like, she had the renter make the payment to her, and then she just deducted the amount and deposited the remainder. Or if it was a large repair, then I just wrote a check for it.
Thank you, Mr.
Ask one more
Yes,
question, sir.
certainly.
We have marked as Exhibit 5 the purchase and sale agreement, where you were going to sell Forest Hill property to Ms. Van Sant. At the time that you signed that agreement, did you consider Ms. Van Sant to be representing you in that transaction?
Well, I wouldn't think so. I mean, it was an agreement between Ms. Van Sant and myself to sell the house, so I figured she'd be representing herself.
Thank you.
Just a couple quick questions. So was it your testimony just now that is your belief the tenants were writing the checks to Ms. Van Sant, who would then write a check or make a deposit on the net to your account?
I believe that was what happened on the ones that needed repair. Generally speaking, I think the deposits were written to me and just made in my name.
So with the first tenant, when RE/MAX was involved, do you recall how rent was paid at that point?
I assumed it went directly to RE/MAX. I'm sorry, I really don't recall how that payment worked.
All right, just a couple more quick questions. So you gave Ms. Van Sant a reduction in rent. What do you think the market rent was? How much reduction do you think you gave her per month?
I think we rented the home for like $1,200 the first time, maybe more. I think $1,200 to $1,500 would have been appropriate for that house.
And finally, during this period of time, when you were at least, was it your belief that you were working with an individual, Ms. Van Sant, and not with a company during most of this period of time?
That's correct. It was my impression that I was working with an individual, not.
Do you have any complaints with Ms. Cudd or RE/MAX?
No, I don't.
Okay, thank you.
Question? No? Thank you. Thank you, Ms. Stone. Let's go off the record for a moment. Mr. Stone, Ms. Brown indicated before we got started this morning that you have a travel schedule. Is that you need to leave? Are you?
Sooner is better than later.
Do we? And also, was it?
They indicated they had a family emergency and had to catch a flight by.
We can hear from his wife as well.
I'm prepared to allow her to be excused if there's no other objection to catch that flight.
Okay. Did we have any other questions? Okay, let's go back on the record then, because I want to make sure you get out of here, Mr. Stone. Any other questions for Mr. Stone from council? No?
I would have just very few.
Very briefly, please, Mr. Collins.
I'm trying to get you out of here, Mr.
All right.
Stone. Be as brief as I can, Mr. Stone. I am sensitive to your time restraints. So, when she was renting, there was a question by the council or by the commission that you were dealing with an individual at that time.
That's correct.
And when she first started managing the properties, at no time did you have any agreement as far as payments were concerned.
Correct.
To manage the properties. And only subsequently did you ever tell her the reduced rent was because she was managing property?
I think it came about the other way. I think she was getting the reduced rent, and then I asked if she would make up the difference. Into the initial term, we had hoped to sell the property within like a year, and it kind of kept creeping on. And I said, well, in that you're getting the property for a reduced rent and you're taking a while getting the financing in place, would you manage the properties, as a balance?
That wasn't contemplated when you signed the lease. And then that was just an oral agreement.
Yes.
After the lease had been in effect.
Yes,
So there was no other written agreement.
that's correct.
It was just something you kind of said to her.
Yes.
But the initial payment of $1,000, this reduced rent, was that due to your personal relationship?
That and the hope that it was a very short-term deal that she, to help her get her finances in order to purchase the house.
Okay, thank you. That's all my question.
Did you have a question?
I do. I would just, 2 questions quickly that I'd like to ask.
Go, please.
Do you recall that when Remax first, we've been managing your property for years, but prior to you making the arrangement with Deanne where she was going to take over the rentals, when Remax first was doing that, and Deanne was your property manager at that time as well, do you recall how much you were being charged for each property through Remax first?
I think it was just 10%
Per month?
per month, yes.
Do you recall getting that it went through our office
Yes,
as far
I
as
got
our
a statement.
administration
Yeah.
goes?
I have
You-
a statement each year for it.
And you got statements as far as what your income was and also any expenses that were taken out during that time on a monthly basis?
Yes.
Okay. But that stopped after you started doing the business with Miss Vincent?
Yes.
Okay. I guess in lieu of Mrs. Stone not speaking, do you recall, was there when Deanne was working for you individually, how was she collecting the rent from the tenants?
I believe they were mailed to her.
Do you recall after I called you after we received the TREC notice and Miss Vincent was released from our company, when I called you and your wife, do you recall telling me at that time that she had a P.O. box in Alcoa?
Yes, I believe she did have a P.O. box in Alcoa.
And is that how she collected the rent?
I believe so.
Okay. To your knowledge, did you think any of it was coming through Remax first?
No, I knew it wasn't going to Remax.
Okay, that's all I have.
Thank you. Thank you very much, Mr. Stone. You're excused. We're off the record for a moment. I'm trying to figure out a schedule here. Miss Brown, what other witnesses do you have?
I have an additional 3 witnesses.
All right, and then
Including this one.
including Miss Van Sant and Miss Cudd. Okay, so you have 1 witness in those 2. Correct. All right. Mr. Chairman, what's the commission's pleasure? It's 11:30. I'm assuming that Ms. Van Sant's testimony will take a while. Do you want to take a short break? Do you want to take a lunch break? What do you want to push on?
Could you poll council and get their best idea of what time they need?
I'll tell you what. Let's take a short restroom break and come back in, and then we'll figure out a game plan for the rest of the day. How about that?
Fine, that'd be
All right.
perfect, thank you.
All right, if we're ready to go back, well, before we go on the record, just so all the commissioners know what we've agreed to, as well as counsel and the witnesses, we're going to hear from the executive director, and then we're going to kind of take Ms. Cudd out of turn here because we don't think her testimony is going to be lengthy. So, Ms. Cudd, after we hear from the executive director, then you'll testify. Well, I guess Ms. Brown, you were going to call her, right?
Yes, Your
All
Honor.
right, so then they will question you, and you can say whatever you wish. Commission obviously has some questions for you. Then after your testimony, we're going to take a lunch break, and then we will come back and we will hear from Ms. Brown. Will call Ms. Vincent. Okay, so we're all clear then. All right, Ms. Brown, you want to call your next witness, please?
Sir, I'd like to call Executive Director Malcolm Young.
Raise your right hand, please, sir.
You swear and affirm that the testimony you're about to give in the court
I do.
Good morning, sir.
Morning.
Could you please state your full name and business address for the record?
Malcolm Young. My address is 500 James Robertson Parkway, Davy Crockett Building, Nashville, Tennessee.
And what is your position with the Department of Commerce and Insurance?
I'm the executive director.
And is that the executive director of the Tennessee Real Estate Commission?
Yes, ma'am.
And as the executive director of the Tennessee Real Estate Commission, are you considered the custodian of the records?
Yes, ma'am. It's the records of licensing as well as complaints.
Now, are you familiar with broker Hope Cudd?
Only that there was a complaint filed.
And does broker Hope Cudd have a current and active Tennessee broker's license?
Yes, she does.
And are you familiar with affiliate broker Deanne Vincent?
Yes, ma'am.
And does Ms. Vincent have a current and active Tennessee affiliate broker license?
I'm not sure according to our records. I know that she was broker released in December of 2015, according to our records, and I'm unsure of her due affiliation.
Now, Mr. Young, in order to get a affiliate broker license, is there a test involved?
Yes, ma'am.
And what is that test?
It's actually a test administered by a testing service called PSI, and you go through a series of questions for a state portion, a state of Tennessee portion for the exam, and also for the national portion of the exam. It's approximately 140 questions.
And in order to become a broker, is there also a test involved?
Yes, ma'am.
So that would mean that a broker would have to take 2 exams, is that correct?
Yes, ma'am.
Now, would you say, in your opinion, the standard of conduct for a broker is greater than for an affiliate broker?
Well, they do have if it's a principal broker, is that the question you're asking?
Yes, I'm sorry.
If it's a principal broker, they do have broker responsibilities of oversight over their affiliate brokers that would be under them.
Now, are you familiar with the complaint that was filed against Hope Cudd and Deanne Vincent?
I am aware that a complaint was filed by Mr. Stone.
And when a complaint is submitted into your office, what action does the board office take?
Actually, what takes place is when a complaint reaches our office, we review the complaint as far as the validity, as far as the complaint processor. It is then forwarded to the named respondent for a response. Once that response has been reviewed, or once it's received, it is then sent to our legal department, and the legal department does an investigation. And after it's investigated, and if it seems of a merit, well, all complaints at that point are then forwarded to the commission for them to make decisions as far as the disposition of the complaint.
Your Honor, may I approach the witness? Mr. Young, do you recognize this document?
I actually recognize, starting on page 2 with the date filed 10/16/14.
And what is this document?
This is actually an official complaint form.
And was this the complaint received by the Real Estate Commission office in this matter?
Yes, ma'am.
And is this a true and correct copy of the complaint and the attachments?
Yes, ma'am.
Now, can you just briefly tell us what this complaint was about?
Actually, yes, I can. It's a complaint in which there was a concern by Mr. Stone as far as
Ms. Brown, I don't think we need to have Mr. Young tell us what the complaint was about, because Mr. Stone has been here for 2 hours and he
That's
told
fine.
us what it is, so let's move on.
I'll withdraw it. So following the receipt of the complaint by the TREC office, there was a complaint opened against both Hope Cudd and Deanne Vincent, is that correct?
well, I would note on the complaint that the second respondent was Leslie Dunham.
Okay.
And
please
in
explain?
it actually, at the time that I reviewed these, it seems that Ms. Dunham was the principal broker after the actual time frame of the facts of this case were actually known. That Hope Cudd was the principal broker at the time of the events of the complaint.
So the principal broker at the time of the events that occurred in the complaint was actually Hope Cudd?
Yes, ma'am.
So this was an error?
It wasn't an error because I believe Mr. Stone was probably doing the appropriate thing, filing the complaint of the actual principal broker of record at the time of October 16, 2014.
Now, following the opening of the complaints, are they sent to the respondents Hope Cudd and Deanne Vincent?
They were probably, according to our paperwork, they were sent to Ms. Dunham and Ms. Vincent.
And after it was corrected and realized that the principal broker was actually Hope Cudd, was the complaint sent to Hope Cudd?
I know in the paperwork that I've reviewed, there was a response from Hope Cudd.
Did you receive a response from Deanne Vincent?
Yes, ma'am.
Your Honor, if I may approach.
I neglected, Ms. Brown, did you intend to put this into as the next exhibit?
Yes, Your Honor, without
I
objection.
have an objection with respect to, number one, the complaint in and of itself, with the exception of the first page, would be cumulative, as there are exhibits that have already been entered, with the exception of the last 3 pages, which I believe Your Honor has previously ruled on.
Your Honor, this is the official record, and it is a public document.
Doesn't necessarily mean
Official complaint file that was filed with the TREC Board office.
Objection. I'll allow the entire document in as the complaint that Mr. Stone filed that initiated this action. This will be exhibit number 6. Do we have copies passed to the commission on the complaint?
Yes, Your Honor.
All right. All right, Ms. Brown, I believe you had another document that you were preparing to hand Mr. Young. Go ahead, Ms. Brown.
Mr. Young, do you recognize this document?
I did see it in the file.
Now, is this the first response you received from Ms. Vincent?
I would not have that knowledge.
Do you know if there were subsequent responses filed by Ms. Vincent with your office?
I have seen other pieces of a response from Ms. Vincent.
Your Honor, if I may approach.
Are you moving this into evidence?
Not yet.
Okay, yes.
Mr. Young, do you recognize this document?
Yes, ma'am.
Is this a subsequent response received from Ms. Vincent?
It is.
Are you aware of any other responses?
I have seen other responses.
Your Honor, if I may approach.
What's your plan here, Ms.
I would like to enter these collectively as one exhibit because they are all the responses that were filed by the respondent, Deanne Vincent, in this matter in the official complaint file.
If I could be heard, I certainly have no objection with the documents in which he can identify, but as far as the first document, I believe the proper foundation was not laid.
Your Honor, if I may clarify.
Well, let me ask you a question, Ms. Brown. Is there anything, first of all, the first document you showed me, I'm not going to allow that. There's nothing in there that's probative. It's just correspondence between an attorney and the office that really doesn't say anything. So we won't. That's not coming in. This other information here that has a rather lengthy statement from Miss Vincent. Is there anything? She's going to testify. I have no problem with it coming in, but what's the point of this? Are you alleging that she's saying something in here that she's not going to testify to today?
Well, I don't know that yet, but this is just part of the official complaint file with the board office, and I'd like this to be entered as in the exhibit. I mean, she filed this with our office in response. She has a statutory duty to respond to us. So she filed all these documents with us at separate time intervals, and
All right. Okay, go ahead and,
Your Honor, I would just state that I believe the appropriate time to enter these documents would be prior inconsistent statements, if those are inconsistencies, and be used to impeach the witness and testimony of Ms. Van Zant. I don't believe that they're appropriate now. However, with respect to the purchase and sale agreement that's contained in this second document or page of documents, we would stipulate that that was the purchase agreement, because I believe there was also a question from one of the commissioners, I believe it's Commissioner Hills, that did we have all the pages? Clearly I did not, but I think this is a full record of the purchase and sale agreement.
but what's the other document that you have, Ms. Brown?
it's an additional document that you filed with our office. I'm just trying to make an accurate official filing of what she responded to our office, so that we have all the documents that she filed with us.
Okay, go ahead and show her the third document, or the third collection. Wait a minute, Ms. Brown, this last document, response from Mr. Stone.
Following the receipt of all the responses from Ms. Vincent, were these forwarded to the complainant, Mr. David Stone?
I would have no knowledge, but I would assume so.
Now, when you say you would have no knowledge, is that because you were not employed by the department at that time?
That is correct.
But is that the proper protocol
That is the proper protocol.
and is that the protocol that you follow at this time?
Yes, that is the policy.
Okay, and following sending out the complaint and receiving a response, the response is sent to the complainant. Typically, does the complainant respond?
Brown, what's the relevance of this?
I'm just trying to establish the official complaint file so that the board has all the documents that were filed in this matter.
We're way off the track here. This is irrelevant. Forwarding this information to Mr. Stone and what the procedures are, this is not relevant to this proceeding. Mr. Stone was here. We could have asked him all these questions. We need to move on to something relevant. I am going to allow the information in that came in the December the 15th packet, because that does have a rather lengthy response from Ms. Vincent, but so far nothing else that I've seen is relevant here. So what else do you have?
Well, Mr. Stone did file a response as well, and that's also relevant.
But we've heard him. He testified all morning, and there's nothing in the response that contradicts what he said. So
I will move on.
thank you.
If we could enter those as a collective exhibit, Your Honor,
All right,
please.
this will be exhibit number. Which one?
I believe it's 7, Your Honor.
7. All right, it'll be exhibit number 7, and
just
this.
for clarification, this is just the December 15th.
This is the document, the collection of documents that is entitled "Additional Information Transmittal to Kelly Gamber from Amy Mayfield, date December 15, 2014."
Thank you.
Go ahead, Ms. Brown.
Now, Mr. Young, do you have a business duty to maintain these documents with the official books and records of the TREC office?
Yes.
Now, have you reviewed all these documents?
The ones you've given me this morning?
Yes.
Yes, upon your receipt of them from you.
Is it your opinion that Hope Cut is that Deanne Vincent is in violation of the laws of the Tennessee Real Estate Commission?
Your Honor, I'm going to object to him giving his
Sustained.
opinion.
Move on, Ms. Brown. The question, Mr. Young's opinion as to whether or not these people have violated the law is completely irrelevant, and it's an inappropriate question. That's a decision that the commission's going to make. Go ahead.
Your Honor, I tender the witness.
Hello.
Good morning. Actually, it's afternoon now.
I guess so. We'll try to get out of here for lunch as soon as possible, so be very brief. I know since you've taken over, there's been some trouble getting records and finding everything, because it's my understanding you came into the commission when there was a little bit of a disarray with some records. Is that an accurate statement?
I would say that the records for the complaints were fairly accurate.
Okay, well, I apologize for my mischaracterization. My question then is, with respect to Ms. Van Zandt, do you know her license number?
Not off the top of my head.
Is it part of the official file or record?
Yes.
Okay. And is there no way for you to be able to ascertain whether another TREC 1 form was submitted that is corresponding to her license number?
I do know that there was a transfer form that's part of the record in which she was broker released.
If there were any subsequent TREC 1 forms filed, would they be a part of the official file?
They should be.
Is that official file here today?
Yes.
Is there any way you could take a moment to review it to see if there is any subsequent TREC 1 forms filed so that we may ascertain more clearly her current status as an agent?
That would be something that, legal has the file, but I could tell you that yesterday I pulled the documentation from the core files, and if you're asking if I know what firm she's affiliated with, the last record that we have in our files is a December 2015 in which she was broker released.
So there are, and I'm just trying to be clear, is there a difference in the whole file and a core file?
Well, it's on our computer system.
Right. So what you're basing your testimony here today as far as her status is what was when I went to verifiedtn.gov, that's basically what you're testifying about.
Yes.
Okay. So you haven't done any actual, and I'm not faulting you for this, I'm just trying to make purposes of the record, any actual inquiry into the actual file as to whether there were any TREC 1 forms subsequently filed.
Actually, that may not be part of the complaint file.
As part of the complaint file, do y'all not automatically check the licensee file?
I have verified it.
But it's your testimony here today that you don't know if any subsequent TREC 1 forms have been filed.
No, sir.
Your Honor, to be quite honest, I anticipated the entire file being here. Therefore, for my next anticipated exhibit, I would not have copies available for everyone, but I would like to proceed or reserve the right to recall him after the lunch break where I can make those copies.
All right, why don't we, let's just do that.
Thank
Because
you.
Mr. Young's not going anywhere. He'll be here.
Sure. That being the case, that would conclude my questions for now.
All right. At this time, does the commission, I'm sorry, Ms. Brown, anything at this point?
No, Your Honor.
Ms. Cudd, do you have any questions for? All right, go ahead, Ms. Cudd.
Young, it was a pleasure meeting you this morning.
Thank you.
Were you
Same to
the-
you.
Thank you. Were you the director at the time the complaint was made by the Stones?
No, ma'am.
Was your predecessor, Eve Maxwell, to your knowledge, she was?
She was the
Director?
executive director.
Okay. Did you, by chance, get to watch the video where the commission had ruled on my failure to supervise Deanne Vincent
No, ma'am.
before, while Eve Maxwell was there?
No, ma'am.
Okay. So no part of it where they dismissed Leslie Dunham, they did dismiss her as failure to supervise on that same hearing.
I have not reviewed the hearing.
Were you able to read anything about the hearing, or?
No, ma'am.
Okay. That's all I have.
Questions for Mr. Young?
Mr. Young, did this Leslie Dunham, apparently she was a subsequent broker that was, I mean, the state must have had some evidence. Or have
She
some-
was actually on the original complaint named by Mr. Stone. Ms. Van Zant and Ms. Dunham were the two named parties on the complaint.
It just seems to me that Ms. Dunham might have been a subsequent broker to Ms. Cudd, but the state has no record of that. Is that your testimony?
Yes.
Thank you. Mr. Bloom.
Mr. Young, when you reviewed the file, there's no indication that Ms. Van Sant is now located with any other broker in Tennessee?
The last record that I have is that I believe it's AB. I don't have my records in front of me, but she was broker released, I believe, from ABC Property Management.
Who's ABC Property Management?
I'm assuming a property management company and where she's located.
I thought she was broker released from Remax.
Those are the latest records that I have as of December 15th, 2015.
But as of yesterday, when you reviewed the file?
That's correct.
The questions? All right, Your Honor. Thank you.
And Mr. Young, if you would please, I think you can see which way the wind's blowing here. If during our recess, if you could go and access the whatever files you have and have them down here when we reconvene. Thank you, sir.
Thank you.
May I ask Mr. Young one more question?
Yes.
So if I'm understanding your question right, you're saying you don't have any records with TREC that Ms. Vincent was released from my company, Remax First, on October 10th, 2014.
Yes, I do have those records. I have a full history of the broker release in history of both you and Ms. Descent.
All right, can I submit this as an exhibit?
What is that?
It's the copy of our release from Remax First from Ms. Vincent. I have copies for everyone.
I'll tell you what, why don't you wait and we'll put that in during your testimony. How about that? All right, do we have anything else then for Mr. Young? If not, thank you, sir. Let's go off the record for a moment. Thank you, Mr. Young. Mr. Chairman, with the agreement of the commission, I'm going to suggest we modify our schedule a little bit. Let's go ahead and take a break now, and then I think we need to finish up with Mr. Young when we come back. So I've got 10 after. Can we all be back at 1 o'clock to proceed? So fair enough, Mr. Chairman?
Work.
All right, and Mr. Young, then if you could have whatever document you have, and then we will reconvene with you. Okay? Thank you, Chairman. If we are ready to go back on the record at this time, I believe we are going to reconvene with Mr. Young, and I don't know, Ms. Brown, do you have questions for him about some documents, or did you want to let him respond to the commission? What?
I have nothing further for Mr. Young.
All right, Mr. Collins, did you have any questions for him?
Yes.
Or Ms. Chuck? I'm sorry.
I'm married into it, but he's a good man.
I know. I've mangled your name all day long today. Maybe I'll just call you Hope. All right. So, Mr. Collins, did you have questions for Mr. Young?
Yes, Your Honor.
All right. We'll start with you, and then.
Thank you, Your Honor. May I approach?
Yes.
Given proper time, I have to. Okay, Mr. Young,
Yes, sir.
can you identify the 4 documents that I've handed to you?
The first document is the release of Miss Vincent by Leslie Dunham of 10/10/2014.
Okay, and what is this? When was that approved and or received?
It was received on October the 14th, 2012.
And what is the next document?
The next document that I have is, again, a transfer. And it is also a Miss Vincent from Remax First. And I can't actually make out the information on it, but I know according to our records at one point she went to Asset Realty.
Okay, now, have you had a chance to review the file for Ms. Van Zandt?
Are you talking about the licensee file?
According to your records, do these first 2 TREC 1 forms that I'm talking about match your records?
Yes, sir.
Okay. Is that a true and accurate reflection of what is also in your records?
Yes, sir.
Your Honor, with regard to the first 2 documents that have been discussed, I would like to move to make these collective Exhibit 8.
All right. Did you have copies for the commission, Mr. Collins? All right. Thank you.
2.
Thank you.
Go ahead, Ms. Collins.
Now, let's look at the next two documents in front of you.
Okay, the next document I'm looking at is dated September the 29th, 2015, in which it shows that Deanna Vincent, she left Asset Realty, and there's a commentary on the form that says, "Don't know, agent took license when she left, can't return to you. Thank you very much."
Now, the second document says what?
This is dated October the 1st, and it shows that Miss Vincent, she transferred from Asset Realty to the new licensee name is ABC Professional Management.
This is a true and accurate reflection of the records which you see.
Yes.
Your Honor, I'd like to make this the collective exhibit.
Number 9, all right.
A and B.
Okay. Be entered into the record as collective 9.
Now, going back to the one that's already been entered and passed to the commissioners, collective exhibit A and B, does it appear that these are two forms? Well, does it appear that both of these forms were trying to accomplish the same goal, just one of them wasn't filled out correctly?
Well, we definitely have the record in which she transferred to ABC Professional Management.
Okay, but with respect to the first two documents, the ones that are from Remax First to Asset Realty,
Right.
okay, in front of you.
Yeah, those track our records.
But looking at these forms, the one that has, and I don't know if you can see it, the one that does, I believe that would be 8A, doesn't have lines 3 and 4, or 4A and 4B filled out. Is that correct?
That's correct. It has a commentary of what happened to the license.
Look at the ones from Vincent to Remax.
It's
Remax First ones.
It's completed.
Okay. Going to Asset Realty.
Correct.
And those two have the same date, 10/10/2014, correct?
Right. Well, this one, yes, it was approved on October 16th, 2014.
Okay. Now, going to the second set of documents that has Deanne, that have two separate documents that have Deanne Vincent going to Asset Realty and Deanne Vincent going from Asset Realty to ABC Professional Management. You have those in front of you, is that correct?
I'm looking at them. Yes, sir. I'm looking at them side by side.
Okay. Now, does this appear again to be two forms in which one person completely filled it out and another person did not completely fill it out?
It does.
Okay. So my question again is, do these appear to be someone trying to make sure that the TREC 1 form was correct? Because the first person did not. Okay.
The one I see on October the 1st, 2015 was completed correctly.
Okay. Now, according to your records, Ms. Vincent is currently with ABC Realty Professional Management. Is that correct?
According to my records, as of 12/07/2015, she is currently under the status of broker release from ABC Professional Management.
Now, is there an explanation as to, provided there's a TREC 1 form in front of the commission and in front of yourself, do you have an explanation to why she would still have that status if this TREC 1 form has been accepted?
Yes, sir, I do.
What is that?
It is actually because payment was not made for the transfer of the license.
And what is that payment fee?
That payment fee is $25.
Was Ms. Vincent notified of this?
Yes, sir.
Do you have record of when she was notified of it?
She was notified on March the 8th, 2016.
Now, I just want to make this clear for purposes of the record. The TREC 1 form that is completely filled out that removes Vincent from Asset Realty to ABC Professional Management, what date was it accepted and filed?
It was in October
Of what year?
2015.
And when was she notified that a $25 payment needed to be made?
With my records, it was March the 8th,
Of what year?
2016.
Thank you. No further questions.
Do you have anything for Mr. Young on this topic?
I have nothing further.
No, I'm sorry, Ms. Cudd.
Oh, I'm sorry. I apologize.
No?
No.
Okay. Anything, Ms. Brown? No? Yes? Okay, go ahead.
Mr. Young, you indicated that according to your records, Ms. Vincent was notified that there was a fee due on March 8th, 2016. Are you aware if she was notified prior to that?
I do not have records that indicate that.
Is it likely that she was? Meaning, what is the policy of the office when a application comes in without a fee?
I would, basically, the policy is that they would be notified.
How long after receipt of the application?
I would, up to 4 weeks.
Now, according to your current records as of today, has that fee been paid?
No, ma'am, it has not been paid. There was no response to the email of March the 8th.
Thank you.
All right. Now, members of the commission, questions for Mr. Young?
Yes, Mr. Young, if a person filled out a TREC 1 form, would they have to be notified? On the left-hand side, does it not say that you are to pay $25 when you fill out this form?
Yes, sir, it does.
And in most cases, when you receive the TREC 1s, is there not a $25 fee adjoining that application?
Yes, sir, there is.
Thank you.
Ms. Hills?
Mr. Young, if a broker wants to broker release and they have no idea where the licensee is going next, can they fill out half of a TREC 1 form and go ahead and send it in?
Yes, ma'am, that is the practice.
Mr. Mullen?
Was Miss Vincent, just to clarify, was Miss Vincent transferred from RE/MAX First to Asset Realty Management in October of 2014?
Yes.
Okay. And TREC's records show that she's currently with which firm?
It shows what we have currently is that she was broker released from ABC Professional Management due to the fact of non-payment.
And that was in December of 2015?
Those are the latest records I have of her.
In December of 2015, she was broker released by ABC Professional Management?
Well, that's the records I have.
And so in October of 2015, she transferred from Asset Realty to ABC Professional Management?
That's correct.
Thank you.
Commissioners? So, Mr. Young, I'm trying to put these 4 pages together chronologically. So, what I have labeled as Exhibit 8B, which may or not, maybe it's 8A, but it's where Ms. Vincent was broker released from RE/MAX First. Now, how do you refer to that document? Is that 8A or 8B?
I don't know. I have the TREC. I actually have the file from TREC. I would refer to the judge on that, the keeper of the documents.
Perhaps I can be some
Thank you, Mr. Conway.
The one that has just Deanne's name and then RE/MAX Elite would be.
All right, why don't we do all this together so we're clear. So we're talking about the document that just has Deanne Elizabeth Vincent and then RE/MAX First and then lines 3, 4 and 4B are blank. That is 8A.
Subsequent document that is completely filled out would
Is
be
8B.
B,
And
and the
then-
same would be true for 9 and.
All right, and then on 9, on Exhibit 9, the document that on lines 3 and 4 read, "Don't know, agent took license when she left." That will be 9A, and the subsequent document that is completely filled out will be 9B. Now,
Okay, thank you.
Mr.
So
Chairman.
on 8A, then when Ms. Vincent was released from Remax First, that was recorded in the Real Estate Commission's records, correct?
That is correct.
And then subsequent to that, what I have is Exhibit 8B, which would be 2 days later. It looks like she's been affiliated with Asset Realty Management. And
That is correct.
And it's your testimony that that never got posted because you never got the $25.
Well, she was never posted to ABC Professional Management.
Well, I got to get there first.
Okay.
She had to get there through Asset Realty, apparently.
Correct.
So was she ever, according to TREC records, licensed with Asset Realty Management?
Yes.
Did you collect the $25 from her on that
Yes.
transfer?
Yes, sir.
Okay, and then less than a year later, Asset Realty releases her, which is Exhibit 9A.
Correct.
And then 9B, she affiliates with ABC, according to this TREC 1.
Correct.
But it's your testimony, you never got the $25 to make that official.
That is correct.
And is there a requirement of the staff to notify people when they don't send $25 in?
Yes, there would be.
Or is it the responsibility of the licensee to complete the application and send it in?
Well, with all the fees that we collect, it is the responsibility of the licensee to remit the fees.
Your testimony that the Real Estate Commission or the Department of Revenue or someone has never received that $25.
That is correct.
Okay, I just want to make sure I got it clear now. Thank you.
anything else for Mr. Young from the commission? No? Thank you very much, Mr. Young.
You're welcome.
Take a seat. I'm sorry, Ms. Cudd, did you have another question for him? All right. Just go ahead from where you are, Ms. Cudd.
On the first one here, I'm familiar with this one where Ms. Vincent was released from our company on October 10th
Right,
by the then principal broker, Leslie Dunham.
right.
The second one here, there seems to be a conflict. It says transfer to new firm. How can it be transferring from Remax First to Asset Realty Management when there was no transfer, it was released? In a transfer, you should have a, you should have a signature of the releasing principal broker, and it just says see attached. What is that in relevance to?
Well, I have a record of a broker released of 10/14/2014 by Leslie Dunham, and then I have a transfer of 10/16 to Asset Realty Management to principal broker Michael Cohen.
How can you have a release and a transfer at the same time?
Well, it's 2 days later.
But we didn't, who would be able to transfer from Remax First?
Well, you broker released, and then she went to a new broker.
Okay, so then that's fine. Okay, that was my only question.
Okay.
Thank you. Thank you, Mr. Young.
Thank you.
Can I ask? Is it too late? Okay.
Go ahead, Ms. Franks.
So now I'm confused about the same thing she's asking you. So if she was not released on 8B by Remax First, How could that happen?
Was released.
She was released, but then she transferred from the same company she was released from 2 days before. I'm wondering, it looks like all of this was filled out by the same person, but then there's no releasing principal broker's signature, and it says see attached. So what was attached?
I actually have the form of October the 14th has a signature of Leslie Dunham.
Right.
And that's October the 14th. October the 16th, the then Asset Realty picked her up.
But it shows that she was transferred from RE/MAX when, in fact, she was released. So
Right.
someone has written on this form and then didn't provide the signature of the releasing broker.
I have a signature, the releasing broker, of Leslie Dunham on the
I'm looking at 8B, the second one. When she was transferred from RE/MAX to Asset Realty.
and maybe the form was incorrectly filled out and filed.
Can I ask a question? Would you normally get the signature of the broker who broker released an individual on a transfer on a subsequent movement to another company? Why would you get the signature of that person who already broker released him?
I don't know.
I don't think you would.
Ms. Hills?
Am I correct that a licensee has 10 days to locate a new broker once they've been released?
That is correct.
Thank you.
Okay, we can ask other people about that. Okay.
All right, Your Honor.
All right, Mr. Young, last time.
One more time.
Take your seat.
Sorry.
That's all right. That's all right, Ms. Franks. You might want to run upstairs, Mr. Young, so we can't find you if anybody else. Okay. Ms. Brown, do you have another witness? Now, as we beforehand, we were going to call Ms. Cudd out because we thought we were going to get her in, get it done before lunch, but that didn't happen. So I'll let you, however you planned on proceeding with your case, if you want to call her first, or if you want to call Ms. Visant first, whichever ones you want to do.
I can go with the plan and just call Ms. Cudd.
All right, Ms. Cudd, would you take a seat, please? Already under oath,
Ooh, it's
so.
hot up here.
Oh, I'm sorry, okay. Good afternoon, Ms. Cudd.
Afternoon.
Could you please state your full name and business address for the record?
Hope Cherise Cudd, 648 Abbey Way, Friendsville, Tennessee.
And what is your occupation?
I'm a realtor, broker associate,
Where do you work?
RE/MAX First.
And at the time in question, were you a principal broker with RE/MAX First?
Yes, ma'am.
And what period of time were you the principal broker there?
August 2008 through June 30th, 2014.
And your job duties as principal broker, did they involve supervising affiliate brokers?
Absolutely.
And what does that entail?
Well, it entails policies and procedures and systems in place that we had set for all of our agents, a very in-depth policy and procedure manual, training every Thursday, one-on-one meetings. I had an open-door policy as a principal broker that, if they needed to see me, they could come in. I was probably at the office during the early days, probably about 60 hours a week. They could always reach me by phone if they ever had any questions. Like I said, a lot of training was involved.
Were you in the office Monday through Friday, Monday through Saturday? What were your office hours usually?
Really Monday through Friday. Saturdays, probably the first 3 or 4 years, I was there till 1 o'clock. Never on Sundays, but I was always available by phone.
And did you also list and sell homes at that time?
Only for, real close personal friends or family, but no, not very often. I was a non-competing broker.
And at that time, did you have an assistant or secretary to help you with various office functions as the principal broker?
I wouldn't say I personally did. We had an administrator.
An administrative staff person to help you?
We do have administrative staff, yes.
And did RE/MAX first provide you with a written job description as the principal broker?
Yes, ma'am.
And were those duties specifically outlined in that job description?
Yes, ma'am.
And could you please tell us what some of those job duties were?
Again, supervising as far as the agents go, being able to be there for their questions, any new files that they brought in. My admin would go over to make sure all the forms were there, and then I personally went over all of the files to see if everything was in proper order, I's dotted, T's crossed, and signatures in place.
Did that involve reviewing all the documents?
Yes, ma'am.
And approximately how many affiliate brokers did you supervise?
23.
Now, you understand that the notice of hearing and charges here is stating that you have violated the law because you failed to adequately supervise your affiliate brokers. Is that correct?
What was the question again?
You understand that in the notice of hearing and charges, the violation against you is for failure to adequately supervise your affiliate broker, Deanne Vincent?
Yes, I do realize that's the charge.
Okay, and what is your understanding of that, failing to adequately supervise an affiliate broker? What does that mean to you?
Well, what does that mean to me? It means that if I was aware of any of the paperwork or the things that had been put in front of me and approved them, then I would say that you failed to supervise.
Now, earlier we heard testimony from David Stone that he had used RE/MAX first for much of his property management. Is that correct?
That is correct.
And did you review those documents?
Yes, ma'am.
And did you review the documents involving Deanne Vincent?
Where she was managing the properties on her own?
She was managing the documents for David Stone through RE/MAX?
Those are, again, two different items, so I'm not sure what you're asking for me on. If when RE/MAX first was managing it and she was the property manager, yes, we did have the forms and everything was fine there. That's not what, to my knowledge, is what's in question here on this hearing.
And you were supervising her at that time?
Before, I was supervising her before she decided to go out and do the business for herself, yes.
Now, in your office at that time, was there a property management department or section?
Yes.
And were you in charge of that department?
Legally, I was as the principal broker, yes.
And did you review all the leases?
We had a managing broker there that reviewed those as far as that goes, and if he had any questions, he brought them to me.
And what about the accounting, the rents and the accounts receivable?
We have an accountant, bookkeeper that does all that.
And were escrow accounts set up as well?
Yes.
And
For security deposits.
And do you recall how many properties RE/MAX managed prior to Ms. Vincent getting involved?
No.
Now, is it possible that once a affiliate broker begins a property management relationship for, say, a 6-month period, is it common practice in your office that that affiliate broker will start managing a property without the involvement of RE/MAX first?
I don't think I understand the question. Can you rephrase it?
In a situation where RE/MAX first was involved in the property management of a rental with an affiliate broker in your office, subsequently is it likely or common practice for that affiliate broker to manage that property on their own without the involvement of RE/MAX First?
Absolutely not.
So was RE/MAX First ever involved in the property management of that 1339 Forest Hill property?
The only time that RE/MAX First was involved with that was when it was initially listed and subsequently expired, and we put it in there as far as listed goes. Once it was expired, we never received any other records regarding the property.
And what about the purchase and sale agreement between Deanne Vincent and David Stone for that property?
No, our policy is for all files to be turned in, as is the law, and for us to go over the files on it. We've never seen that contract before.
And that was not on a RE/MAX First form?
No, ma'am. It would appear that all of our forms always had RE/MAX First with the address and phone number at the top. And on all of those forms that we've been presented today, it would appear that it's not there.
Now, to the best of your recollection, do you recall approximately how many times a week you would see Ms. Vincent in the office?
Probably 5 times, 5 days a week.
And did you review any of her work or her schedule, her hours? What type of supervision did you exercise over her?
I exercise, I think, what is considered normal supervision for them to come to me and have an open door policy, and had lunch probably, one-on-ones every other month. I think had good interaction as far as that aspect if it goes, but outside the office, I had no knowledge as far as what Miss Vincent does after hours or.
Did you have any office policy manual?
Yes, ma'am.
And did that address the supervision of affiliates at all?
Yes, ma'am.
And do you recall what it said?
Well, our policy and procedure manual is probably about 56 pages where it addresses that. But it states that, I have a copy of paper there that I'd be happy to share with you that addresses specifically that, but I have it on my desk there.
Your Honor, if you would allow her to refer to her, if you would like to grab that.
Brown or?
Sure, if you have enough copies, that would be great.
All
Is
right,
it
why
quite
don't we go
lengthy?
ahead and mark this then? Have you seen this document, Mr. Collins? Would you show that to Mr. Collins? And any objection, Mr. Collins?
Your Honor, for the purposes of the record, this document is titled Office Policy and Procedure Manual with some stars and circles and asterisks on it. And, excuse me, it's a 2-page document with a signature page and section E miscellaneous starting at page 22. I don't know that this is a complete record, but as far as
just answering her question.
Well, I don't think
hang on, Ms. Scott.
as far as substance, I have no objection to the substance of this 2-page. I just.
All right. I'll allow this to come in, and Ms. Cudd can explain to us what this document is, and obviously it came from a larger publication. She can explain that to us.
Your Honor, if it doesn't address supervision of affiliates.
Does it address supervision of affiliates, Ms. Cudd? That was the question Ms. Brown asked you.
Yes, I believe it does.
Okay, that's fine. We'll mark.
I mean, I could be wrong, but I believe it does.
Okay, fine. This will be exhibit number 10. Would you pass a copy of that to us, please? One for the record and copies for the board and the commissioners. No, go ahead. I don't need them. Now, Ms. Brown, ask your question again, please.
Ms. Cudd, you said that your office does have a office policy on supervision of affiliates, and you are providing this one page. Where does it address the supervision of affiliates?
Well, specifically, talking about that all problems related to real estate shall be reported to the broker.
But it doesn't discuss how you supervise your affiliates or what needs to be involved or entailed in their supervision. Is there more details within your office policy manual?
There is. I didn't bring the whole 56 pages.
Do you recall what it says?
It basically follows the law as far as what is expected of a principal broker in supervision, which is to be available for agents at all times and to be there in the office, which I was, to be able to answer any of their questions, to be able to, I think I went above and beyond in looking at all their files to make sure that their I's were dotted and T's were crossed, and to help them in any of their endeavors day to day in the business. But probably the biggest job that I did on that was training, and that involved every week Thursday mornings at 9 to 10:30.
Now, when you received the complaint from the Real Estate Commission office, did you provide a response? Was that a written response? Your Honor, if I may approach.
Right.
Cut, if you turn to the second page of this document. Is this the response that you provided?
Yes, ma'am.
And is that your signature on the third page?
Yes, ma'am.
And what did you respond to the board concerning the complaint?
You want me to read it?
Just briefly summarize what you stated.
Summarize it, yes, please, ma'am. Ms. Scott.
Basically, the first and foremost, I believe that Ms. Vincent acted outside the scope of my duties to supervise, and that I should not be held responsible for the actions that she is alleged to have done. The complainants, Mr. and Mrs. Stone, will attest, I think, as you saw earlier from Mr. Stone, that I had no knowledge of any of these actions. It also states that as to when I became aware of the complaint or any of the issues regarding this was after I received the grievance complaint from the car board, which Mr. Stone had made. And then I believe it was a few days later that I received a TREC 1, or Leslie Dunham received the TREC 1, which she shared with me. And at that time, we had read through it, and again, we're not aware of anything. We asked Ms. Vincent to come in and explain it to us. Her response at that time was that it was a personal matter and had nothing to do with RE/MAX First. Ms. Leslie Dunham, who was the acting broker at that time, did not agree with that, and she was released from the company and asked to her personal belongings were boxed up for her. And again, the only thing I knew about 1339 Forest Hill Road was that she was going to rent. She told me that she was renting from there, and after it had expired and she hadn't sold it, And I had advised her as her broker then to make sure she did a TREC 1 form to change the address, and there was no charge for that.
Stated that you had no knowledge of what she was doing, and you had confronted her about the rental.
Excuse me, Ms. Brown, did you want to move this into evidence?
Oh, yes, I'm
All right,
sorry.
so this will be exhibit.
Excuse me. Again, with respect to the response filed by Ms. Cudd, I think it ends where Ms. Mayfield sent the complaint against Hope Cudd in an email, but anything after that would be already admitted exhibits and therefore would be cumulative and should not be admitted as part of this exhibit.
That's fine, Your Honor. This was the entire response that Ms. Cudd filed.
Well, I do see a few extra items. There's also an email from Ms. Stone in here.
That was something she did file with her response.
Your Honor, I guess my problem with this is the state released Ms. Stone, and now they seek to introduce statements from her without the opportunity for my client to be able to cross-examine that statement.
I'm not.
I agree with that, Mr. Collins. Well, here's what we're going to do. I understand we had this conversation earlier about all items that have been filed with the commission office, and some of the items I did not allow into evidence. So what I think the best thing, and plus I am a little concerned about this rather lengthy email that is to Ms. Cudd from Ms. Stone. So I think that the best thing for us to do is to simply redact. I will allow into evidence the first 3 pages of this document, which is the cover sheet, and then the letter from Ms. Cudd to Hope Mayfield, to Amy Mayfield, and after that, the rest of the items won't come in because either A, they're duplicate of what we've already received, or B, we have an article in here from a publication. I'm not sure what that is. And then the email from Ms. Stone. I think if we wanted to get that in, we should have had Ms. Stone's, who was here and was prepared. So, is this that one? Okay. Oops, I'm sorry. Why don't we take a moment to, before you, I'm sorry, Ms. Brown, did you have further questions for Ms. Cudd?
Yeah, just a few more.
All right, why don't we take a moment to allow the commissioners to read Ms. Cudd's response here, and then we'll proceed. Start with you. That's a clean copy for you.
Sorry, Your Honor, would that be Exhibit 10?
Go ahead, Ms. Brown.
Ms. Cudd, earlier you stated that you had no knowledge of what Ms. Vincent was doing. However, you were her principal broker. How is it possible that you were supervising her and you were her principal broker and you had no knowledge of what she was doing?
Well, because I don't believe that it's possible for a principal broker to follow someone around to see if they open up a P.O. box on their own, or if they don't share information with you, if they use contracts that are outside of our office and don't turn the contracts into us, which they were supposed to, if they collect money from tenants and tell the tenants to pay them directly. How am I supposed to know about any of those actions?
You also said that you had learned that she was renting the home from these Stones, and that you and the principal broker at the time, Leslie Dunham, had confronted her and advised her to file the TREC 1 form for address change. Is that correct?
No, Ms. Dunham was not, the principal broker was not part of our company at the time. I don't remember exactly when it was. I know that the property was listed and it had expired. At that point, I thought we were done with the Stones in regards to that property. She had told me that she was moving, and I said, okay, please make sure that you do a TREC 1 form with your new address. It's free to do that, and gave her a blank TREC 1 to turn in.
Did you follow up with her about that form?
No, I think that when you look online with the TREC, it doesn't show the address of, if you look up the licensee, it doesn't show the address.
Follow up with her, with Ms. Vincent?
Don't recall.
Thank you, Your Honor. I have nothing further. I tender the witness.
Scott, I have a few questions for you. I'm going to be as brief as possible, okay? The only questions I have are in relation to the setup of the company in which you work for, okay? You said that there were two arms of that company, is that correct? A sales and a rental?
Correct.
Okay. Now, were they all under the RE/MAX First umbrella?
Not always, but eventually they were.
Okay. Prior to eventually, when did eventually happen? What date?
I can't recall the exact date on that.
Okay. And at some point, are you the owner of RE/MAX First or just the principal broker?
I was the principal broker. I'm not the owner.
Okay. Now, do you know what the makeup of those companies prior to being under the same umbrella was?
They were two different locations, two different buildings and addresses. So according to the state, they needed to be two different companies or have two different company names with the state. And it was Remax First Quickway Homes and Remax First.
Okay. And which was in charge of what? Okay, you said there was two arms, sales, property management, correct? Am I tracking? Is that correct?
Correct?
Okay. Which company was in charge of which arm?
Company.
You just stated in your testimony that there were Remax First and then Remax First Quickway.
Right.
Okay. Which one did what?
Well, Remax First Quickway did primarily rentals and property management, and Remax First did primarily sales.
And how long did it go on as you just stated?
I can't recall.
Was it like that when you were a principal broker at any time?
At some point, yes, it was.
Would that have been early on or subsequent?
Much earlier on, probably in the 2008, obviously early on, when we we sold the building at 503 Lamar Street where the property management was, and we all reconvened in one building at 612. Then we formed together as far as the company goes under Remax First, or the owner did.
Who was that owner?
John Owens.
Okay, nothing further.
All right, Ms. Cudd, I'm sure the commission has questions for you, but so now is your opportunity to say anything that you wish about this matter in the form of your testimony, anything you want to add to the answers to the questions, and then we'll allow the commission to ask you anything that they have on their minds.
I just again would like to reiterate to the commissioners that I feel that I did everything possible and was a good broker while I was the principal broker for Remax First, and supervised my agents very well. But again, I believe it's impossible for me to be able to supervise anybody, or any principal broker could for that matter, for someone who is deliberately goes out of their way to hide something from you, where I had no access to anything until the TREC 1 form came in. And my subsequent conversation with Mr. and Mrs. Stone, once we received that, I did reach out myself personally to call Mr. and Mrs. Stone, and had a lengthy conversation with Mrs. Stone in retrospect to everything that had happened over the last 2 years, and did everything I could to satisfy them. And at this time, we're able to bring them back as good clients of ours that they trusted, and are back, actually with Remax First, and are managing their properties for them.
Commissioners, Ms. Franks.
Ms. Kuhn, do you have in the heading of all of your contracts Remax First?
Yes, ma'am, we do. We have a full logo with our address, phone number on all of our contracts.
So you don't have in your office a blank lease that any of your agents could get?
No, ma'am.
Do you use TAR forms?
Yes, ma'am.
Okay, so you have no knowledge of where Ms. Vincent may have gotten the lease without or any of the documents without your logo on it?
No, but the only observation I can make is that the copies I've gotten, and it may just be because they're copies, but it would appear that our logo on the purchase and sales contract would appear that a lot of something was whited out there, as well as the bottom of the TREC forms, in my observation.
So that was my next question. The form that looks like the purchase agreement appears to be a TAR form.
It does, yes, ma'am.
And it's whited out at the bottom. It would have had probably someone's name on it. Is that correct, on a TAR form?
Yes, ma'am.
And so that's not there, so we know that that's been whited out.
Well, I don't know if I can attest to that. I know for a fact that it has been whited out. It would appear to, in my opinion, as well as the top, there's a lot of marks that are left there that look like something was removed from the top. There's room there for the logo, and it's just blank with.
So you first learned of this when Miss Dunham got the notice, is that correct?
Yes, ma'am.
And so I'm sure she thought, oh my God, and she realized that it was under your principal-broker relationship that this took place?
That's correct, and she came to me about it first, as well as the owners, and we discussed that to see what the knowledge was.
Okay?
And at that point, we asked Ms. Vincent to come in and talk to us about it.
And did she come in that day?
It was either that day or the very next day.
Okay. And so when she came in, according to your affidavit, that she said it had nothing to do with RE/MAX. What did you think she meant by that?
Well, I think that she meant that I think she thought that it was a personal item that she needed to deal with on her own, but we don't agree with that. We feel that we did not agree with that.
So when you were her principal broker, did she mostly deal in selling homes, or did she mostly deal in property management, or both?
Mostly property management, but she did do sales as well. Some
Okay.
sales.
Okay.
Ms. Hills?
So there were two companies, RE/MAX First and RE/MAX Quickway.
Yes, ma'am.
Were you broker of both of those companies?
I was principal broker under that, yes.
For both companies?
If I can clarify that, maybe just make this a little easier for you. I'm not sure even how the relevance is of this case, but because the owners had the way those companies set up before I became the principal broker, and it was what the owners had set up for their businesses. And I understood the fact that they were two different buildings. When we sold the building and brought it in together, they should have immediately went ahead and combined the company, got rid of RE/MAX First Quickway Homes under the state as well as with TREC, and they didn't do that right away. And all of the agents were underneath RE/MAX First, underneath me as the principal broker. It just so happens that Ms. Vincent had a complaint by a tenant that was sent to TREC. It was heard before you. It was dismissed. It was a ridiculous complaint in that sense. But it was at that point that TREC staff picked up on the fact that you picked up, I think, as commissioners, how can she be working for this company under RE/MAX First, and then all these forms I see is under RE/MAX First Quickway. That was a boo-boo as far as that aspect of it goes. I don't really think it was Miss Vincent's fault on that aspect, nor do I think it was mine. And the owner, of course, paid for our $1,000 fine that was given to us in that aspect, and it was immediately remedied right after that to where everything was under RE/MAX First. All the forms are proper now. Everything's correct. And that was done 2013 or 2014.
But when you had the two locations, you were the broker at both locations, correct?
Yes, ma'am.
Okay.
But at the time of Ms. Stone's and Mr. and Mrs. Stone's complaint into that aspect of it, we were all under one building.
When did you get your broker's license and practice as a broker?
I
Approximately.
was first licensed in 1990, and I practiced as a realtor for 19 years before getting my broker's license. I specifically got my broker's license to become the principal broker in 2008.
And both locations had property management as well as sales. Is that what I understood with Mr. Collins asking?
No. The property management there was just rentals, and then the 612 Crawford Street was just sales.
So the RE/MAX First was just rentals.
RE/MAX First was just sales.
Sales. So the
Quickway Homes was just the rentals, correct.
Okay. And you had escrow accounts at both locations?
Yes, ma'am.
Okay. But did the RE/MAX Checkway do sales besides rentals, property management?
Well, again, eventually some of them did, not all of them, but Miss Vincent did a few as far as sales goes with that.
Did you use the one escrow account for sales and for property management, or two separate escrows?
Two separate escrow accounts.
And who had access to those escrow accounts?
Our bookkeeper and owners.
Okay. So, am I understanding that did you know that Ms. Vincent was doing, managing property outside of RE/MAX?
Absolutely not. That would never have been tolerated. That's taking away from RE/MAX First income as far as the company is concerned on it. So absolutely not. That would never have been, is against our policy and procedure.
When you questioned Mr. Stone, did I recall correctly that you would send monthly statements or accountability when when RE/MAX did have the property management?
Absolutely. We had no issues with that. Deanne Vincent was the property manager for Mr. Stone with RE/MAX First. What had happened with that was, clients come and go just like they do, and we average about 350 homes that we manage there. It was told by Ms. Vincent that Mr. Stone no longer wanted us to manage our properties. His contract had ended, and so that's where it ended in our paperwork. We thought Mr. Stone had decided to manage his own or maybe find another management company, but we were not aware that she was managing them on her own or had opened up a P.O. box to collect from the tenants. We were not aware of that.
And did RE/MAX pay Ms. Vincent for the property management when RE/MAX was managing Mr. Stone's?
Yes.
Okay. And you stepped away from being broker the end of June?
June of
2014?
Yes. Yes. Officially.
Any reason why you just decided not to be broker anymore?
I really loved training and teaching, giving the experience that I could, I think, from my years as a realtor, but my real love is sales and being out on the street, so I'd made that decision.
You just said that you enjoy training and other parts of the job that you may have. Did you have anything to do with the training of this lady?
Yes, she regularly attended my training.
Can you recall any subjects such as conflict of interests?
I'm sure that we were. There were a number of times when we had videos of the hearings here from the board. It's probably one of the greatest lessons they could get to watch as far as, what not to do, that sort of thing on it. But we had a lot of training in regards to law and ethics and how to lose your license and the day-to-day business. I think that even Ms. Vincent would attest to the fact that I ran a real tight ship. I wanted to make sure that everything was done. I was big on risk management.
How do you feel about the job that you did?
I feel I did a very good job, sir. I think that I did a lot than I've seen from a lot of other brokers on that. I think I bent over backwards to be there for my agents, and I was floored when I discovered this information. I was actually hurt.
Ms. Taylor?
Yes, I would like to know, do you recall when Ms. Van Zant had the leases on these homes that did not go through your office? Do you recall that she had any that were going through your office at that time?
Yes, Deanne managed probably up to 50, 55 properties at a time. And she was very good at what she did. I don't understand why she chose to do this, I guess for the reduction in the rent. Is all I could guess as far as that aspect of it goes. But, I'm not aware as to why, at this point that she did it. She said it was personal. I didn't find out about her managing these other properties until after we'd released her from the initial complaining about Forest Hill. And then, after reaching out to Mrs. Stone, discovered that she had been taking money from tenants directly, having them write the checks out to her, and depositing them into a P.O. box in Alcoa. And then, I guess, paying the owners.
So, just to get it straight, her main job, I think I heard you recall, was managing properties, leasing properties and managing?
Yes, ma'am, and we had no problems with those.
And she did some residential sales, but what would you say the percentage would be?
I would have to say she probably did 95%. Property management, 5% sales.
All right, thank you.
Mr. McMullen.
Hi there. I have a few questions I want to ask you generally about what affiliates do and are not allowed to do with RE/MAX, and then I want to ask you a few specific questions about Ms. Van Sant and Mr. Stone's properties. So let's talk about some of the general things first. RE/MAX first has affiliate brokers, and what I want to know is, are those affiliate brokers required to do all of their real estate services that they're providing through RE/MAX first?
Absolutely.
Okay. And when those affiliate brokers are providing services, if they use a form, whether it's for purchase of a property or for lease of a property, are they required to use the RE/MAX form?
Absolutely.
And that would have the RE/MAX logo on it?
Correct.
Okay. Are they required to get approval of that particular offer or acceptance from the principal broker in each instance?
In our particular office, yes. We had a system in place where they were to turn the file in to office admin. She goes through all there to make sure all the forms are there that need to be there. And then it was turned over to me as the principal broker, and I went through all the files thoroughly to see that I's are dotted, T's are crossed from a legal aspect to make sure everything lined up right with dates and that sort of thing.
So those would be required to be reviewed by another person in the office as well as yourself?
That's correct.
Okay. Okay. Let's talk some about Mr. Stone's properties. I think you said that the Forest Hill property was in RE/MAX's system for the time that it was first listed for sale by Ms. Van Sant.
That's correct.
Okay. Now, Mr. Stone testified earlier today that whenever that listing wasn't successful, he decided to rent the property. Do you remember that? That testimony
Yes.
from today? Was that particular lease done through RE/MAX?
He had, there were tenants that were in there before, and again, I don't have all the documentation on that, but yes, the tenants were done with that, and that was fine. Had a good tenant in there for a long time. The proper paperwork was turned in from Deanne. We had our bookkeeper go through and take care of the monies, which is her job. He got his reports. We took out our 10% commission. The only time that we lost track of Forest Hill was when we were told that he was not going to rent the property anymore. And, you know, then it becomes dead out of our system that it's done, you know, that tenant's not there anymore. And Deanne moved in. We did not have knowledge of that lease.
Okay, I want to, you told me a lot right there. I
Okay,
want to try to
sorry.
go back and break that down a little bit. Okay, there was a time where it was listed. That sale wasn't successful. That was with RE/MAX. And then it was rented, and that was done through RE/MAX.
Correct.
Okay.
There were no issues with either one of those.
Right. And then at some point, it stopped being rented through RE/MAX.
Ms. Vincent came to our admin in the rail department, which is Amy, and told her that he's not going to be renting the property anymore through us.
Okay.
So she knows to shut him down in the system.
Okay. Okay. And do you know of any other conversations or communications with Ms. Van Sant around that time about what was going to happen to the Forest Hill property, other than it wasn't going to be rented anymore by Mr. Stone?
No, I mean, other than he was not going to rent it out anymore and she wasn't going to relist it.
Okay. There were some other properties that Mr. Stone had and that he rented. Are you familiar with that?
I am, yes.
Okay. And in the charges that we have, the addresses that we were given were 720 South Washington, 711 Hillsdale, and 811-13 Alexander. Were any of those properties ever rented through RE/MAX?
Originally they were, and then we were told that he was not renting through us anymore. What he testified as to when he started paying her direct or having her manage them at no charge.
So those properties had been rented through RE/MAX, correct?
We had collected, again, the same thing, no problems with them. Everything was done properly.
But at some point, Ms. Van Sant came and told you or your staff that those properties were not going to be rented anymore by Mr. Stone.
That's correct.
Okay. Thank you.
Ms. Franks, you good? Ms. Cudlin, just one quick question. Oh, Ms. Taylor, I'm sorry.
I thought,
Go right ahead.
excuse me, I just want to ask you, you say that property management retained 10% of the rents on the homes that were leased.
Yes, ma'am, that was our fee for
Right.
for managing the properties.
Do you recall what the rental amount was on the 4 homes here?
No, ma'am.
Do you
I'm
have?
sorry,
No, you have
I can't-
no
I can't.
idea at all, right?
well, it's just hard to
It would-
memorize.
it'd be a guess. Mhm.
Everybody's rent, yes.
All right. Thank you.
Sorry.
Ms. Code, so I was looking at your response to the complaint. Is it your belief that you had already broker released Ms. Vincent when you got the complaint from Tennessee Real Estate Commission?
I'm sorry, can you repeat that?
Yes. So, according to your response, you became aware of complaints, judgments, and court proceedings on October 8th.
That's correct.
Called Ms. Vincent in on the 9th, broker released her on the 10th.
Yes.
To it. When did the complaint from TREC show up? Was it sometime before that or sometime after that?
October 8th.
Okay, so you also heard from the Knoxville Area Association of Realtors on that date?
They were within a couple of the days together. Again, we're going back a few years here, but they were within a couple of days. We did receive the car complaint first, and then I would say the next day, they were almost simultaneously, that we received both of them at the same time.
So there was not a period of time once you knew about it but didn't do anything about it?
Oh, no, I think that we acted very quickly. I mean, I felt that the right thing to do, of course, was to ask Ms. Vincent before we made a decision what her side of the story was. And that wasn't acceptable to us in our beliefs.
Okay, thank you. Ms. Hills.
I'm sorry, I just have to have something clear in my head. To follow up on Mr. Grease, so Mr. Stone, when he received a letter from an attorney dated April 9th, 2014, that was Exhibit 3, he did not reach out to you?
I wish he had, but no, he never did.
So he didn't come to you before TREC, you received notice from TREC?
Not at any time.
Okay. And then one other question. The Exhibit 1, and I know you don't have your exhibits there, but because it does reference in number 21 and 22, RE/MAX first at 503 Lamar, notices and maintenance. Do you think this may be a copy of your lease agreement that is maybe missing the top?
I do.
Okay.
But I can say that I've never seen that contract before. It was never turned into the office.
Thank you.
All right, Your Honor.
Else?
Ms. Brown or Mr. Collins, either one, have anything for Ms. Cudd? No? All right, thank you very much. Ms. Cudd, anything else you'd like to say at this time? All right, thank you, ma'am. All right, and your next witness, I assume, is Ms. Vincent. Is that correct?
Yes, Your Honor.
All right, let's take a short recess before we hear from Ms. Vincent. Members of the commission, there are a couple of exhibits that we did not have extra copies of. I know specifically 4 and 5, and Mr. McMullen and Mr. Bloom have reviewing some of these, so that I have. So if anybody needs to look at anything you don't have, just holler at me. I believe we're up to number 11. Is that right? We're through 11. So okay. All right. All right, Ms. Vincent, would you raise your right hand, please, ma'am?
Do you swear or affirm that the testimony?
Go ahead, Ms. Brown.
Good afternoon, Ms. Vincent. Could you please state your full name and address for the record?
Beth Vincent, P.O. Box.
You're going to have to speak up. You're going to speak up and speak into the microphone, please.
Deanne Elizabeth Vincent, P.O. Box 4482, Maryville, Tennessee.
And where are you currently employed?
I'm not at the moment.
What is your occupation?
Realtor.
Sorry? I didn't hear what you said.
A realtor?
Okay, thank you.
Do you know a Mr. David Stone?
Yes, ma'am.
And how do you know Mr. Stone?
Mr. Stone was a personal friend and a business associate.
When did you meet him?
We actually met in 08.
2008?
Yes, ma'am.
And did you meet him professionally as a realtor or personally?
Personally.
Do you recall where you met?
I met him through a friend at a shooting range.
Now, did you have occasion to provide real estate services for him?
Yes.
What type of real estate services?
It started off in sales with him and his partner at the time.
Sales of a home?
Yes.
And what home was that?
As I recall, the first home was Forest Hill, 1339.
And were you affiliated with a firm?
Yes.
And what firm was that?
Remax First Quickway Homes at the time.
And who was your principal broker?
At the time, I'm almost positive in 08, I think it was Dennis Morgan. Dennis Morgan is when I started there with Remax, and I'm not exactly sure when Hope Cudd took over broker, but at first it was Dennis Morgan.
How long had you been with them at that time?
At what time, I'm sorry?
At the time when you had listed 1339 Forest Hills.
I'm not exactly sure. I'm not sure exactly when I listed it. And
now, did you sell any homes for Mr. Stone through Remax First?
I listed, but they were unsuccessful on a sale.
How many homes did you list for him?
2. Well, the second home is Myers Circle. It was kind of very confusing on that house because, I don't know if you want me to explain, but Mr. Stone owned the land that Myers Circle sat on, but Mr. Stone did not own the house. So the person that owned the house was his former business partner, and that property, Mr. Stone foreclosed on that property to take over the whole home and land and everything on that property. So it's kind of confusing. So at first, when I first started listing it, it was through his other partner, and then Mr. Stone foreclosed on that property, and so.
Did you list that property?
Yes.
And were you able to sell it?
No.
And were these listings done through Remax First?
Yes.
Now, did you also provide some property management services for David Stone?
Yes.
For what properties?
For Forest Hill after it did not sell, and then for Myers after it did not sell.
Were there any others?
Later on, there was a few others, yes.
What were the others?
720 South Washington, 811 Alexander.
And these were all property management services?
Yes.
Not listings?
Yes, correct. And South Washington, and 711 Hillside.
Now, back to the 1339 Forest Hills property, you said that you had listed that through Remax First, and it did not sell. Is that correct?
Correct.
And thereafter, what occurred?
Then I talked to Mr. Stone about if he wanted to put it on the rental market so that he could earn some income off of it, and he said yes, and so we put it on the rental market.
And were you able to rent it?
Yes.
And was that rental done through Remax First?
Yes.
And how long was that rented for?
Approximately 15 months.
And after that, was it rented again? Or was it listed for sale? What occurred after that?
I'm not 100% sure on if it was rented again immediately or listed again and then rented again after the next tenant.
And you handled that through Remax First again?
Yes.
And at what point did the home become vacant?
What are you referring to? After it didn't sell, after a couple of tenants?
After it was rented and
then there was a couple more tenants after that.
And did it become vacant?
Yes.
And did you approach Mr. Stone about renting it?
Yes.
And what did you do?
I asked Mr. Stone, because by that time we owned another house together also, Mr. Stone and myself, and I asked him at that time, if he'd be interested in personally renting it to me.
And what did he say?
Yes. And I asked him how much.
What did he charge you?
$1,000 a month.
And what was the rent prior to that?
I don't recall. I think it was around $1,200.
Did he give you a reduced rental amount?
He gave me the $1,000.
And how long was that lease term for?
1 year, and month to month after that.
And was he planning on listing that home with you again for sale?
After what point?
After you rented it for 1 year?
No, as far as I know, he didn't have plans to list it. I was going to try to buy it, but not list it.
Did you lease it for another year?
Around month to month.
After the first year?
Yes. Yes.
And did you pay him a security deposit?
No.
And you paid him rent on a monthly basis?
Yes.
Did you pay him on a timely basis?
Yes.
And who lived in that home?
My daughter and myself.
Just the two of you?
Yes.
And did you have any pets?
Yes.
When did you vacate the home?
As I recall, it was either April or May of 2014. I'm not sure of the exact date.
Your Honor, if I may approach. Vincent, do you recognize this document?
Yes.
And can you please describe it?
It's the lease for myself on Forest Hill.
And if you turn to the second page, is that your signature?
Yes.
And is this the lease agreement you entered into with Mr. David Stone for the 1339 Forest Hill property in Maryville?
Yes.
Your Honor, this was a previously entered exhibit. I believe it was Exhibit 1. It's the lease agreement. Now, Ms. Vincent, did you ever approach Mr. Stone about purchasing the 1339 property?
Mr. Stone and I talked about it early on.
Prior to you renting it?
I don't recall prior to me renting it. I would say after I started renting it.
How many times did you guys talk about purchasing the property?
Not very often, a few times.
And how many times did you enter into a purchase and sale agreement?
One.
And did you purchase the property?
No, I did not.
Why not?
Well, because when I had an FHA appraisal, there was all this water under the house. And so I had a couple of different companies come out and give me an estimate on getting the water removed from the house. And I couldn't get a loan approved because of the water under the house.
Now, did Mr. Stone also have an appraisal done?
Yes.
And did you see that appraisal?
I have an email from the appraiser.
And did that appraisal also corroborate the appraisal you had done?
No.
Did that appraisal mention the water issue?
I don't know. All I have is an email from the appraiser telling me what he appraised it for. I don't have that appraisal.
You didn't have the actual appraisal?
Not that Mr. Stone had done. I did not.
Now, when you were managing Mr. Stone's properties, did you go to the properties and collect the rents? How exactly were those handled?
What property are you referring to?
Properties you managed for Mr. Stone?
Like, most of the time, we had, at RE/MAX, they have a office for property management, the bookkeeper who would come in and you could pay the bookkeeper, that way. Early on, I don't recall being able to, that the tenants were able to pay online, but later on, then they were able to pay online.
Did they mail in payments?
Yes.
And when you were managing the properties outside of RE/MAX First, how did you handle the rent collection and accounting and all of that?
I would go out to the property.
You go out to the tenant and collect the rent on the date the rent was due?
Most of the time, yes. Mm-hmm.
And then what would you do with the rent check?
Deposit it into Mr. Stone's account.
So the checks were made payable to Mr. Stone?
Correct. Unless there was like a repair that had to be done, then he said, just have him make the check out this month to me, deposit the difference, and then give him the receipt, obviously, for the repairs.
Now, did you ever ask tenants to make checks payable out to you?
That's why I just testified, yes. The checks were made payable to me only when there was a repair to be done.
So every time there was a repair, they'd make the checks payable out to you?
Yes, and then the repair would take place, and then I would give Mr. Stone the receipt, and yes.
And would you deposit these checks into your account?
I don't recall. I don't recall.
And did you keep a spreadsheet or an accounting, or how did you keep track of all these rental payments?
I had an accounting.
What type of accounting?
QuickBooks, I think, as I recall at the time.
And did you provide an accounting to Mr. Stone?
I don't recall.
You don't recall? You don't recall if you provided an accounting to Mr. Stone for his rental properties?
I'm sure I did at some point, but I don't recall like how often. I don't recall. I don't recall how often or when that was. I would text him and say, I would text him and let him know. But I don't recall you know, about the accounting, how often he would.
So, do you know at the time when you were renting the property from Mr. Stone, what would you say is the fair market value of the rental at the time?
I would say it was probably around the $1,200.
Around $1,200, so you were getting a discounted rent?
$1,000 is what Mr. Stone had come up with. I just asked, how much would you rent it to me for? And he said that.
And when he
So-
proposed the property management situation, you agreed to it?
It was nothing to do with in the very beginning. That was never, I'd never heard of receiving a discounted rent until his wife, years later, said something, well, you're getting that for a discounted rent, so you need to do this. And Mr. Stone testified, in the beginning it was never brought up. It was never even mentioned until years later when he married and his wife mentioned it. But other than that, I'd never heard that.
Now, earlier, we were discussing a lifetime lease. Do you recall that testimony?
Yes.
And I believe, I don't recall what exhibit that was. Can you just bear with me? Hang on.
Or
Do you recall Mr. Stone's testimony about this lifetime lease?
Yes.
And were you aware that you were inserted as the property manager in the lifetime lease?
Not till sometime afterwards.
But you had already been receiving the checks for this property?
No. No. Prior to this lease, Mrs. Stowell had not made any payments to Mr. Stone. And Mr. Stone at that time said, well, she needs to start making payments to me. If she's going to be living in this house, she needs to start making payments. And so that's when he did this. But prior to that, she had not, prior to this document right here, she had not been paying him rent, as far as I know. This money, I had never collected any money from Miss Stowell prior to this, ever.
When did you come to find out that you were to be collecting rents?
It was a few weeks after this document was completed.
And did Mr. Stone come to you and let you know?
Yes.
Okay, so he let you know that he included you in that document as the property manager to collect the rents?
Yes.
And you agreed to do that? Now, at some point, were you advised by Ms. Terry Stone that you were released as their property manager for all the properties that you were managing?
Yes, I
And how was that done? Were you told that verbally or in writing?
I don't recall.
And then were you still in the 1339 property?
I don't recall if it happened before I left 1339 or after I left 1339. I don't recall when exactly that conversation took place.
Now, were you asked to vacate the 1339 property by the Stones?
Yes.
And did you vacate?
Yes.
When did you vacate?
I don't recall the exact date. It was either the end of April or beginning of May of 2014.
Did you vacate within the time period that they requested?
Yes.
Are you sure?
I'm almost positive, yes.
Did you have your attorney send David Stone a letter with a lease to option purchase? Could you please explain that?
Lease option purchase had already, as I recall, the lease the lease with an option had already been given to Mr. Stone, and then the attorney had also sent it.
Sorry, the attorney already sent it.
As I recall, I had already given Mr. Stone a copy, and then the attorney also sent it. Yes. Is that your question? I'm sorry.
When you were asked to vacate the premises, did you contact an attorney? And did that attorney send David Stone a letter and attach a lease with the option to purchase agreement? Okay. Now, where did you get that lease with option to purchase agreement?
I drew it up from David Stone and I discussing about it when I first moved in.
Now,
And before
previously, you heard testimony where David Stone said that he had never signed such a document, correct? So how do you explain that?
It's not, he didn't sign it. I made a huge mistake and did it.
What did you do exactly?
I copied the signatures. I copied the paper.
Please explain.
It was just a cut and paste.
So you cut from another document the signatures? Did you cut the lease from the lease agreement, the signature lines? I'm sorry?
I don't recall.
Where did you get the signature that you cut?
I don't recall where it came from. I did a lot of business with David. So I don't recall exactly where it came from. I'm sorry.
I don't recall which document you took it from.
Correct.
But you cut it from another document.
I did, ma'am.
And then you pasted it or glued it.
Yes, ma'am.
So you basically forged a document.
I don't know what you call it, ma'am, but I did do that.
Now, of all the rent checks that you were collecting for David Stone, did you deposit all those checks into his account?
Yes.
Did you deposit any of those checks into your personal account?
No.
Are you sure?
I'm not 100% sure, no. I don't recall if someone wrote a check and there had to be repairs. I don't recall.
Your Honor, I have nothing further.
Mr. Collins, I'm guessing that your questioning of Ms. Vincent might be rather lengthy or more lengthy. So why don't we say, Ms. Cudd, do you have any questions for Ms. Vincent before Mr. Collins asks? No questions. Okay, Mr. Collins, go ahead.
Thank you.
Ms. Van Zandt, I'm going to ask you just a simple question to start because you just had to talk about it. Why on earth would you forge a document and put his name there?
I got scared. I was a single mom. I just got scared, and I'm sorry I did it. I'm truly, truly sorry. I lost a lot from it. I was wrong, and I'm sorry.
Explain to this commission the circumstances that made you scared enough to where you would take this action.
You know, everything was fine with David and I for a lot of years, and throughout the years we talked about me purchasing the house, but we had to, David and I had to work things out on the other house that we owned together, and
Let's make sure, just for record, and I'm sorry to interrupt at this time. Just when you talk about the other house, just maybe the address and kind of the one that he was talking about earlier. Is that correct?
that's 519 Sherwood.
Okay.
That was the house that we bought together.
Say there was problems with that house. Continue.
We had some legal issues on that house, and so those legal issues kind of rolled over into Forest Hill. So at first, like when we first started talking about me purchasing the house on Forest Hill, we talked about, well, we can't do anything until we clear up the legal issues on 519 Sherwood. So we had these legal issues on 519 Sherwood that we had to clear up before I could qualify over here on 1339 Forest Hill. So Mr. Stone and I talked about that, and we talked about, well, at the time he was like, well, I'll just do a lease purchase for a while and see what happens, and we'll get this cleared up until we get Sherwood cleared up, then you could purchase Forest Hill. And so then it, like I said, we had a great relationship. It didn't start getting rocky until the last probably 2 months that we spoke, and that was in 2014. And I was just scared. I had no place to go, and like I said, I was a single mom, and I did wrong, and I know it, and I'm sorry.
I'm going to shift gears a little bit. We're going to talk about specifically each one of the counts that have been alleged against you in this notice of hearing and allegations of charges, okay? Specifically, I want to talk about count 1 right now that alleges a violation of Tennessee Code 62-13-312-B11, which, and I'm paraphrasing, is accepting a commission or any consideration or valuable, getting any money whatsoever for things that you should be doing under the direction of the code or the Tennessee Real Estate Commission. You understand what I'm talking about?
Yes.
Okay. So while you're managing these properties, did you receive any money from Mr. Stone after they ceased being with RE/MAX?
No.
Did you receive any commissions whatsoever?
No.
Okay. In the purchase and sale agreement that you in fact put together for the purchase of 1339 Forest, in that contract, were you purported or were you supposed to receive any commission whatsoever?
No.
Now, the next part of 11 is valuable consideration. So let's talk about that. There's been a lot of questions, and the commission has asked and the state has asked about what the fair market rental rate of that property was, Forest, and you said it was $1,200. You're getting a rent of $1,000, right?
I'm paying a rent of $1,000.
Right. It's a $200 difference.
Yes.
Now, it would appear that that would be valuable consideration. However, I need you to explain what were the circumstances and what did Mr. Stone communicate to you when you entered into that agreement for $1,000 a month?
Okay, so we talked about it in the very beginning. We talked about the fact when I made the phone call, I said, okay, so those tenants that were just in the property left before the term of the lease expired. So they left. So I said, David, how much would you rent me the property through if I just rent it personally? I'm not going through RE/MAX. You're not paying commission on RE/MAX. So he said, $1,000. You pay the property taxes and
let's make sure that the pronouns are clear.
Sorry.
Who is you?
myself. He said to me, you pay the prop,
And pay the taxes.
the taxes on the property, and you pay the insurance of what I could. I maintain like dwelling insurance, and I pay the property taxes.
So, in your capacity as a tenant, you weren't receiving any commission or monetary value for renting 1339, in your
No.
opinion?
No,
Did you feel like you were receiving valuable consideration at that time?
no,
Okay.
because I look at it as the previous tenant, as I recall, was paying $1,200. Now I'm paying $1,000 plus the insurance and the taxes.
Previous tenant pay insurance and taxes?
No,
Okay. Do you have any idea what that amount was?
the taxes were, I felt like quite high. They were about $1,300 a year, as I recall. I don't know the exact amount. I think it was around $1,300 a year, as I recall.
At this time, I don't want to put words in your mouth, so I'm just going to ask you. What type of relationship did you have with Mr. Stone at this point?
Back in when I first moved to Forest Hill,
In and throughout the time you were managing his properties?
we had a great relationship. We had a great friendship.
Considered him a friend?
Yes.
Okay. And, okay, I'm going to move on from that. Now, count 2 is charging you with violating any provision of this chapter, which is a catch-all. So, which basically means, do you understand that if you're found to be violating any part of this chapter, you could be found guilty of count 2? Do you understand that?
Yes, so it's a little confusing, but
Legal jargon? Okay. Count 3 specifically is kind of what we're here about. It talks about any conduct that constitutes improper, fraudulent, or dishonest dealing. Now, before this commission today, and as you previously testified, do you feel that you acted in a dishonest or improper way when you forged that document?
it was wrong. It was wrong. Yes.
You accept responsibility for that?
Absolutely. I'm telling the truth. I did it. I'm sorry.
Now, I want to talk about count 4, which is talking about written disclosure. Okay? As a real estate agent, you know that you're supposed to disclose what your agency status, or if you have any personal interest or anything like that when you're working out a purchase and sale agreement.
Correct.
Okay. In your capacity at 1339 Forest, what was your, in your mind, agency status?
When I was renting,
Now, when you were preparing the purchase and sale agreement.
I wasn't a realtor. We were just friends.
And is it your testimony that you were purchasing it on your own accord as a person?
Yes.
Okay. Did you feel at that time that you had any obligations as far as agency?
No.
Okay. Was that your understanding of the law at the time?
Yes, I was doing it on my own. It wasn't going through RE/MAX.
Ms. Van Zandt, can you identify that document for me?
Yes, it's a personal interest disclosure and consent.
Was this filled out in conjunction with the purchase and sale agreement that's previously been marked as an exhibit in this hearing?
Yes.
Did you personally fill this out?
Yes.
Okay. Now, did you deliver this to Mr. Stone?
Yes.
Do you have an explanation as to why he did not sign that?
No, I do not. I'm not sure why.
I'd like to make this the next hearing, exhibit to this hearing, I believe
I believe.
During the time that you were preparing this purchase and sale agreement, and you gave him this written disclosure, any doubt, based on the relationship and your understanding of what Mr. Stone understood, their doubt that you were representing yourself as a buyer?
No, there was no doubt. I was just representing myself. I mean, yeah, I mean,
Did you previously talk to him about what the purchase would look like, general terms, that kind of thing?
yes, and they didn't want to pay commission, and so they wanted me to do it just on my own so that they didn't have to pay commission.
And did y'all discount the purchase price based on that amount of commission?
Yes.
What did you base, if you recall, that commission amount on? So what I'm asking is, what purchase price did you agree was fair? Do you recall?
The appraisal, and I think there was something floating around from Ms. Stone, an email saying that the appraisal was for $258, and the purchase price then was $242, as I recall.
And the difference in price would have been reflected in a percentage of about 6% commission?
Yes.
Okay, that you didn't go, and at the request of Mr. Stone, you didn't enter into an agency status with RE/MAX, is that correct?
Correct.
Now, in the policies and procedures that you recalled for Meet RE/MAX that have previously been mentioned, did there have anything to do with you actually purchasing real estate for your own residence and whether or not you could do that outside of RE/MAX?
As I recall, on RE/MAX, you were allowed to purchase one property a year outside of RE/MAX, not paying RE/MAX commissions.
But you disclosed your interest with the document that's been provided as the last exhibit to Mr. Stone in anticipation of this purchase and sale agreement?
Yes.
Okay. Now, what I really want to know and what the commission wants to know is, given the fact that you have admitted under oath that you fraudulently signed a document that was an inaccurate document, right? You admit that?
Yes.
You admit that you did this without the knowledge and consent of Mr. Stone, okay? Why should they not take away your license forever? And why should you get any consideration for a lesser penalty, such as a suspension or something like that?
I mean, to be honest, I mean, I definitely feel like I should receive some punishment, but to take away my livelihood for the rest of my life, I mean, to me, that's pretty drastic. I mean, you know, I watch the commission actually a lot, and I, see other people that do a lot of things that, it's not like taking away their license for the rest of their lives. I agree that I should be punished. I'm the first one to say it. I did wrong, but for the rest of my life, when you make one mistake and you pay for it for all your life, just to me, it's very harsh.
Okay. The rules are promulgated and given to protect the public. Given what you've had to go through with this hearing and with the possible revocation of your license, what would you say you've learned?
A lot. I mean, I would never make a mistake like that again. I've learned a lot. It's hard to explain everything I've learned, to be honest. It's hard to explain, but I mean, I've definitely learned a lot. I'm sorry, but it's hard to explain.
I understand that, but I guess what I'm trying to get at is, actions that you took at any point going.
Absolutely never. Never.
Since this has happened, have you immersed yourself more in the laws and the rules?
This has happened. I've watched a lot of the board meetings and learned a lot. Learned a lot of the.
Do you think you're able and fit to serve honestly and have fair dealings with the public going forward if you?
Yes.
Do you think a suspension for a period of time would be a fair punishment for you?
Yes.
Do you think payment of fines that the commission would seem appropriate would be a fair punishment? Are you willing to accept any additional education, training, or whatever the commission decides is pertinent and necessary to rehabilitate the actions that you took on that day?
Absolutely.
Are you willing to do that?
Absolutely.
Is that what you're asking this commission to do to you today?
Sure.
Nothing further.
Brown, do you have any redirect from Ms. Vincent?
Yes, Your Honor, I do. Your attorney was asking you about the reduced rents that you were getting and whether or not that was valuable consideration in the notice appearing in charges. And you had mentioned that you were paying property taxes.
Yes.
And insurance.
Yes.
Now, how long were you paying those property taxes?
From the very beginning.
Very beginning of the lease term?
Well, from the beginning of the taxes being owed for starting in October, because the taxes are behind. So as soon as that first tax bill came out that was due for that period, I started paying them right away. Yes. Throughout the whole time I stayed there. Yes.
Said that that tax bill was approximately, what, $1,200 per year?
I think it was around $1,300 approximately. I cannot remember the exact amount.
And do you have a receipt for that?
I'm sure I do. Not with me. I'm sure I do.
What about the insurance?
I've got receipts for that too.
How much was the insurance?
That I don't recall. I don't recall how much it was.
And for what period of time were you paying that insurance?
I paid the insurance from the very beginning.
From the time you moved into the home?
Yes.
And that was the homeowner's insurance or the renter's insurance?
Dwelling insurance is what I had.
And you were here when you heard the testimony of David Stone, correct? And he never made reference that you were paying any type of property taxes or insurance, do you recall?
Yes, I'm sure it slipped his mind. I'm sure if he had been asked, he would have told the truth, and I'm sure he would have told you, yes, I paid the taxes.
Didn't he specifically state that you were getting a discounted rent?
I don't recall him saying that.
Now, you also were asked a few questions by your attorney about the personal interest disclosure. Do you recall that?
Yes.
Now, it said you had signed it, correct?
Correct.
And you said that you had given it to Mr. Stone.
Correct.
Now, Mr. Stone didn't sign it, though, did he?
Paper's not signed by Mr. Stone, no.
You have no signed copy of that.
Correct.
So how do we know that he received it?
Testimony. He said he couldn't say whether for sure or that he didn't.
But we're supposed to believe that you gave it to him.
Like he said, he couldn't say that I didn't give it to him. He doesn't recall it at all.
But why wouldn't you have had him sign it?
Not sure why it wasn't signed.
So if it's not signed, then it's no good, wouldn't you say? I mean, it's invalid. It's useless.
I wouldn't say it's useless.
Now, earlier you were saying that you were scared. What were you scared of, Ms. Vincent?
Being homeless.
Being homeless.
Having nowhere to go.
Now, you kept saying that it's not fair to take away your livelihood for the rest of your life when your attorney was asking you a few questions about this, correct?
Correct?
Was it fair what you did to the Stones?
Not saying that it was fair. I did wrong. I'm sorry. And I'm very, very sorry.
So how are we to know that you're not going to do this again? How is this commission going to know that you're not going to just keep doing this?
Learned my lesson. I would never do that again.
And how do we know that?
50 years old. I haven't ever done anything like that in my life. It was a moment of panic, and all I can do is say I have completely learned my lesson, and I would never do it again.
Your Honor, I have nothing further.
All right. Ms. Cudd, do you have any questions before I let the commission ask?
Could I ask after the commission?
Why don't you ask now? Ms. Cudd, could you take the podium, please?
Hello, Deanne. A couple questions that I have for you that have not had the opportunity to discuss since you left RE/MAX first, and you had stated that you thought it was a policy and procedure manual that you were able to sell one property on your own per year for where RE/MAX didn't charge you a commission. Is that correct?
Correct.
Okay. So did you see that as a bonus or as a benefit for being with RE/MAX first?
I thought about it one way or the other, to be honest.
Have you read, you recall what it says in the policy and procedure manual in regards to that?
I don't recall, no. I didn't do very much sales.
Okay. Did you assume that you could write the contract outside of RE/MAX first?
Yes.
Did you ever come and personally ask me as your broker if you could do that?
I did. And we spoke about it.
You're under oath, so again, I want to ask you, you're saying that you asked me if you could do that.
We spoke about it.
Did you ever turn the contract and all the required addendums into myself for RE/MAX first?
No, I did not.
And why did you not do that?
I wasn't going through RE/MAX first. I was doing it on my own.
And you received your broker's license, correct?
Yes.
And nothing in the broker's license stated that you were not allowed to do business on your own outside your brokerage?
I don't recall.
Do you think that you learned a lot from training while you worked at RE/MAX first? That's all I have.
Questions for Ms. Vincent?
I'll start with Ms. Franks.
Okay, let's start with that you are a broker then, right?
Yes, ma'am.
Are you grandfathered?
No.
When did you get your broker's license?
Honest, ma'am, I don't know the exact date. I'd have to look it up on the licensing. To be honest, I'm not exactly sure.
Has it been, you think, within the last 8 years?
Yes, ma'am.
Okay, so you're probably not grandfathered then, probably. Okay, can you tell me, do you typically take continuing education?
Yes, ma'am.
Okay, where did you get the lease agreement document?
That is a lease agreement that we used at RE/MAX first.
And so you took off the heading and the footer off of it then? Since it doesn't have RE/MAX on it?
I'm not 100% sure back then that RE/MAX first heading was on the top of the lease. So I'm not sure if I took it off at the time of the lease or not, ma'am, because I'm not sure. I know we put it on there later, and then I think after we left, they started using TREC forms. But prior to that, I don't recall if it was on there.
So, but this is an agreement between you and Mr. Stone, right? And that's when you moved into the house and started renting it?
Yes, ma'am.
Okay, so were you were at Remax first then?
Yes, ma'am.
Okay.
Way Homes.
Okay. Why did you not, okay, I want to know what your conversation was with your principal broker about her allowing you to do leases without paying Remax first.
That lease, is that what you're talking about?
Anytime
This
you
lease?
spoke to her about, was it okay for you to do leasing with, or property management without it going through Remax first?
Okay, so if you take it lease by lease, okay? So if you're talking about Forest Hill, I don't recall having a conversation with Hope about me renting Forest Hill outside of Remax, okay? I think at the time that she was broker, but I'm not 100% sure in 2010. I think she was, but I'm just not 100% sure if she was principal broker at the time, I'm sorry, or not. So that is the one that I did personally through, without Remax.
But I want to know, I don't care when or where it was, I want to know about your conversation with her and her telling you that you could do leases without it going through Remax first.
I didn't talk to Hope about the leases.
Isn't that what you just told us?
No.
Oh, it was about the
No.
contract.
Yes, and Hope does sales, okay? There was another managing broker that did rentals, that if I had a question on anything, that's who I was supposed to go to, was that managing broker. Hope and I did not have a conversation about this. If I had a conversation, it would have been with Harold Brown. If I had a problem with sales, then you would go to Hope. But if you had a problem in the rental department, you went to Harold Brown.
So, but you have a broker's license.
Later on, I got it. Yes.
So you've had you've had lots of hours. You've had to get 120 hours after you got your broker's license, and correct?
I have not got all my hours, ma'am.
Okay. So, but you knew she was your principal broker, not your managing broker. Okay. So she didn't know anything about it. Your managing broker did, not your principal broker.
As I recall, yes.
Okay. So, do you think that she is not guilty of any of this? She's not guilty of any of this?
On a sales aspect, Hope is a awesome selling broker and training, and she does a great job. So she can't, I don't want her blamed for my faults or my mistakes, ma'am.
So you agree with Mr. Stone then that she didn't know anything about it? Because there are ways that things can be done without your broker knowing it. And it was the way you did it. Is that correct? Yeah. Okay. All right. Hang on one second. Okay, on your on the initial complaint form, what do you disagree with on the complaint form? What do you feel that you are not guilty of? Did she have a complaint form?
Are you referring to October 16th, 2014?
The original complaint?
Is that this one?
Yes. Mr. Stone's complaint?
Mr. Stone talks about on several occasions she asked me to reduce the price of the home at one point for a credit of 6%. However, it wasn't on several occasions. The original purchase contract was minus the 6% from the appraisal value. So it wasn't like I asked on several occasions. After I got my appraisal done and found all the water underneath the house. Prior to that, I didn't know anything about no water underneath this house. I went to Be Dry and one other company, but I can't recall that name. I went to Be Dry and I said, can you come look at this? I don't know what this is. I don't know what's going on down here underneath this house. They came out and they explained to me, and they're the ones that told me that it was like a natural spring under there. It didn't smell. There was no smell of sewer. I mean, there was 2 to 3 feet of water underneath the house. So I had Be Dry, and I have the estimate to come and give me a price on getting all this water out. I didn't want the house sinking, obviously, so come get the water out. So you're asking me about what I disagree with. It wasn't several occasions. It was the contract was done, and then this FHA appraisal, and then I got Be Dry out there, and I went to him with Be Dry, and I said, here, this is what they're saying. Here's the estimate from Be Dry. Can we go down on the price some because of this? So that.
Okay. Whose idea was it to not go through RE/MAX 1?
Mr. Stone's wife.
So Mr. Stone's wife is the one who said, because you're paying less rent, you do this other work in addition. Is that correct?
No. Are you talking about? You're talking about the sale or the rental?
I'm talking about any of it now where it should have gone through RE/MAX first. There was a decision made at some point that you were going to do it on your own. So did he tell you, did his wife tell you, or did you come up with that idea?
He asked me after I'd started renting the property, quite some time after I started renting the property, he came to me and asked me, will you help me with these rentals? With me being out of town so much, I'm really struggling with trying to get this stuff done. And we were business partners, we were great friends. I was just trying to be nice and say, yeah, I'll help you out. We didn't have a contract. We didn't say, there was no money involved. There was nothing like that. It was just, can you help me out? And I said, sure. And
But as a broker, you knew better right then and there, didn't you, when he asked you to do that?
To be honest, I wasn't a broker then.
Well, you had a license.
Yes, ma'am.
Even as an affiliate, we are taught that is not, that's against the law. So you knew right then when he made that suggestion to you that there was a red flag. Oh my God, what do I do? Is that what happened?
No.
It's not?
No, it's not, because I was doing it as a friend. I wasn't taking any money from it. I wasn't benefiting at all. I was just trying to help out a friend.
But you were practicing real estate, right?
Yes, ma'am.
Okay. So let's talk about the TREC forms. I still don't understand on 8B, and it's all in the same writing, where you first of all, on 8A, you were broker released, and then 2 days later, the same company is transferring you. How did that happen?
Okay, no, I'm sorry, what?
Okay.
page now?
On 8B, where a couple of days after you were broker released, you have a form here for TREC that says you were then transferred from Remax First to Asset Realty Management.
Yes.
Is that your handwriting?
Yes, ma'am.
All of that's your handwriting?
Yes, ma'am.
Why didn't your releasing broker sign that?
Because she didn't give the opportunity to. She took the original copy of this and mailed it in. Then I get a copy of it like a couple of days later. Well, it might have been later that afternoon because she said, well, I just mailed it in. I didn't give you a chance to transfer. I just mailed it in. And I said, I'm transferring to another company. I should have the right to be able to take this form to my new company. That wasn't an option at the time. Miss Leslie Dunham just took the form and she mailed in the original without even giving me a chance. So then when I talked to my new broker at Asset, this is what he said, this is what we fill out, because what else would you have done? If you didn't have the original here, what else would you have done?
But you knew you were released. That day that you came in and they confronted you about what's happening, did they let you go that day?
Yes.
Okay. So within 2 days then, you were scheduled to go to Asset Realty Management. Is that correct?
That day.
The very same day they let you go, you got a job at Asset Management?
Yes.
Okay.
So from what I understood and from what this broker understood too, was this is how we had to do it. We had to transfer because
even though you were broker released, though?
Yeah, because you had 10 days. So
So he misunderstood it, that broker.
I mean, so I guess I'm still confused too. What would you have done if you weren't going to transfer it to a new? What would you do? Like start a whole new TREC and not say transfer? I guess I was confused. I didn't write this up here, transfer.
Okay.
That came from the state. The
Okay.
state wrote in transfer.
Okay.
State wrote in the word state.
Okay. So have you been selling or doing property management since you said you were unemployed now? How long were you working after at ABC? How long were you working there?
I guess that's kind of a confusion too. ABC is my company. And ABC is a licensed company.
So who's the principal broker of that company?
There's not one. It's not being exercised right now.
So is there a firm license for ABC?
Yes, ma'am.
So who's the principal broker?
Well, it was supposed to be me. It was supposed to be transferred.
So you
And
don't really have a firm license if you don't have a broker, a principal broker.
Okay.
That's where
The-
some confusion's coming in, I
Yeah,
think.
it is confusing because I'm not sure about where I was notified about the $25. From what I understood was when you do a new company, there is a list of things you do. Okay, you have to do this, you have to pay this, you have to do this, okay? So I had called ahead of time to make sure I was doing everything right on this list of stuff that you had to do, okay? And that I had everything prepared right. So I said, okay, so the last thing is the $25. Well, they said, you don't pay that until, when I talked to them, they said, you don't pay that until the company exists. So, and I've got my canceled check showing that I paid the fees for the license, for the ABC to be licensed and the different fees involved. There was a $300 check and there was a $100 check, okay? So then after that point, so this was sent in on 9/28/15, okay? ABC wasn't even licensed until December. So what that time frame was, I'm not too sure. I would call and ask what's going on. It's going. I never did really find out why this time frame was such a gap. And so then, and that's what I'm saying. I asked, even when all this was going on, I asked, how come I'm not part of ABC? And they said, well, you didn't send in your TREC 1. And that was the last response I got from someone at Miss Brown's office. I'm not real sure who that was. Said you didn't send in a TREC 1. I said, well, can you please send me a copy of all of my TREC 1s? And they sent me a copy, and then it's...
So you didn't keep a copy
here.
of those TREC 1s?
I didn't have a copy of the old ones. I'm sorry, ma'am, I didn't. I didn't have a copy of the old one. And I still didn't get a copy of the very first one, you know, when I went to RE/MAX years and years ago. But I was never told about that $25. I have the other cancel checks about the $300 and the $100 that I submitted to the commission, but
Okay.
I'm not really too sure
Okay.
where it was said that. I remember receiving the email saying you didn't fill out the TREC 1 form,
Okay.
but I don't remember about the $25.
All right, so this is the last question. I appreciate that you've been honest and basically confessed that you have forged a document, which is a very big thing. So tell me, in your opinion, if you were a commissioner, what would you do if you came before you?
No, I mean, I firmly agree that everyone makes mistakes in life. But are you to pay for that mistake, that bad judgment for the rest of your life? I agree that everyone in life, we all make mistakes. And I'm sorry that I did it. It tears me up that I'm not, that David and I aren't close anymore. The whole situation, it does tear me up, and I'm very, very sorry. I would say, well, you lose your license for a year and you have to do this. But
I would just like to say this, and this is the final thing. I don't have any more questions. I see no winners here today, and I feel sorry for both of the respondents, actually. I feel sorry for both of you because you've both been are in terrible spots. But I know everybody's going to learn. Everybody in this room is learning from this. So,
Commissioner Bloom.
Yes, thank you for being here, Ms. Vincent. I know it hadn't been easy for you. I think the very best thing that could have happened is you telling us the truth, and so I appreciate that, although that's been very difficult. But I do have to ask you some questions. I'm sorry.
yes, sir.
So tell me what the nature of this post office box in Alcoa is.
I don't know what they're talking about. I've never had a post office box in Alcoa, ever. I have a post office box in Maryville, yes. But I've never...
What's the nature of that post office box in Maryville?
Oh, because at my house, it's a really busy road, and people just kept hitting the mailbox.
But it had nothing to do with your rental payments?
No, sir. I got that post office box within the first week I moved here in 2006.
Are you aware of the policy and procedures for RE/MAX as it applies to forms? Like contracts, leases?
Well, to an extent,
That you
sir.
generate.
So, with RE/MAX, it was two different divisions.
Well,
so
I'm
when you
talking
say
about
about
the
the forms, yes, as far as the sales forms and goes towards that, the policies and procedures.
Was it a different policy for the lease?
There
leasing?
wasn't one.
There wasn't one?
No, sir.
So you could lease whatever you wanted to, whenever you wanted to, and charge whatever you wanted to charge?
Oh, no, sir. There was the contract that RE/MAX has two different contracts, and I think that's where this kind of gets confusing too. On rentals, there is two separate contracts for rental properties. One is called managed, and one is called non-managed. So the contracts that you're referring to was RE/MAX first, Deanne Vincent agent, managed. RE/MAX first, Deanne Vincent agent, non-managed.
But in either one of those, did you not have to turn those into a broker to review those?
We turned them in, yes.
Okay. how about
That
the,
wasn't part of the procedures manual is what you were asking.
okay, how about the policy and procedures about how many houses could you sell, how many houses could you list without ever having to pay RE/MAX? What was the policy about that?
As far as I recall, you could list one house a year and not pay RE/MAX.
Did it have to be your house, or could it have been anybody's house?
As I recall, it was either your personal or your buying, not, so you're buying a house, so if you're, from what I recall, if you were personally involved in the transaction. So if it
What was the condition of the house when you left? The house you're leasing from Mr. Stone?
took a whole bunch of pictures. I didn't think it was that bad, and you're more than welcome to look at the pictures. We took tons of pictures.
So it was in good condition?
I did do some painting. I'm sorry.
Excuse me, Mr. Commissioner Bloom, we had decided earlier, and I decided earlier that that's really beyond the scope of the charges in this case, what the condition of the house was.
Ask questions about the documents that have been presented?
Yes.
On document 6, it presents the last page of document 6.
I'm sorry?
The last page of document 6.
What is that?
Judge, this was specific to my objection of the entry of that exhibit.
It is 6. If it... Yes, Mr. Bloom, we're not going to have any discussion about that. That probably, frankly, should have been deleted from this packet of information. Obviously, there was a disagreement between Mr. Stone and Ms. Vincent about the condition of the house after she vacated, but that's beyond the scope of these charges.
I have no more questions.
Taylor.
Ms. Van Zant, I want to ask you, there were several houses mentioned here that you were handling at the time that you moved into the Forest Hill home, right? Did you continue to, I have the address of Myers Road, were you still managing that?
I was managing that through RE/MAX, yes, ma'am. At
When
the time.
moved into, when
I
you
moved in.
moved into the Forest Hill?
Yes, ma'am.
The South Washington?
No, ma'am. That wasn't until later on, quite a bit later, a couple of years.
Alexander?
That wasn't until like 2011, after the time I moved in. Yes, ma'am.
Hillside?
That was quite a bit of time after I moved in. Yes,
And
ma'am.
then the Sherwood House?
Sherwood House is the house that Mr. Stone and I own together.
Yes, but you were managing that. Was it, or you were not managing that house?
No, ma'am.
Okay, you just owned that, but it was a vacant house then?
Yes, it required a lot of repairs. I was doing all the repairs.
So there was no lease on that at all, all right. So then the only ones, refresh my mind as to what was leased and you managed at the time you moved into Forest Hill?
None of the houses.
None. Now, then you subsequently leased houses after that time, some of these houses, right?
Well, now take the Myers house, I was renting it, I was the leasing agent on that through RE/MAX first when I moved into Forest Hill. But the three others, Hillside, Washington, and Alexander, that was sometime later on.
Were they leased through RE/MAX?
So Alexander was the one that Mr. Stone put me on as.
So it was a life lease, right?
Yes, ma'am.
Mhm.
It was a life lease for this lady that he had put me on. The other two were leased through RE/MAX as a non-managed program. So what that means is that those two properties were non-managed, which means that RE/MAX first finds a tenant. RE/MAX first, the lease is completed and the security deposit is taken. Sometimes the security deposit on non-managed is taken under RE/MAX name, and sometimes it was taken under the owner's name. Okay, so then after after that point, the properties were turned back over to the owner. So I did not personally rent them out. I didn't have any way to check credit and things like that. It was done through RE/MAX first as a non-managed property. And so that's the way it was done, through RE/MAX first non-managed.
Once those leases expired, did you continue to manage without RE/MAX being involved?
Yes, ma'am.
You did, all right. On this, another question, this personal interest disclosure and consent that we've been talking about, that you signed that Mr. Stone did not, I noticed that you did not sign it as buyer. You only signed it as agent, and you just signed it under the firm name of RE/MAX first. So, and this was in your, where was this attached?
I think it would have been attached to. Would have went over with the other documents on the purchase and sale.
So
And I
this,
think that-
so you acknowledge,
Hang on, Ms. Taylor, I'm sorry. I couldn't hear your answer.
I'm sorry. This would have been attached to the purchase and sale contract that was sent to Mr. Stone.
without RE/MAX on it.
Yes, ma'am, and that might have been why I had made the mistake of putting RE/MAX on it. That might have been why he didn't sign it, because didn't want to have RE/MAX any part of the sale.
The other thing I want to ask is that you say you paid the property taxes, and you paid the insurance on the homes?
I paid
On the Forest Hill home?
just on Forest Hill, yes, ma'am. I paid dwelling insurance. I couldn't.
Excuse me, by dwelling insurance, you mean renter's insurance? Or what do you mean by dwelling insurance?
It was just called dwelling insurance. What happened was, Mr. Stone had said about getting the insurance. So then I checked into the insurance, and he checked into it, and he had a lien. Well, on Forest Hill, he took out a home equity on his other home. And so something about that because he had some kind of lien against it, he had to still show some insurance on it. So the insurance company said, well, then you just get the dwelling insurance. I'm not sure exactly what dwelling insurance is. That's just what.
Well, you paid the bill, but whose name was, let's say if there was a beneficiary, if there was something happened to the home, who would have?
David Stone.
Would have gotten the money, although you paid the bill. So the
Yeah.
insurance was in his name or your name?
My name. And then he would have been.
He would have gotten the
beneficiary, I guess you could say.
All right. I want to ask again about the RE/MAX policy as you understanding of buying or selling a home within 1 year. I don't want to put words in your mouth. How again did you understand that?
I understood that we were allowed to sell one home a year and not be paying commission on that home, not going through RE/MAX and not paying commission on that.
All right. Now, would you understand that there's two sides to a sale?
Yes, ma'am.
So which side did you understand that RE/MAX was going to forgive?
Well, Mr. Stone wasn't represented, so there was no commission on that side. It would have been me, because I'm not
You as the what?
buyer, ma'am.
So you as the buyer could forgive your commission. What about Mr. Stone's commission? Does RE/MAX, how does their policy read on that?
I don't recall. I
think that's all I have at this time. Thank you.
Commissioner Horn.
Yes, ma'am. I was puzzled a couple of times through the testimony when you said that the first house you and he bought together. What does that mean? Does it mean that you had a pocket of money somewhere saved, and y'all pooled your money, or exactly what does that mean?
We pulled our monies and bought this house.
So it was like 50-50 type thing?
Well, I had a loan from some of my portion was a loan from a relative, but it was more like 60-40 because I put in 60, he put in 40. 40, yeah. Right around.
Well, one of the things you kept saying was waiting until you got your finance in order or something similar to that.
That was on Forest Hill.
Mm-hmm.
The house we bought together was Sherwood years
How
earlier.
did you get your finance in order? You hit the lottery, or, I mean, you got additional finance coming in. I don't understand getting my finance in order.
I guess I'm confused about the question. I'm sorry.
No, I think you used it also. The captain used it, and you kept saying you was going to buy the house when you get your finances in order. And he said you never did get your finances in order. I want to know exactly what did you mean by that?
Well, because of Sherwood, 519 Sherwood, Mr. Stone and I had some legal problems on that house, which I couldn't go get another loan until we took care of these legal problems on this home. So getting financing in order, I guess that's what you'd call it, getting in order, we had to finish up over here first in order to get it in order over here on Forest Hill.
The question, I'll be finished.
Oh, no problem.
You said you were business partners.
Yes, sir.
It seemed like he was doing all the business. How did you consider yourself a business partner?
We owned this house together. To me, that's business partners. It wasn't a house that we were going to live in. It was a.
Thank you, Commissioner. Ms. Hills.
Thank you. The lifetime lease, I had noted this morning when Mr. Stone is in his testimony that he said the reason he added your name to the lifetime lease was that you were already collecting the rent on 81-81113 Alexander. Was his testimony correct or not correct?
It wasn't correct, ma'am. I'm sorry. I think he forgot that I had never collected any rent on that property prior to that lifetime lease. I never really even knew who this person was until finding out later.
When you were managing Mr. Stone's properties outside of RE/MAX, did you manage anyone else's properties at the same time?
No.
Are you managing anyone's properties now?
I help an owner out, but I'm not managing any properties. I help an owner out.
What do you mean you help an owner out?
Well, if he calls and says, can you suggest this or can you suggest that, I do help him out like that.
But do you collect his rents or
No,
anything?
no.
Okay. And when you said you kept records, you had QuickBooks. And where did you deposit security deposits?
See, that's where it goes back to RE/MAX on the non-managed. RE/MAX collected the security deposit, so like it was either made out to RE/MAX or it was made out to the owner. And then if it was made out to the owner, RE/MAX bookkeeper would send it directly to the owner.
But I was talking about when you were managing properties when you were not, that did not go through RE/MAX.
Okay, so on a non-managed program, RE/MAX finds a tenant. RE/MAX does a lease, RE/MAX collects a security deposit. At that time, it's turned over to the owner, and that's when I would pick it up. After all that stuff, all the
Okay.
initial stuff was already done, then I would pick it up.
So you knew that RE/MAX did not know that you were collecting rents, and you were keeping your own set of books on QuickBooks, correct?
After that point, RE/MAX contract had expired, so what RE/MAX knew or didn't know, I don't know. I mean, it wasn't like we didn't speak about it, is what I'm trying to say.
Right. So then, but you were still collecting rents on properties that who has the security deposit?
It would have been sent back to the owner.
Were the leases up?
Yes.
So after a year, if they're still there, they get their security deposit back and they keep renting?
No, you can't release a security, in the contract, it would have said, security deposit being held by David Stone. Then Mr. Stone, and he testified, he takes it and he puts it into his trust account. Then after the tenant moves out, if there was nothing wrong, then Mr. Stone would return the.
So Mr. Stone, if RE/MAX didn't have the security deposits, Mr. Stone had them in his accounts.
Correct.
And you would put them there. And that's what you kept QuickBooks with?
No, not necessarily. I didn't necessarily put them in there. Most of the time, RE/MAX would mail them a letter saying, thank you for your business, blah, blah, blah. Here's the new tenants, here's the security deposit, blah, blah, stuff like that. It didn't go through me. It was initial.
So, shoo, I am confused.
I'm sorry.
So what did you keep in QuickBooks? What records did you keep
Rental
in
payments.
But you did not collect security deposits, just rental payments?
Correct.
Okay. And you received compensation from RE/MAX when it went through RE/MAX, but when that stopped and Mr. Stone decided to use you exclusively and you were keeping books, it is your testimony that you stopped receiving income with RE/MAX and chose to go with Mr. Stone and not collect any income?
Correct. I never received any income from Mr. Stone. None. The only income I would have received is when it was with RE/MAX.
And you entered into a lease with Mr. Stone, and in the lease, you say you paid the taxes, you paid the probably the contents insurance. I'm not sure about structure insurance, and that's not addressed in the lease, but you just decide to pay it as it's not addressed that you have pets, but you have pets too. So those three things were not in the lease, and you decided to do it. Okay. Did you manage property at ABC Properties?
Or
asset? You're
with
asset.
Yes,
realty.
ma'am.
You managed properties there. Okay.
Yes, ma'am.
And it's your testimony that you were the one that drew up the purchase and sale agreement. Okay, and we have that exhibit that you drew up the purchase and sale agreement, Exhibit 7, and on every page, you, besides maybe removing the RE/MAX from the top of the first page, also removed the Tennessee Association Realtors on the bottom page. Yet, however, the copy you gave us of your personal interest where you disclosed it, you chose not to remove it on that form.
And like I said, I'm not sure exactly why. I'm not too sure. I don't recall what happened.
And then you did remove so you removed those things off of forms, and you removed a signature off a form of Mr. Stone from some form you're not sure of where, and put it somewhere else too. Correct? Okay.
Commissioner McMullen.
Good afternoon. Help me a little bit, ask a couple of follow-up questions on the RE/MAX non-managed property program. So in this program, RE/MAX would find a tenant for a customer and would get the tenant to execute a lease, would get a security deposit, and would then send the security deposit and the signed lease to the customer for the customer to then do their own rent collecting. Is that right?
Correct.
And for that, the customer would pay how much to RE/MAX?
So on non-managed, it was 100% of the first month's rent and 100% of the first month's rent. I'm used to just saying it, but it was 100% of the first month's rent. Managed was 50% of the first month's rent and 10% every month thereafter.
Yeah, so you sort of anticipated what my next question was, which was there was also a managed program.
Yes.
And in that program, correct me if I'm wrong, RE/MAX would do the same things they did under the non-managed program. They would get the tenant, get the security deposit, but then RE/MAX would be in charge of collecting that rent every month and then providing the net rent amount to the customer. Is that right?
Correct.
And in the managed program, it was 50% of the first month's rent and then some percentage of every ongoing month rent.
10%.
Okay. Thank you for clarifying that for me. Okay. Did Mr. Stone ever have any properties that were in the RE/MAX managed program?
Yes.
Okay. And he also had some that were in the non-managed program.
Correct.
All right. Help me with the timeline then.
Okay.
I
So-
understand that, let's go back to as early as we can. I understand that there were times where you were listing properties for sale. There were times where you were helping him through a RE/MAX non-managed program. There were times you were helping him through a RE/MAX managed program. Let's go back to the first property that you did any of those things on. Which property was that?
Forest Hill.
So for Forest Hills, you had a listing agreement to try to sell it.
Correct.
And where does Myers Circle, or if I may not be saying that right, Myers Circle or whatever that house was, where does that fit in? Because didn't you have it listed for sale too?
Yes, it was. Muddy, but when Myers Circle first came up, there was a tenant in there that other business partner of David Stone's had in there, some friend of his. So they had to get him out in order to get that property sold. So Forest Hill came first. That was during the construction. What had happened was David Stone was in business with David Perry. David Perry was the contractor on Forest Hill. David Stone couldn't get that house sold, and I had met him, and he said, can you come over to his house and look at this house and tell me what's going on?
About Forest Hill.
Yes, sir.
Okay.
So I go to Forest Hill, and what had happened was David Perry, the old contractor, just pretty much walked off the job, and there was tons of stuff that needed to be finished. So I told David, you need to get another contractor in here and assess this whole situation. And so he found a contractor, got a contractor in there and assessed all the situation. And then Myers came in, but I'm not exactly sure the timeline. I would say 2008, 2009.
So you think Forest Hill was the first listing,
Yes,
correct? And then you listed Myers Circle.
Some point after that, yes.
Okay. But before you personally started renting Forest Hill, is that right?
Long time, yes.
Okay. So when do South Washington, Hillside, and Alexander come in this whole picture? Were they all after you were personally renting Forest Hill?
Yes, sir.
Okay, so let's go back then. Okay, so you had a listing agreement for Forest Hill, but you weren't able to sell it ultimately.
Correct.
You had a listing agreement for Myers Circle, and you weren't able to sell it either, correct?
Correct.
So then you started renting for, not personally, but you
Right.
found a tenant
Correct.
for Mr. Stone for Forest Hill.
Correct.
And that was through RE/MAX, correct?
Yes, sir.
And you would have used a RE/MAX approved lease form for that
Yes.
transaction?
Yes.
Was that a RE/MAX non-managed program, or was that a RE/MAX managed program?
Managed.
Okay. So Mr. Stone was paying some compensation to RE/MAX for continuing to manage that rental
10%.
at Forest Hill.
10%.
Okay. And so then you also got, when Myers Circle didn't sell, did it go into the RE/MAX managed program as well?
Yes.
Okay. And so you found a tenant for that one,
Yes.
correct?
Yes.
And Mr. Stone was paying commission to RE/MAX for the rental of Myers Circle by somebody that you had found, correct?
Well, I mean, the 10% is taken out from rent and then sent to Mr. So, I
Yeah,
mean, yes,
it's
he's
netted.
paying it, but it's, yeah,
It's a net
yes.
thing.
Mhm,
Okay.
mhm.
Then at some point, I mean, you have a couple of tenants in Forest Hill over time, correct?
Yes.
Before you became a tenant.
Yes.
And was Forest Hills Forest Hill always rented through the managed program, or did it ever go to non-managed?
Always managed.
Always managed, okay.
Yes, sir.
Was Myers Circle always rented through the managed program, or did it go non-managed?
Always managed.
Always managed, okay. So then, at some point, a tenant leaves Forest Hill in the middle of a lease, and we've heard several times about how then you became the tenant,
Yes, sir.
correct?
Yes.
Now, in that situation, you did a lease agreement that we've seen and we have a copy of. And was that basically the RE/MAX form that
Yes,
you
sir.
used just for yourself?
Yes, sir. I did a lot of this form.
You used it a lot because you did 95% or so property management, correct?
Yeah. So
Okay.
I drew up a lot of this leases.
Okay. So, at the time that you signed the lease personally to rent Forest Hill, Myers Circle was still in the RE/MAX managed program or not?
It was still in the managed program because it had a few different tenants that fulfilled the lease, so it had gone on a few years. So yes, it had never gone to non-managed.
Okay.
After I left RE/MAX, from what I understood, they have sold it now.
Okay, we'll get to that. I'm just trying to keep it chronological in my mind. Okay, so you're now, at this point, you're living at Forest Hill, you're renting it. Myers Circle is in the managed program
Yes,
with RE/MAX.
yes.
And then at some point while you're renting Forest Hill, South Washington, Hillside, and Alexander come up.
So, Mr. Stone created this lifetime lease with Miss Stowell, and I feel that, and I can't speak for Mr. Stone, but I feel that he put my name on it. He was trying to distance himself from this person because it was an ex-girlfriend. So he was trying to distance himself. So I feel like he put my name on it so he tried to distance himself from this person.
Okay.
So then this was in 2011.
So
And
was
I
that
think
the first, out of Alexander, Hillside, and South Washington, was that the first of
Yes,
those
sir.
three that you became involved in
Yes,
helping
sir.
to manage?
Mm-hmm.
Okay. And did that particular lease for Alexander ever go through RE/MAX at all?
Stone had this done at his attorney's office.
Okay. And so that wasn't a RE/MAX form, but you were in charge of collecting the rent on that particular property, correct?
She sent the rent to me.
Okay.
Mailed the rent to me in Mr.
Okay.
Stone's name every month, yes.
Okay. And did you keep any part of that as any form of compensation for yourself for doing that?
No, absolutely
Okay.
none. No.
So then after Alexander, Hillside and South Washington come up as additional rental properties, correct?
Yes.
And
So,
and were either of those ever through RE/MAX at all?
they're all like right next door to each other, but they're all three different streets, but they're next door to each other. But so South Washington, so you start with Alexander. I start taking over this in, I think the first payment was due January of 2012. Okay. So then later on in 2012, David had asked me about helping him with the other properties. South Washington was already rented. He had tenants in there for a few years. So once those tenants moved out, then it was put on non-managed through RE/MAX.
January of 2012.
No. January 2012 is when the first payment was due on Alexander.
Okay. South Washington, whenever a new tenant was needed, it went through RE/MAX non-managed.
Correct.
And RE/MAX took 100% of the first month's rent pursuant to the non-managed.
I'm not sure if
program.
they took 100% or 50%. I'm not sure. Sometimes RE/MAX had things that if a lot of the agents were longtime agents, and if you knew somebody did a lot of business with them and they brought you a lot of business, then they would only charge you 50%, even though it was non-managed. But
So
I'm not sure which one it was.
South
to be honest.
Washington, you used the Remax form contract,
Yes, sir.
and then after that, it went to non-managed, and you collected the rent.
It was non-managed from the very beginning.
Right, and
Yeah.
and so it went directly to non-managed, and you started collecting the rent and providing that to Mr. Stone. Okay, and then after that, Hillside came up, correct?
Yes.
And did it also go through Remax non-managed to get started?
Yes.
And then you collected the rent on Hillside.
Yes.
And this was all while you were living at Forest Hill. Okay.
2 years after I moved in there.
Okay. Once, so there was an initial tenant at South Washington and an initial tenant at Hillside that went through Remax non-managed, correct?
Well, South Washington initially had a tenant in there that Mr. Stone had.
Right, before, but then whenever he came to you and asked for your help, it was a Remax non-managed tenant. What happened when that tenant's lease ended? Was there a new tenant that was found?
I don't know.
Okay.
It was after I had gone.
It was after 2014.
Yeah.
Okay, and
Yeah.
same thing with Hillside?
Yes.
Okay. So you've indicated that there was a time whenever Mr. Stone's new wife, is her name Terry? Okay. There was a time where Terry said that you should collect the rents on, I assume we're talking about South Washington, Hillside, and Alexander, at no charge because you're getting discounted rent at Forest Hill. Correct?
I never heard that I never heard her, so like on Alexander, that, I didn't even know she existed at the time. I didn't even know they were dating. You know,
Terry?
Yes. I didn't know, I'd never heard anything about Terry.
So you
before that.
were collecting rent at South Alexander before you had ever heard of Terry?
Yes.
Okay.
Yes. And so then, and I never heard about, well, you're getting a discounted rate, that's why you need to be collecting these rents. I never heard that until like 2014. When stuff started going sour, that's when she was like, well, you're getting a discounted rent, so that's why you're gonna. And I didn't get that.
So that
at
was
all.
like April of 2014 or something?
In the beginning of 2014. I'd never
Okay.
heard that.
How did
that
you
wasn't the
respond
kind of-
whenever you heard that?
I was shocked because I was like, I was just doing this as a friend for David. We were good friends. We were, we had business and everything else. So
Let me ask you about your lease for Forest Hill, where you personally leased it. That lease says that you're going to pay $1,000 a month in rent, correct? And then it also says that you will be responsible for the utilities,
yes,
correct?
yes.
But the lease doesn't say anything about you paying taxes or insurance, does it?
Correct. No, it does not.
Okay.
I
You,
have
wh-
receipts. I can definitely provide that to the commission. I just don't have them with me here, but I do have all the receipts.
Okay. You were asked a question about when you did the cut and paste of the signature block into the lease option to purchase. And you said that you weren't sure where you cut and pasted that from. You don't know whether you cut and pasted that from this lease agreement, this Exhibit 1?
I don't recall. I just don't recall. I'm sorry.
Have there ever been any other times where you've done a cut and paste like
Never.
that before?
Never.
Okay.
Never.
Thank you.
All right, any questions the chair might have had have been asked and answered. Your Honor, back to you, sir.
All right, thank you, sir. Anything else, redirect? Oh, I'm sorry, you're right, I lost
No,
track.
Your
Mr.
Honor,
Brown.
I do
All right,
not have
any other
any-
questions, Mr. Collins?
I have one exhibit to
Oh,
present.
I'm sorry,
Based on
go ahead. Yeah,
questions
go ahead, please.
By Commissioner Frank.
A real estate license for ABC Professional Management.
Is that a true and accurate copy of the lease or the?
Yes, sir, it's original.
All right, this will be exhibit number 13, is that right?
I'll have nothing further.
Is that right? All right, thank you, Ms. Van Zandt. You can take your seat. Ms. Brown, any other proof?
No, Your Honor, the state concludes.
Mr. Collins, did you have any? Ms. Cudd, did you have anything else? All right. Mr. Chairman, I think let's take a recess. We will come back in, and then we will have closing argument deliberations.
Okay, to the audience, you're welcome to stay, but some of you are here and you're ready to go, go ahead. But make sure you sign out. But we'll continue in about 10 minutes.
10 minutes, right.
10-minute break.
Thank you.
Mercy, mercy, mercy. Oh, an act of mercy from the chair.
I gotta go upstairs.
I wanted to put a little thing on the end of it that said, but in no case will you ask how
That's right. If you don't stay,
In no
you
case.
cliffhanger.
you're not permitted, in no case are you permitted to call any commissioner to see how it turned out.
Yeah, yeah.
Oh, my.
Yeah, that should work.
I guess we can't do it. I can't do it.
Appreciate it, man. I've enjoyed it.
All right.
Let me ask you something. How'd you learn to break that?
I wanted to say hi too. I'm Marcia Frank.
I haven't checked mine.
Nice to see
Hey,
you.
well, let me check my email.
We got good news. He's coming off of his.
As far as I know.
Oh, it's at Metro. Oh, you're so sorry.
Well, I thought bless his heart coming and him to sit here with
This was worth the trip, guys. This is good
I
news.
got, you know what, I'm just gonna say it.
I'm from Knoxville.
This will scare the bejesus out of them to where, you know, if you really.
Well, very good. What am I doing here?
I'm the only principal broker sitting up there. Everybody else has been a principal broker and they're not anymore.
Amen to that.
That tells you
I
something.
you.
Yeah.
I've learned something
Principal brokers need to be well paid. That's all I got to say. Huh?
Well, I'm happy.
So
You're the odd one in the family.
what are you gonna do when you grow up?
Always?
Really?
Almost always.
Good. Well, I just want to come say hi to you. That's all I said back there. And I was feeling sorry for you. Glad you brought
He
it.
hangs out with mom.
That's a good thing.
We'll buy him a candy
Good
bar.
means a lot to she and I.
You're top 10, aren't you?
They've been through this thing. So they know.
Vacant. Well, I'd call it as the agent and say I have a verbal. Do you want me to write it?
Actually, I had it. Everybody's doing great. So, proud of you. I know it's hard, but you're making it and you look good. Nobody would know you were sick at all.
It's hard to tell. You are almost taller than me. He deserves a candy bar.
I'd have been tougher than Marcia. What? I'm tougher than Marcia?
I'm leaving. Well, I told Philip said he was going to dock my pay, and I said, well, I only got a 15-minute lunch break instead of an hour, so I'm making it up now. I know. Well, this isn't going to be 15 minutes. This is going to be at least an hour. So.
I know.
Calendar happy.
I'll get you one. I think there's some up here. Oh, are they gone?
That's okay.
I thought they were replenished.
Oh, they might. No water.
Thanks anyway.
Are we out?
Sorry, no water.
That's why I bought that big one.
I thought they were replenished after lunch, though.
I don't have a choice.
Not much I can do about it.
Hey, so you get to hang out.
Yeah, I get an hour myself.
Yeah. Or 3.
20.
Diet Cokes in there. The boy that was in here. Yeah, his mother asked me yesterday.
There's bottled water in the machine.
There have to. Will you hand me my? Will you hand me my? When she kind of tried to pull me, I think she was going to tell me what to do. I was like, lady.
I said, well, I'm just so sorry your mama drug you over here.
Sorry?
I know I don't want to do
Oh,
this.
I'm clear? Oh, good. Well, that's good to know.
I'm going to be short. That's like,
I'll say, what were we doing now?
a lot of meth.
Oh, is it really? It's like everywhere nowadays.
At one point, I wanted to add an E, drop an S, and add an E. It's greasy. I thought I might be able to collect some of something.
There you go.
That's what I was thinking about.
Yeah,
But not-
you could have called them up and said, hey, remember me? I'm a long lost cousin.
Yeah. They probably wanted proof, and then it might have been a problem.
We all back? No, Ms. Taylor?
Johnny. There's Johnny right there.
I would.
He'll come when you need that gavel.
Oh, that's right.
Oh, yeah.
Oh, here he is.
She may be on the hall.
And Ms. Cud. Thank you very, very much.
Sorry. I know.
Hey, Chris, could you see if Miss Cud's just standing right up there? Here she comes. Here she comes.
No problem. This is, it's just one page. All right.
Gary, little boy's saying. Who is he?
My fault.
You ready? All right, if we're ready to go back on the record, we are ready now for closing statements. So, Ms. Brown, you want to go first? So we'll go Ms. Brown, then we'll hear from Mr. Collins, and then we'll hear from Ms. Cudd. So go ahead, please.
Commission members, Your Honor, the department has shown by preponderance of the evidence that Respondent Hope Cudd has violated the Broker's License Act of 1973. In particular, Respondent Cudd has violated 62-13-312-B-15 by failing to exercise adequate supervision over the activities of a licensed affiliate broker, Deanne Elizabeth Vincent, while she was engaged in the conduct of as a real estate agent with RE/MAX First. Respondent Cudd was at all times the principal broker with RE/MAX First, a licensed real estate firm in Maryville, Tennessee, and she was the principal broker for the affiliate broker Deanne Vincent, the other respondent in this matter. As the affiliate broker, Deanne Vincent submitted listings for the sale of homes. She submitted lease agreements to RE/MAX First. They handle the property management for the Stones. The principal broker is responsible for Deanne Vincent. When Deanne Vincent told RE/MAX First that the Stones no longer wanted to rent property with them anymore, Hope Cudd didn't do anything to verify or to check. She relied on what Ms. Vincent told them. She failed to exercise adequate supervision over Ms. Vincent. Now, you have heard her state she didn't know. How could she have known? But it is her job to know. She is supposed to know what goes on in her office as the principal broker. Instead, she turned a blind eye. Additionally, the numerous property management functions that respondent Deanne Vincent engaged in for David Stone and Terry Stone fell under the function of the supervisory duties of Hope Cudd as the principal broker of RE/MAX First, and she did not adequately supervise these activities. Commission members, please keep in mind the law does not provide for any exceptions. It is clear. It states the failure to exercise adequate supervision over the activities of a licensed affiliate broker warrants disciplinary action to be taken by the Commission. I would urge you to take the necessary action in this case. As to the respondent, Deanne Elizabeth Vincent,
Ms. Brown,
I'm sorry.
can I ask you a follow-up question about Ms. Cudd before you go on to Ms. Vincent? Is that allowed?
Go ahead, Mr. McMullen.
So, with respect to Ms. Cudd, you're saying the failure to supervise was that when Ms. Vincent came in and said the Stones no longer want to rent or want to use RE/MAX's property management services, Ms. Cudd should have then investigated that further?
Should have at least checked and verified that, correct.
Okay. Is there anything else that you're saying forms the basis for her failure to supervise?
Just overall, her overall activities in terms of her duties to supervise, but just please keep in mind that this is my closing.
If there's another chance where I can ask you questions, I'll do so, but I thought this might be my last chance. I want to make sure I understand your case.
Yeah, I'm not sure I can provide that testimony either, so
Okay.
I just...
Go ahead, Ms. Brown.
Thank you.
Now, as to the respondent, Deanne Elizabeth Vincent, she clearly took advantage of David Stone and Terry Stone. She violated several statutory provisions. First, 62-13-312-B11. She accepted valuable consideration for the performance of real estate duties for those property management services. Next, 62-13-312-B14, violation of any provision of the law of the Broker's License Act. She did violate the law. Next, she engaged in conduct that constitutes improper, fraudulent, and dishonest dealing. She admitted to the altering of that lease with option to purchase agreement. This is a clear case of fraud and dishonest dealing and warrants revocation of her affiliate broker license. She forged a document and thought that she could get away with it. She was dishonest. Not only did she deceive the Stones, but she deceived RE/MAX as well. Deanne Vincent has a duty. She has a duty to all parties. Pursuant to 62-13-403, a licensee who provides real estate services in real estate transactions owes all parties under this section, Section 7A, not to engage in self-dealing nor act on behalf of a licensee's immediate family or on behalf of any other individual in which the licensee has a personal interest and the timely written consent of all parties to the transaction. Here, she did just that by entering into the lease personally with Mr. Stone. Commission members, The laws governing real estate professionals of the state are in place for a reason, a specific reason. It's to protect individuals from people like the respondents. Respondent Vincent has a duty to the public and a duty to safeguard the public from incidents such as what occurred in this case. You heard from David Stone. He explained to you all the details of what occurred. If Deanne Vincent had not engaged in the self-dealing and acting in an improper, fraudulent, or dishonest way, we wouldn't be here. Brokers have an obligation. They have to adequately supervise and can't hide behind, how could I have known? I didn't know what they were doing. They hid it from me. These are all excuses. This is a classic example of a broker that was not on top of everything that was going on with her affiliates, and a rogue affiliate decided to engage in forgery, deception, stealing, etc. She took advantage of innocent people. I would request that you impose the maximum penalty in this case and revoke the broker license of Hope Cudd and the affiliate broker license of Deanna Vincent. Their actions are a direct violation of the law of the Tennessee Real Estate Brokers License Act, and it is not acceptable, and it should not be tolerated by this commission. Additionally, I would respectfully ask for investigatory and hearing costs for bringing this action against these licensee respondents and prosecuting this matter for the violations of the Tennessee Real Estate Broker License Act and rules. Thank you.
Oh, thank you. Members, Judge, you know, in the closing argument of the state, they mentioned a blind eye. And what troubles me about that is that we have these laws and we have a prosecution by the department that is going after Miss Cudd. Even after Miss Vincent said she had nothing to do with it. And yet that blind eye doesn't allow them to let it go. But I think that's why the legislature had this body. Because as real estate professionals and people that have been in it, or civilians, you have a different understanding of what the reality is given the real estate profession. I've sat through many of these hearings. And I don't think I've ever seen a respondent be that honest and fall on the sword and say, I messed up. If we were in federal court on criminal charges, there would be a demarcation in the available sentence to them for accepting the guilt. For ponying up and saying, you know what, I did it, I made a mistake, and I am sorry. This was a professional relationship between an individual, and she thought incorrectly, and it was a lesson to everyone here that heard it, incorrectly that she could help out a buddy. Without realizing that once you take that oath, or once you take that test and you become an affiliate broker, and ignorance is not an excuse. I'm not suggesting that it is. But once you take that broker's license and you have it, you can't just help out your buddy just because you're not getting paid. And that's what she did, and she made a mistake. But she wasn't getting paid. Now, I know the commission members had a lot to say about valuable consideration. It wasn't $1,200 a month, it was $1,000 a month. But if she's paying the rent, paying the taxes, and she's also paying the insurance, I would suggest it's roughly the same amount. And keep in mind that when Mr. Stone was on the stand, his wife was going to testify right behind him. That's a new wife that came along after all of these agreements had been in place And after she found, and let's not hide the fact that this was a lifetime lease given to another woman that Miss Van Zant happened to be on. Now, if I'm a new wife or husband from 11/11/11, and I find out that my significant other has given a lifetime lease to somebody at a significantly lower rental rate, I'm going to start my own witch hunt and see if I can find something else. I would suggest to the commission that given the demeanor, testimony, and actions from Mr. Stone, I don't believe he truly was the one driving this complaint. And for that reason, it was hard not to go after Mr. Stone, but at the same time, what would that have accomplished? Because at the end of the day, my client did something wrong. And she told you about it. There are any number of things you can do to my client. Suspend her, make her have hours of CLE, make her pay a fine, many fines. Whatever you deem appropriate, she has already submitted to you that she's willing to accept it. Just don't take away her license. Good.
I've been in this business for 26 years. I've never been accused of what Mrs. Brown stated in her closing statement. I was brought up to be held accountable for my actions by my father and mother, and I believe in that to this day. But in this case, when you first heard it, and there was a lot of confusion, if you watched the video, a tremendous amount of confusion, I think, for the commissioners. And even Julie Kropp, who was the attorney for counsel at that time, recommended for you to dismiss me in failing to supervise on this case with her having the facts in front of her. How can you hold a broker responsible for someone who goes out of their way deliberately to hide and cover illegal activities that they're doing outside the company? I can't follow and trace them. I can't watch what they do in the evenings. I can't put private detectives on them. I believe that Ms. Vincent perjured herself today. In my opinion, I know for a fact that RE/MAX First had managed all the Stone properties. They were not non-managed. Please don't get sucked up underneath the dog and pony show there. It's irrelevant to the facts that were here. RE/MAX First was defrauded from income that belonged to them, that he was paying, Mr. Stone was paying to RE/MAX First all along. And I believe that she suggested to reduce her rent down, that she would manage the properties, and lied to the company the fact that he no longer wanted to manage the properties. We do, as a fact, check in with the owner on that, and he did concede with that on that aspect of it. We also send a letter out to him as far as how do you want us to handle the security deposits. So we do go about and not checking as far as our not just taking any agent's words. We have an exceptional system put into place. In sales and rentals, there was absolutely no difference, no different policy and procedure manual. It's all real estate business. It all applies under the same rules. Maybe there's different forms for a lease as there is to a sales contract, but we use TAR forms. We abide by the law, and we put our name and address on top of the contracts, which is required by law. I would never, ever allow an agent to go out and do their own business knowing I'm the principal broker and I'm responsible for that without me checking forms and making sure that sales contract is proper and making sure that personal interest disclosure is signed by both parties and making sure that that agent disclosed that she is a licensed Tennessee real estate agent. Not to mention all the addendums that go along that are required by TREC to go with all the forms. So please don't, again, misunderstand that. RE/MAX First does allow as a benefit to our agents for them to sell one of their own properties or buy one of their own properties for a year without having to pay RE/MAX First a commission. But that doesn't mean you have the right to not turn any of the paperwork in. I never had that conversation with Ms. Vincent. I just want to reiterate again, I had no knowledge of her actions on that until after the fact when the Stones placed that with us. I wish to God they had. It's a little odd that the Stones didn't come to us as far as that goes, but I think if you could see from his demeanor here, he was not very educated in the field of real estate. He's a very trusting soul. He was a very busy man traveling a lot as a captain. That's what he knew, is how to fly planes, not how the business of real estate worked. I think had he known that, I would have heard from him a lot earlier. I also believe if he got married a lot earlier than 11/11/11, I would have heard something a lot sooner too. But this is the case that's before you, and I'm asking you to please treat it separately from any of the actions that Ms. Vincent has done. Please see my point as the broker, that I did everything in my power to run that company properly. But I don't know how you could hold a broker responsible for something they have no knowledge or is deliberately kept away from them. There was no way I could have. If we could have caught it, she knew how to go about every way she could to not get caught on this. Right down to the P.O. box and telling tenants not to come into the office and you've got to pay me directly. There's no way we would know that. That's all. Thank you for taking the time to hear me today.
Thank you, Ms. Cudd. Anything else, Ms. Brown?
No, Your Honor.
All right, you said, I believe you had proposed findings for the board?
Yes, sir.
All right, Ms. Collins, do you have, all right. If this time, Ms. Brown is going to pass proposed findings to the board, we will take a moment and give copies of those to Ms. Cudd and Mr. Collins, please. And we'll stand in recess for a few moments to allow the board to review that. I'm sorry, Mr.
May I ask you this question?
Yes.
Will we consider one respondent at a time?
I will give you that instruction.
Okay. Well, are the finding of facts?
Yes, there are two documents, right? Yeah, there are
Okay.
two documents.
Correct.
All right. If we're ready to go back on the record. It is the responsibility of the commission to make a decision in these two matters, and that decision will be the final order of the board, and that final order will contain findings of fact, conclusions of law, a determination as to what, if any, penalty is appropriate against these respondents should the commission find they were any violations of your Practice Act. In response to the chairman's inquiry to me before we broke, as well as I hope has been made clear throughout the proceedings today, you have in front of you two separate respondents, two separate notice of charges. So you need to come up with two, as the same as Ms. Brown has provided to you, proposed orders. You need to come up with two distinct orders in these cases. And yes, Mr. Chairman, I would suggest that probably the easiest thing for you for this commission to do would be to take it one at a time. But my charge that I'm about to give you applies to both. The burden of proof is on the state to prove by preponderance of the evidence or as the more probable conclusion that the factual allegations contained in the notice of charges are true. The burden of proof is also on the state to show by that same preponderance of the evidence that the facts that it deems have been proven, and whether or not the facts that you find have been proven, constitute a violation of the statutes and or rules as set forth in the notice. Now, Ms. Brown has handed to you a proposed order. That proposed for each of these two cases, that proposed order is not, of course, evidence. It is merely the state's written position, in this case, if you will, and the commission may find it helpful to use that proposed order as a guide during your deliberations, but you are, of course, not bound in any way by anything that's in that, and you can accept those proposed orders as written or reject them and come up with your own findings completely, or accept them with any modifications that you believe have been proven in this case. Your decision must be based only on the record that's produced during the course of this hearing today. The evidence that has been presented to you today has been in the form of witnesses that have testified under oath, as well as the exhibits. Statements of counsel in this case are merely argument, and they are not to be considered as evidence in this case. And no rulings that I have made in this case on evidentiary issues that have come up or procedural issues should not be in any way taken by this board as a reflection upon my opinion on the evidence in this case. Also, as was made clear to you this morning, the fact that Ms. Cudd proceeded without counsel today should, of course, not be in any way held against her, the mere fact that she wasn't represented by counsel. After you decide whether or not, after you have made your findings a fact, you then must, of course, determine by your conclusions of law whether or not any of the provisions of your Practice Act as set forth in the notice of charges have been violated by either or both of the respondents. Should you find that any violations have occurred in this case, you are then authorized by statute to impose discipline. The statute that authorizes this commission the authority to do that is set forth in the notice of charges as well as in Ms. Brown's proposed order. That, of course, the discipline that is this commission has the authority to impose whatever discipline it deems appropriate, and that could be revocation, suspension, or downgrading of a license or anything below that you deem as appropriate. The commission also has the authority and is requested by the state in this case to impose civil penalties and costs of this procedure should you find that the respondents have committed any violations. I will not take the commission's time to go through all of the options that you have on civil penalties. I'm sure you're more familiar with that than I am. However, I borrowed Commissioner Horn's book here, and I was looking, and that the range of civil penalties available is at Rule 1260-2-.32, which is found on pages 90 and 91 of this book, and then it might help you as a guide in this case. As I stated earlier, as the administrative judge, I will not participate in the decision that is made on the merits of this case. However, I will be available for any questions that you might have during the course of your deliberations. If you don't have any questions of me at this time, I will turn it over to the chairman to conduct the deliberations.
Honor, what's the pleasure of the commission as far as which respondent first?
Van Zandt.
You Van Zandt first.
Then that way we'll see how everybody feels about the.
Okay.
I'm just one person now.
So is there, Ms. Frank suggests we take Ms. Van Zandt first. Is there objection to that or any strong feelings? All right, Mr. McMullen, would you like to assist us with findings of fact?
I'll do my best. Mr. Chairman, and these are going to be in the case of Ms. Van Zandt, I move that we adopt the following finding of fact. Hope Cudd holds a broker's license with the Tennessee Real Estate Commission. Through June 30, 2014, Ms. Cudd was the principal broker of RE/MAX First in Maryville, Tennessee.
Second.
You've heard the proposed finding of fact offered by Commissioner McMullen, seconded by Commissioner Franks. Discussion on the motion. All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Deanne Van Zandt holds an affiliate broker's license with the Tennessee Real Estate Commission. Through October 2014, Ms. Van Zandt was an affiliate broker with RE/MAX First, Maryville, Tennessee, and Ms. Cudd was her principal broker.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks. You've heard the motion. Is there discussion? All in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. David Stone, a resident of the state of Tennessee, had a business and professional relationship with Ms. Van Zandt while she was affiliated with RE/MAX First. During the relevant period, Mr. Stone did not have contact with Ms. Cudd or others at RE/MAX First. Mr. Stone is not educated in contracts or real estate transactions. His job required him to travel extensively out of town.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks. You've heard the motion. Is there discussion? All in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone had an ownership interest in real property located at Myers Circle, Maryville, Tennessee, and 1339 Forest Hill Road, Maryville, Tennessee.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks. Discussion on the motion. All in favor of that motion vote aye.
Aye.
Those opposed, no. That finding of fact passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone listed the Myers Circle and Forest Hill properties for sale with Ms. Van Zandt as an affiliate broker of RE/MAX First. Neither property sold while listed with Ms. Van Zandt and RE/MAX First.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner Franks. Discussion. All in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone then hired Ms. Van Zandt as an affiliate broker of RE/MAX First to manage the rental of the Myers Circle and Forest Hill properties. These properties were rented by Ms. Van Zandt through the RE/MAX Managed Property Program, in which RE/MAX lease forms were used, RE/MAX procured tenants and security deposits, and RE/MAX collected monthly rent. RE/MAX was compensated from collected rent before turning over net proceeds to Mr. Stone. Ms. Van Zandt was compensated by RE/MAX First.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks. on that particular finding of fact? Is there discussion?
Well, I don't know that that was ever introduced as evidence.
Pull that microphone towards you, Gary.
I wasn't sure that that was ever introduced as evidence
Art.
about her leasing with Remax.
When I believe that Ms. Van Sant testified, whenever I know I asked her some questions about it.
Okay.
That she leased the Myers Circle and Forest Hill properties through the Remax program before she personally became a tenant. That's okay.
No, that's a great question. Further discussion? All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Remax First requires that all affiliated brokers provide all real estate services through Remax First.
Second.
Discussion? All right, let's vote on that proposed finding of fact. All those in favor say aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Remax First provides lease and purchase sale forms that its affiliated brokers are required to use. Those forms contain logos of Remax and the Tennessee Association of Realtors.
Second.
Motion by Commissioner McMullen, second by Commissioner Franks. You've heard the motion. Is there discussion? All right, if you're in favor of that finding of fact, please vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Remax First affiliate brokers are required to provide proposed leases and purchase sale agreements to their principal broker for review before transmitting these to the other parties to such transactions. These documents were reviewed by Ms. Cudd and another employee of Remax First in each instance.
Second.
All right, you've heard the motion. Discussion on that proposed finding of fact. All right, all those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. When Ms. Van Sant rented the Myers Circle and Forest Hills properties through the Remax Managed Property Program, Remax lease forms were used.
Second.
All right, a motion by Commissioner McMullen, seconded by Commissioner Frank. Another proposed finding of fact. Discussion. All right, if you're in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. In 2010, the tenant in the Forest Hill property vacated the property. The market value rental of this property was approximately $1,200 to $1,500 per month. When the tenant vacated, Mr. Stone leased the property to Ms. Van Sant. The lease agreement was the Remax form, but with the Remax logo removed. The lease provides for Ms. Van Sant to pay rent of $1,000 per month and utilities. The lease does not provide for Ms. Van Sant to pay taxes or insurance. The term of the lease was 1 year, beginning November 1st, 2010.
Second.
Fairly long motion. Any discussion? If you agree with the proposed finding of fact, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone believed Ms. Van Sant would quickly purchase the Forest Hill property after she entered into the lease agreement with him. This did not occur as she could not arrange financing. After the 1 year term of the lease ended, Ms. Van Sant remained in the property on a month-to-month basis.
Second.
All right, another motion from Commissioner McMullen, seconded by Commissioner Franks. Discussion on that motion. All right, if you're in favor of that motion, that proposed finding of fact, please vote aye.
Aye.
If you're opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone owned residential real properties at 720 South Washington, 711 Hillside Avenue, and 811-813 Alexander, all in Maryville, Tennessee.
Second.
Discussion. If you're in favor of that finding of fact, say aye.
Aye.
If you're opposed, say no. Motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone requested that Ms. Van Sant, personally and not as an affiliate broker of Remax First, managed the rental of 811-813 Alexander. Ms. Van Sant agreed and collected rent on this property and managed the rental of this property.
Second.
You've heard the motion. Discussion? All right, those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Stone requested that Ms. Van Sant, as an affiliate broker of RE/MAX First, manage the rental of 720 South Washington and 711 Hillside Avenue through the RE/MAX non-managed property program. Ms. Van Sant agreed, and tenants were located for these two properties. After the leases were entered into, Ms. Van Sant personally, and not as an affiliate broker of RE/MAX First, collected rents on these two properties.
Second.
Discussion? All right, if you're in favor of that motion, please vote aye.
Aye.
If you're opposed, no. The motion passes unanimously.
Do you have Exhibit 5, Your Honor?
We weren't given a copy of that.
Mr. Chairman, I move we adopt the following finding of fact. In March 2013, Mr. Stone and Ms. Van Sant entered into a purchase and sale agreement for the Forest Hill property for the purchase price of $242,000.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks. You've heard the proposed motion. Is there discussion? All right, then, those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. The sale of the property from, the Forest Hill property from Mr. Stone to Ms. Van Sant never closed.
Second.
Discussion? Those in favor of that motion, please vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. In connection with the purchase and sale agreement for the Forest Hill property, Ms. Van Sant provided Mr. Stone with a personal interest disclosure and consent. The personal interest disclosure and consent is signed by Ms. Van Sant. It was not signed by Mr. Stone.
Second.
Discussion? All right, then, those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. In 2014, Mr. Stone decided that he wanted to terminate Ms. Van Sant's lease of the Forest Hill property and wanted to try to sell the property himself. He sent Ms. Van Sant a notice to leave the property.
Second.
Discussion? Those in favor of that motion vote aye. Aye. Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. On April 9th, 2014, an attorney for Ms. Van Sant sent a letter to Mr. Stone indicating that the parties had entered into a lease with option to purchase, and that Ms. Van Sant was not obligated to vacate the property but had the right to purchase it.
Second.
Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move we adopt the following finding of fact. The lease with option to purchase that was attached to the April 9th, 2014 letter from counsel for Ms. Van Sant was a forgery. Ms. Van Sant had cut and pasted Mr. Stone's signature from the lease agreement for the Forest Hill property.
Second.
Discussion. One piece of discussion on that. I don't know that it was ever absolutely confirmed where that cut and paste came from. What?
I agree she didn't admit that, but I think anybody can look at it and see that that's a cut and paste job from that lease agreement.
I'm just making a comment.
Yeah.
Are you saying any fool can tell that?
I think Ray Charles could see it, but I don't know.
All right. Any other discussion on that motion? Sorry I brought it up.
Oh, gosh.
All right, then let's vote on that motion. If you're in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Response, Mr. Chairman, I make a motion that we adopt the following finding of fact. In response to the letter from counsel for Ms. Van Sant, Mr. Stone hired counsel of his own to respond to the letter and at expense to himself. After counsel for Mr. Stone became involved, Ms. Van Sant ultimately removed herself from the Forest Hill property.
Second.
Motion by Mr. McMullen, seconded by Ms. Franks. Discussion. All right, if you agree with that motion, vote aye.
Aye.
If you don't, vote no. That motion passes unanimously.
Mr. Chairman, I move we make the following finding of fact. Ms. Van Sant informed RE/MAX First that the properties belonging to Mr. Stone were not going to be rented any longer when, in fact, they were being rented and Ms. Van Sant was collecting the rent herself, personally.
Second.
Discussion. All right, those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Yeah, anybody else, feel free to jump in.
Well, could you restate one finding of fact about the contract, purchase and sale agreement?
I didn't have it written down.
Okay. That's all right. Thank you.
Do you want to look at it?
No.
You can make
no.
another finding of fact if you want.
No, it's, there's not a closing date. It just hit me. That's the page it's missing. There's no ending date. All the pages, I counted for all of them but that one, and it's just hit me what.
Feel free to,
what
that's a
it's-
fact. If you think that's a fact, make a motion that we find that a fact.
I can't think of the code.
Don't need a code, just contract between Mr.
Yes,
Stone and
Mr. Chairman, I'd like to add to finding of the fact that the purchase and sales agreement between Ms. Vincent and Mr. Stone did not have a closing date or ending date.
Second.
got a motion. I have a motion by Ms. Hill, second by Ms. Franks. You've heard that proposed finding of fact. Is there discussion on that? If you're in favor of that motion, vote aye.
Aye.
If you're opposed, no. Motion passes unanimously. Anything else, Ms. Hills?
No.
Mr. McMullen?
Yeah, Mr. Chairman, I move that we make this following finding of fact. Ms. Van Sant was not paid directly for the property management services that she provided to Mr. Stone outside of her involvement with RE/MAX, but a reduction in rent was provided for her property management services.
Second.
You've heard the motion. You want to hear it again?
No.
So if you believe that finding of fact has been established, vote aye.
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 Aye, excuse me.
If you're opposed, vote no. Let the record reflect that the chair voted no. The balance voted aye. 6 ayes, 1 no.
Mr. Chairman,
Yes.
could I withdraw my finding of fact because it was not in my copy on Exhibit 7 and it is in Chairman Bloom's copy? There is a closing date.
Is there an objection from any member of commission for Ms. Hills to withdraw her proposed or previously approved finding of fact? Then please let the record reflect that finding of fact has been withdrawn.
Thank you.
You're welcome. No, appreciate your participation.
Mr. Chairman, I move that we make the following finding of fact. Mr. Stone did not consider Ms. Van Sant to be representing him in the purchase and sale agreement for Forest Hill property. Any listing agreement that had existed with Ms. Van Sant for that property had already expired by the time the purchase and sale agreement was entered into.
Second.
Discussion? Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move we make the following finding of fact. At the time that Mr. Stone and Ms. Van Sant entered into the purchase and sale agreement, there was no written disclosure of agency status executed between the parties disclosing Ms. Van Sant's status in the transaction.
Second.
Heard the motion. Discussion? If you're in favor of that finding of fact, please vote aye.
Aye.
If you're opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we make the following finding of fact. While managing Mr. Stone's properties, Ms. Van Sant performed real estate property management tasks such as collecting rents, depositing checks into Mr. Stone's bank account, and coordinating repairs of the properties.
Second.
Discussion? If you're in favor of that motion, vote aye.
Aye.
Opposed? No opposed. Passes unanimously.
Mr. Chairman, I think that's all I can come up with right now.
Sure.
Yeah.
Other commissioners have findings of fact that they would like to propose. All right.
Why don't you guys
Okay.
get on the record?
Do we need to add that she confessed that she had committed the fraud,
Forgery?
the forgery?
I mean, I think we found that it was a forgery.
Okay.
But feel free.
If you want to.
No, I think you didn't, you did say that.
All right, other commissioners, discussion or comments before we close this section? All right, so I'm going to rule the findings of facts related to the case involving Ms. Van Sant is over, and now we're moving to the conclusions of law portion. And again, Mr. McMullen, can you help us with that?
Your Honor, as part of our conclusions of law, do we need to go back and restate code sections, or can we just assume that those are established?
Well, are you, as long as, I would suggest that as long as you reference either the notice of charges or the, well, I take that back. I do think it's appropriate to reference the statute or the rule. You don't need to read the entire thing, but just the citation would be appropriate.
Mr. Chairman, I move that we make the following conclusion of law. With respect to count 1 of the notice of hearing and charges, the state has established that the respondent's acts and conduct, as described in the foregoing allegations of fact, constitute a violation of Tennessee Code Annotated Section 62-13-312B11. Such a violation constitutes grounds of possible disciplinary action and the assessment of civil penalties and investigatory and hearing costs pursuant to Tennessee Code Annotated Section 56-1-311 and Tennessee Rules 0780-5-11-.01. I want to go on for just a second about why I think that violation was established. This is the section dealing with accepting consideration by an affiliate for the performance of real estate services from a person other than the affiliate's principal broker. Ms. Vincent accepted compensation from Mr. Stone in the form of reduced rent rates for the Forest Hill property for the property management services that she provided at the South Washington property, the Alexander property, and the Hillside Avenue property.
Second.
You've heard the proposed conclusion of law offered by Mr. McMullen, seconded by Ms. Franks. Discussion. All right, let's vote. Those in favor of that finding or that proposed conclusion, that conclusion of law, please say aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 2.
Mr. Chairman, I move that we make the following conclusion of law with respect to count 2 of the notice of hearing and charges. The state has not established that the respondent's acts and conduct constitute a violation of Tennessee Code Annotated Section 62-13-312B4. This is the section that deals with the violation of other rules or statutes. No other rules or statutes that Ms. Vincent allegedly violated were identified.
Second.
Actually, for the record, Mr. McMullen, I believe that is B14. You said 4.
I'm sorry. Yes, B14. I
14.
misspoke. Thank you.
Okay, so the effect of your motion is to say there is nothing to be handled as far as count number 2.
That's what I think.
Okay, I just want to make sure that we're in agreement before we vote. Okay, that motion was offered by Commissioner McMullen, seconded by Commissioner Franks. Is there discussion on that motion?
Yes, 14 says if you violate
But
Record now.
I guess if I could address that, I think as a separate count, it's intended to refer to some other rule or statute besides those that are encompassed by the other counts that have specific rules associated with them. And here, we can get to counts 3, 4, and 5, but with respect to count 2, I don't see any other rule or statute that was violated, and the state never really specified any other rule or statute that they were operating under, and so I don't think count 2 was established as a separate violation because there was no other rule or statute that they directed us to besides the ones that are specifically enumerated in the other counts.
I would agree with that if it said violating any other provision of this chapter or any other rule, but it says any provision and any rule.
Well, let me say this. If you look at Rule 6213, 312B, it says the commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of. And then it lists 21 different things. And some of those we're dealing with in other counts. But then one of the 21 things that lists is under Section 14, violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by the commission. So I think B14 is intended to bring in all the rest of the code and all the rest of the rules as a basis for suspending or revoking a license. But since we have other counts that deal with the other potentially applicable numbers under 312B, and I don't think we're dealing with any of the conduct that's outside of 312, I don't think 312B14, applies in this situation.
Let's take a vote.
We're going to vote, but I want to finish discussion. Mr. Bloom? No, I don't have any. Okay. All right, so you've heard the motion. If you're in favor of the motion offered by Commissioner McMullen, which is to effectively throw out the second charge, you'll vote aye. If you're opposed to that, you'll vote no. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
No.
That motion passes on a 6 aye, 1 no vote. Mr. McMullen.
Chairman, I move we make the following conclusion of law. With respect to count 3 of the notice of hearing and charges, the state has established that the respondent's acts and conduct constitute a violation of Tennessee Code Annotated Section 6213 312B20. Such a violation constitutes grounds of possible disciplinary action and the assessment of civil penalties and investigatory and hearing costs pursuant to Tennessee Code Annotated Section 561311 and Tennessee Rules 0780-5-11-.01. The state established violations of 6213 312B20 through facts including Ms. Vincent's forgery on the option to purchase and lease agreement, and Ms. Vincent's communications with RE/MAX regarding the lack of continued leasing of the subject properties, and Ms. Vincent's use of RE/MAX forms that she had redacted and manipulated in a way such that they did not appear to be RE/MAX forms any longer.
Second.
All right, Mr. McMullen's offered a conclusion of law, seconded by Ms. Franks. Is there discussion on that motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that with respect to count 4 of the notice of hearing and charges, we find the following conclusion of law. Yes.
Go ahead, sir.
Okay. Mr. Chairman, I move that we make the following conclusion of law with respect to count 4 of the notice of hearing and charges. The state has not established that the respondent's acts and conduct constitute a violation of Tennessee Code Annotated 62-13-4037A, which deals with self-dealing when providing real estate services without the written consent of another party to the transaction. The transactions that the state alleges constitute a violation of this section were not transactions in which Ms. Vincent was providing real estate services to Mr. Stone.
And that one is number 4, and you're relying on which?
4037A.
I'll second that.
All right, have a motion, a proposed conclusion of law offered by Commissioner McMullen, seconded by Commissioner Bloom. Is there discussion on the motion? I hear none. Let's vote on the motion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Mr. McMullen.
Mr. Chairman, I move that we make the following conclusion of law with respect to count 5 of the notice of hearing and charges. The state has not established that the respondent's acts and conduct constitute a violation of Tennessee Code Annotated 62-13-405, which deals with the failure to obtain written disclosure when assisting an unrepresented party before providing real estate services. The transactions which the state alleges constitute violations of Tennessee Code Annotated 62-13-405 were not transactions in which Ms. Vincent was providing real estate services to Mr. Stone.
Is there a second? Motion by Commissioner McMullen, seconded by Commissioner Horn, that conclusion of law be adopted by this commission. Discussion. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Does that conclude your conclusions of law proportion?
I think so.
All right, ladies and gentlemen, now we're to the penalty phase, if the commission is so inclined, and the floor is open for discussion or for a motion.
Are we going to go count by count?
It's open for discussion, so if that's your preference,
Basically 2 counts.
we have 2 counts at this point. Your microphone forward, please.
Is it 6213, 313B,
62-13-312 B11
3B11? Okay.
and B20.
And B20. And then what's the second count, just so I'm sure I have it right?
Well, count 1 was B11.
Oh, and
And
the
count
other's
3
20.
was B20.
B20. I got it. I saw it down there. Thank you.
All right, so Ms. Franks, do you want to talk about each one of those sections first, one at a time? Or
Why don't we?
Okay. 6213, 312, 11, accepting the commission or any valuable consideration by an affiliate broker for the performance of acts specified in this chapter. So this commission has found that to be true. What's the penalty that you would like to propose? That's to the whole commission. Mr.
Mr. Chairman, I think, Ms. Franks, that you're only going to come up with one
Yeah. so
one
it needs to be
disciplinary
together, so
action.
I was just thinking.
I mean, you may have more than one sanction, but I mean, so I don't think it really makes sense to break
Agree.
it down per count. So I
Agree.
would recommend that you come up with a proposal for discipline that incorporates a sanction for both of the violations you found.
And, Your Honor, I'm still a little bit confused about, does she have an affiliate broker's license or a broker's license? So we'll know if we're downgrading what we're doing.
She has a broker's license according to what we just received.
You get Exhibit 13?
That's the firm.
That's a firm.
That's the firm.
Yeah.
That's the firm.
At this point, Ms. Franks, I think the commission just needs to make a decision as to on what your understanding of the proof has been.
And
Admittedly, it's been rather muddy on that point.
And as I questioned her, she did say that she had a broker's license, so I think we can understand that she did.
Commissioners, the state has asked for revocation of the license. The Respondents' Council has asked to not impose that death penalty. We need to get this thing started.
I'll start.
Okay.
There's a few points. I appreciate Ms. Van Zant's honesty. I think that that helps her a lot. I hate that as a broker that she decided to do this for a friend and she didn't get paid. I feel like Ms. Van Zant was also taken advantage of by Mr. and Ms. Stone by asking her to do that. They knew her well. They knew she was a single mother. So I feel like that they're culpable in some ways of suggesting it to her and making her so scared that she's done some criminal acts here. But as a broker and now a principal broker, if you're the principal broker, if she's the principal broker of this firm, she had to know that what she was doing was unlawful. I would like to see that her license be downgraded to affiliate broker, but I'd like for there to be some way that I mean, I don't even know if we can do this or not. I'd have to ask our attorney. Is there some way that we can keep her from ever getting a broker's license?
Revoke her license.
Revoke her broker's license.
No, just revoke her license. If that's your intent, never to have a broker's license, then you can revoke it. But if you downgrade her to an affiliate broker license, I think at some point she can go back and apply to be a
So you
broker.
can't put any caveats on that?
I don't, yeah, by law, Ms. Franks, I don't think that this commission could ever could prohibit Ms. Van Sant from ever reapplying for a broker's license. Now, this commission or a future commission would then would review that application, and I would assume would take her entire history into account. But I don't think that you can prohibit her from ever doing that in the future, from at least applying for it.
Mr. Chairman, I have a suggestion.
All right, Mr. Bloom.
Number one, I think she should be assessed a penalty of $1,000 on each count for a total of $2,000. She should be downgraded from a broker to affiliate broker, and that license suspended for some period of time. What the commission feels like is appropriate, 12 or 24.
So, Mr. Bloom, it would be helpful if you would put that in the form of a motion. Let's see how the commission reacts to it.
I'm going to say 12 months.
Okay, so I'm going to interpret your comments to be a motion.
Okay.
And your motion is that Ms. Van Zant's license be downgraded to an affiliate broker's license, that should be assessed a civil penalty of $1,000 for each of the two counts for a total of $2,000, and that her license be suspended
12 months.
for 12 months.
And number 3 should come into play. She should be assessed all the costs associated with bringing this action.
And the fourth bullet point in this motion is that all costs of the hearing and investigatory costs be assessed to Ms.
Right.
Van Zandt.
That's my motion.
I need a second to that motion to discuss it. Second. I have a second by Commissioner McMullen. It's a proper motion on the floor for discussion. Ms. Taylor.
Well, I think that I agree that she should be suspended, and I agree. I was actually going to go for revoking her license because she's done so many different things. She didn't realize that she didn't have the capacity to act on her own instead of always being an agent. She did fraud. She she put his signature in when she didn't have the okay to do that. There's so many things that she did, and they're not minor things. Every single thing she did was major. And it seems to me that she really doesn't realize what an agent is supposed to do. If we go ahead with this, I would add some classes on this, but I just think this is not enough to do for anybody that did so many things that was so egregious.
All right, Ms. Taylor, so you have every right to offer a substitute motion at this point.
Or you could say what classes.
That reflects your thoughts, or you can make an amendment to the motion on the floor if you'd like to add to it. Or you can say those were your thoughts on this, but you reserve any other comments at this time.
Let me think about this a second. If I take away her license, then it doesn't make any difference whether she takes the classes or not, because she won't take the classes, because it won't. I mean, why do that? $2,000, I guess, is the maximum we can do on those, so that's the maximum. So only if we downgrade her license will she take classes. I would suggest that on top of the $2,000, the downgrading of the license, the suspension for 24 months, that she'd have to take 12 hours of classes before she gets her license back. And they would have to do with contracts and what would other good ones be, since you're teachers? Ethics and let's see what else we could do. Those are each like 4 hours each, aren't they?
I'll second it so I can talk about it.
Well, let me just make sure I'm clear. Let me make sure I'm clear on one thing.
What
So,
about property management?
1 second.
Property management would be a super one, yes.
All right, was your initial motion for 24 months suspension or 12 months? For 12. Ms. Taylor mentioned 24 months. What was your intent there, Ms. Taylor?
I misspoke.
So
I think 12 months is fine.
Okay, so that's okay. What you're adding to Mr. Bloom's motion is a continuing education requirement, or education requirement of 12 hours in contracts, ethics, and was property management?
Mm-hmm.
Okay, so like 4 hours in each of those?
Right.
Okay.
And again, all costs involved with this
Right.
procedure.
Okay, Ms. Hill seconded that motion. Do you have comments at this point?
Yes.
Okay, please do.
I seconded it to talk about it. 12 hours just seems so little. My concern is that this person who had gotten their broker's license and who had had the education to get the license at the beginning and then got the education to have the broker's license can't manage themselves as a broker. And I think the education hours are just too little. I mean, I'd rather see 120 hours. I mean, it's like
That's fine.
redoing.
She's not completed her 120 either, she said.
So, regardless of that, you have the floor, and so if you'd like to offer something up, be my guest.
Well, if I did and she hadn't completed the 120, how does that count?
It doesn't matter if she's downgraded at this point.
I think the hours should be after today. Because if
Yes.
she's done extra hours trying to get the principal broker's license, those aren't going
That's
to, I don't
lost.
think those
They
count.
don't count.
Yeah,
It's
they should-
proven they
Yeah,
didn't
so
count.
I think whatever hours are
That's
imposed should
penalty
be
there,
after
too.
today.
All right, Ms. Hills, you still have the floor.
I still have the floor to see if I can offer a friendly amendment of 60 hours after today.
That's fine. I think that her acts have been so egregious and so.
I do too.
Okay,
Absolutely.
so the maker of the last amendment, Ms. Taylor, is in agreement with Ms. Hill's amendment or suggestion that it be 60 hours, not 12 hours of education.
Yeah, and my only problem with that is that I don't know if there's 60 hours in contracts in, is Ross still in here?
Well, I think those three have to be included, wouldn't you say?
Oh, yes.
Those three, at
Property
least.
management
yeah.
contract and,
Mr. Chairman, that's 60 in-class hours.
Yes.
yes.
Discussion on what's on the table at the moment. If you- Mr.
I'm
Horn.
just a little bit concerned. It went from 12 hours to 60 hours. What she did didn't have a whole lot to do with her education.
Oh, I think it had everything to do with her education.
You think she didn't know what she was doing?
I think she did it because was, as she said, scared. And I think she let it all go out the window. And I do believe that 60 hours is the adequate thing to do. The state's asking us to revoke her license. This allows her to keep her license, but it has a penalty to it too, so that, I don't think she's going to do this again, but I think she needs to take some classes. She's going to have a year that she's going to be off work anyhow from this. 60 hours, it's what's required for an affiliate license. I don't think it's too many, Mr. Horn.
Well, I think it's great that we came down from the revocation to something that she can live with. But to me, I don't feel that the schooling is going to do any good. I mean, if she did not know, oh my goodness, I did not know you could move a block, this type of thing. But she knows. And I think the best crutch that she had is when she said she'll never do that again. So we don't even have to take her at her word. Or we throw the book at her. Am I making sense? I don't.
And by the way, Mr. Horn, you have the floor, so if you'd like to make a suggestion of a different type of penalty or to modify this penalty, it's certainly your prerogative at this point.
But I would say that 60 hours is a lot. And, yeah, go ahead.
Jump from 60 in-class hours, that's what we jumped, 60 in-class hours. The 12 hours was like college hours, like you take a 3-hour course. We didn't really jump 48.
Okay, I'll go along with that. That's
Okay, other discussion. I'm going to repeat the motion as I believe it is on the floor. During this penalty phase, the motion on the floor that Commission will vote on is for the respondent's broker's license to be downgraded to an affiliate broker's license, that she be assessed a $2,000 civil penalty, $1,000 for each count, that she be suspended, any real estate license she may hold be suspended for 12 months, that she be required to take 60 in-class hours on topics specific to contract writing, ethics, and property management, and that all costs of this hearing be assessed to the respondent.
And that the
Yes, and back to those hours, those 60 hours would be classroom hours that are initiated following July 7th, 2016.
Not online.
Yeah, it's in class. That's the motion as I understand it. Does anyone want to modify that?
I want to make sure that the 60 hours weren't all property ethics and contracts, but they were to be included. That's the way I understood it. At least those 3 classes, but I don't know that you can get 60 hours in those. Okay.
Okay, 60 hours of in-class instruction.
Which shall include at least.
Including contract writing, ethics, and property management. Is everyone clear on the motion? Is there more discussion on that motion? All right, then, I sense you're ready to vote. Do you need a roll call on this by any chance, or is voice? Okay. All right, if you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Mr. McMullen, we have a public statement, or one final piece of the puzzle we have to. You did work on that, didn't you?
No.
A policy reason for the decision. And anyone else can offer that same policy statement.
I'll come up with something off the top of my head.
Okay, good.
Mr. Chairman, I move that we adopt the following policy statement. This order is based on the information presented during the hearing before this board. This board determines that the action taken to suspend and penalize Ms. Van Sant is necessary based on her violations of statute. The violations were significant and support the penalties imposed. However, Ms. Van Sant's contrition and honesty during the hearing were also recognized and justified a more moderate penalty than might have otherwise been imposed.
Is there a second to that?
Second.
Unanimous second. All right, let's vote on that statement. If you're in favor, vote aye.
Aye.
If you're opposed, vote no. All right, we're going to consider this particular phase completed, and now we will move to Ms. Cudd. Mr. McMullen, do you have a proposed series of findings of facts?
Sure. Your Honor, can we adopt all of the same findings of fact that we made in the previous matter?
Yes, I mean, if you think that's applicable to the CUD matter, yes, absolutely, yes.
Mr. Chairman, I move that we adopt the findings of fact previously made from the Vincent matter.
Seconded by Commissioner Hills. Is there discussion on that motion?
Let me.
Mr. Horn.
And then I could see where you might include resulting into these things that Ms. Hill was, had the finger pointed at. Well, she didn't do all of those things.
I think it's strictly a matter of findings of
Just
fact, but
what the facts are of the case.
well,
Not the penalties and
Not the penalties.
conclusions.
I understand that, you know, but I give up.
oh, don't give up.
Was one of those findings of fact that both Ms. Vincent and Mr. Stone both said that she was not guilty of anything?
No, but I think that after we adopt the findings of fact from the other case, we could make additional findings of fact that apply to the CUD case. But
All
I
right.
think that those findings of fact from the Vincent case would kind of provide all of the factual background without us having to rehash all that.
All right, the motion on the floor that was made by Commissioner McMullen, I believe seconded by Ms. Franks,
Yes.
was to adopt the same set of findings of fact as we did in the Vincent case. Is there discussion on that motion? Now, remember, commissioners will have a perfect chance to add additional findings of fact. All right, I hear no objection, no discussion. All those in favor of Mr. McMullen's motion say aye.
Aye.
Those opposed?
Abstain.
Those opposed, no. No noes, and one abstention. Let the record reflect 6 ayes, no noes, 1 abstention. All right, Ms. Franks, did you want to propose a finding of fact?
I would like to make the finding of fact that both Ms. Van Zant and Mr. Stone said that Ms. Cudd had no knowledge or participation in the wrongdoings of Ms. Van Zant.
All right, you've heard the motion offered by Ms. Franks. Is there a second to that?
Second.
Seconded by Ms. Hills. Discussion on the motion. All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Commissioners, other findings of fact, and I'll give you a little time to think about that.
Mr. Chairman, I move that we make the following finding of fact. As the principal broker for RE/MAX First, Ms. Cudd saw Ms. Van Sant in the office approximately 5 days a week and would meet with her to have lunch approximately every month to supervise her work.
Every other month.
Every other month, that's right.
Second.
Okay, you've heard that proposed finding of fact. Discussion on that. All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Finding of fact that she herself had no knowledge, that she has acknowledged that, we've acknowledged that. I'm talking to them.
Oh, yes,
Yeah,
yes.
that's what she does.
Yeah,
I'm talking to them.
don't forget that.
I was trying to decide if we needed a finding of fact that she herself acknowledged that she knew nothing about this until after till informed by the Tennessee Real Estate Commission.
Second.
All right, thank you.
We have a motion by Ms. Taylor, seconded by Ms. Franks, that you've just heard read loudly into the record. Is there discussion on that motion? All right, let's vote on that motion. If you're in favor of it, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Other findings of fact. Mr. McMullen, are you through?
I'm through.
All right. Everyone else had a chance. Any other findings of fact before we go to the next phase, which is conclusions of law, Mr. McMullen?
Mr. Chairman, I move that we adopt the following conclusion of law with respect to count 1 of the notice of hearing and charges. The state has not established that the respondent's acts and conduct constitute a violation of Tennessee Code Annotated 6213-312B15, which requires a principal broker to exercise adequate supervision over the activities of its licensed affiliate brokers. The wrongful conduct of Ms. Van Sant would have been extremely difficult for any principal broker to reasonably detect. On that basis, we cannot find that Ms. Cudd's supervision of Ms. Van Sant was inadequate.
Second.
Okay, we have a motion related to conclusion of law offered by Commissioner McMullen, seconded by Ms. Franks. The intent of the motion is to say the state did not prove their case, and the motion states that the commission finds no violation. That's what's on the floor in front of you. Is there discussion?
I'd just like to say something.
That's what the discussion is for.
Okay.
You go right ahead.
I think that Ms. Cudd represented herself well, especially without an attorney. I think I'm the only principal broker up here,
That's
but
not
most
true.
of us.
That's
Who
not
is?
true.
Diane?
Oh, you're a principal broker.
Get your hands.
Okay.
And you?
We're both principal brokers.
Oh, me too.
We understand what's happened to you. We are not God. We cannot know everything. It's a huge responsibility that's placed on principal brokers. And there are many cases that the principal broker is wrong and have not supervised. You have done everything that you could have done, that you should have done, and I apologize that you even had to be here today.
All right. Any other discussion? Mr. Horn?
Yes, I would like to just say that I think she did a splendid job of representing herself, but also it seems that she's doing a magnificent job with her staff and her training. She was up on all of the, I would say, real estate jargon that y'all asked her. But however, I spent 20 years in the military. We lost an atomic bomb one time with somebody. A silly mistake. And brother, it cost me 15 pounds of paperwork. But what I'm saying, it can't be everywhere,
No.
all the time. And I just wish she'd had some help in her office. Would have said, ma'am, you better check this situation out because I think it might be getting out of hand. Thank you so much for your work.
Other comments? Are you ready to vote?
Yes, sir.
You've heard the motion. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Mr. I guess, do we need to consider a penalty phase if we found
No, you found
we're
there's been
finished?
no violation. You need a policy statement, and then that's the end of it.
Chairman, I move that we adopt the following policy statement with respect to the CUD matter. Tennessee law provides that principal brokers are to provide adequate supervision of their affiliate brokers. This is a very important requirement and helps to protect the public. And while principal brokers are to provide adequate supervision, this does not mean that they are strictly liable for all conduct of their affiliate brokers. Maintaining the distinction between those two is important to help in the system of protecting the public.
All right, is there a second to that?
Second.
That policy statement, which was eloquently stated, Mr. McMullen, and appropriately seconded by Commissioner Bloom. Is there discussion on the statement? Let's vote. Those in favor of that, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
All right, nothing further, and we'll stand adjourned in this hearing.
This hearing is
And
adjourned.
this hearing is concluded.
Commission, we have one more item to
Yes,
handle.
one more thing.
We have one more to go. Ms. Kirby, thank you, Judge, thank you.
Really, really quick.
And congratulations and good luck.
But once again, you guys in the audience can go, let me ask one question. This young man here, what are you doing here?
He's thinking about getting his broker's license.
Come up here to the microphone for a minute.
It came with his mama.
Come up here.
Oh, he's embarrassed. It's okay. It's okay.
Is that right? That's wrong now.
Well, have your mom come up here and tell us what you're doing here.
Tight ship, we enjoyed it.
What are they? What are they now?
Didn't enjoy it.
Just right there. Stand right there and talk into that microphone.
Hello.
What are you and your son doing here? I don't care about you. What's your son
I
doing?
left at lunchtime to go to Vanderbilt. He had a doctor's appointment. He was struck with a very rare illness in the leukemia family, HSP, a little bit over a year ago, and we went there for his checkup. And today we got wonderful news that he gets to come off of azathioprine, which is a oral chemo that he has taken for the last year, and a lot of other medicine, so it's good news. So I asked earlier if I could come back and bring him, so he's here. And this is Brent.
Great, great, Brent.
Good job, Brent.
Thank you.
He probably never wants to be a principal broker.
All right, Ms. Kirby.
Oh, what's this?
Okay.
There we go.
The following matter, this is a complaint that was opened, and it's kind of an urgent matter. We just received a response for it yesterday, so I wanted to go ahead and present it to the commission. Complaint number is 2016026651. There are two issues regarding this respondent's license. The first is that respondent enrolled online for E&O insurance coverage with Rice Insurance on April 15th, 2016, which was charged back by the bank, but was then settled successfully and downloaded into Rice's system on April 18th, 2016. Rice states that a call was received from a holder of the card used for this transaction on April 27th, 2016, stating that the transaction was not authorized. On May 5th, Rice received a chargeback notification from the bank. Respondent enrolled again online on May 26th and coverage cleared. Respondent currently has a valid E&O policy should respondent's license be made active. The second issue is that respondent answered no on respondent's application to the question, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by federal, state, or local government? However, respondent has had an insurance producer's license revoked in Tennessee, Connecticut, California, and South Carolina. According to the order from the hearing before the administrative law judge in Tennessee issued in April of 2015, an individual who was a licensed insurance producer responded to respondent's Craigslist advertisement, which was seeking to employ insurance producers. Respondent met with this individual to discuss the job. Respondent used a different name and supplied the individual with an application which the individual filled out with personally identifiable information. The individual did not accept respondent's offer to be a part of respondent's alleged insurance agency. Respondent, without this individual's knowledge or consent, used the individual's identity to establish an insurance appointment with an insurance company and wrongfully procure insurance sales and deposit fraudulent commissions totaling approximately $3,308.58. Then respondent renewed the individual's insurance license without consent and changed his contact information using his personally identifiable information. Respondent then submitted the individual's insurance application to an insurance carrier, to which respondent also furnished a fraudulent certificate of liability insurance. The previous events took place between October of 2011 and July of 2013. In addition, respondent worked as an insurance agent for an insurance company in Florida on January 21st, 2014, and negotiated a policy on behalf of an Oregon resident. On or about January 29th, 2014, respondent discontinued respondent's contract with the agency. However, respondent continued to portray respondent's self as still working for the company and told the Oregon resident that there were changes needed to this policy. Thinking respondent was still working with the insurance company, the individual provided respondent with personally identifiable information about his bank account. On about March 3rd, the individual experienced an unauthorized attempt to issue pre-authorized debits from his bank account, which requested money be withdrawn in the form of payments to a marketing group in Florida. The order also states that on December 13th, 2011, respondent was arrested for battery but answered no on the license renewal application submitted on May 1st, 2012, which asks, have you ever been convicted of a crime, had a judgment withheld or deferred, or are you currently charged with committing a crime which has not been previously reported to the state? The ALJ found respondent engaged in a total of 13 violations of Tennessee insurance law based upon all of these facts and issued a civil penalty of $100,000 in license revocation. The order also included the fact that respondent's Connecticut insurance license was revoked by default decision for violating 11 statutes, and respondent's California insurance license was revoked for violation of 2 statutes. Further, it appears that respondent's South Carolina insurance license was revoked for failing to report respondent's revocation in other states as required by South Carolina statute. The Tennessee order was issued as a default as respondent failed to appear at the hearing after being properly served. Respondent submitted a response stating respondent wants to fix things. Respondent states respondent is not a bad person, is very active in the Christian community. Respondent states respondent is a very honest and driven individual with strong passion to help others, and real estate allows respondent to help. Respondent wants to do whatever it takes to prove respondent is a good, honest person and would like the opportunity to do so. The recommendation is a consent order for voluntary surrender or revocation of respondent's license, plus notifying the respondent of a summary suspension hearing to be held at the August 2016 meeting should the respondent not accept the consent order. The summary suspension hearing would allow the commission to suspend respondent's license until a formal hearing could be scheduled should the commission find that there is sufficient evidence to do so.
Mr. McMullen.
Mallory, do we have the ability to do anything to this license before the summary suspension hearing in August? Like just on the basis of the falsities and the potential risk to the public and to others?
So there's 2 types of summary suspension hearings. One is that we would notify them of the hearing, have it at the next meeting. You can also do, like if you wanted to do, you could do a summary suspension right now, but then we'd have to have the actual full hearing within 7 days. I don't recommend that just because I still need to get the actual file from this insurance hearing and have all that evidence or then give it to the litigator would be presenting it. But all I have at this point is just the order from the revocation hearing. I don't have the file or any of the investigatory documents yet, so I think it would be best to wait and do that once we have all that information.
This is the best
At the next meeting.
best we can do right now. Well, then I make the motion that we
Accept
go along with the
council's.
recommendation.
Second.
All right, motion by Commissioner Taylor, seconded by Commissioner Franks, that council's recommendation be adopted.
Yeah, well, but didn't we just revoke his license?
So I'm going to offer, if you vote to accept the recommendation, I'll offer a consent order for voluntary revocation of the license. But if they don't accept that, then we'll want to do the summary suspension hearing.
Best we can do today.
Other questions? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. So, for two commissioners on your way out of here, just remember, some days you get out of here at 11 o'clock on the second day. Some days you get out at 6 o'clock. It's,
What day have we got out at 11 o'clock?
well, someday I said we will.
Well, and I know I've done a lot of talking, but I'd like to have a closing remark
You go
on the record.
Go right ahead.
Thank you. Enjoyed you.
Thank you, sir. Thank you, ma'am.
Thank you very much.
Will you send, will you,
Thank you, thank you, thank
are
you.
you gonna send me an order?
Yes,
Can-
I'll have to.
Documents you sent, so
I
I'd
know.
like to get that right.
Are we
I know-
still on the record?
Yeah, we're
Okay,
on the record.
I'm asking her back there.
I get,
Okay, I would just like to say this. I'm very sorry that, Commissioner DeChara could not be here yesterday and today. And I want to recognize her for all that she's done for this commission, for all that she's done for the state of Tennessee, and all that she will continue to do. And just tell her that we appreciate her and love her, whether she's here with us or not.
Here, here.
Yes. Excellent remarks.
Thank you.
All right, we're adjourned.
We'll talk about the Bill Toon Ward next month for her.
Okay. So you're gonna go to the office, go to work?